very good morning to all of you. My name is Ashish Bhardwaj. I'm the Dean of Jindal School of Banking and Finance at OP Jindal Global University. I'm very happy to open the inaugural session of the two-day National Virtual Conference on Economic Dimensions in Judicial Decisions, which is jointly hosted by OP Jindal Global University and Cuts International. At the outset, let me say that this is an incredibly difficult time for everyone. Our hearts go out to all those who have lost people in the pandemic, and we hope for a speedy recovery for those who are currently battling the crisis. Given the current circumstances, we are streaming this conference live on our official YouTube page of JGU. So if you're trying to find us, please look for the JGU YouTube page. And we are doing this so that several people can access the vibrant discussions that we'll host today and tomorrow. I extend a very warm welcome to all the distinguished speakers of this session on the theme Economics in Judicial Decisions or Judicialization of the Economy. It's a thought-provoking question. Professor Rajkumar, Founding Vice Chancellor of JGU, Mr. Pradeep Mehta, who's going to join us in a minute, who's Secretary General of Cuts International, Professor R. Sudarshan, Dean of Jindal School of Government and Public Policy, Dr. Francis Julian, and Senior Advocate Supreme Court, and Professor Srijit, who's Executive Dean of Jindal Global Law School. Each one of them is, of course, a giant in the field, be it legal scholarship, research in economics, policy planning, law practice, higher education, and consumer activism. I'm thankful to all other speakers of the conference who've accepted the invitation, all the participants, all the viewers who have joined us virtually. It's a pleasure to host each one of you today. Economic dimensions in judicial decisions, which is the theme of this, central theme of this conference, are really vital in many different ways. Most public institutions in India perform complex tasks at the intersection of public interest, political pressures, and an incredibly diverse socioeconomic expectations of the people. The judiciary in India, which has played a monumental role in the evolution of our society, economy, not only continuously negotiates these tough undercurrents, but it's also responsible for demonstrating an ideal conduct for all institutions to follow. With this background, an important question that India has to grapple with is whether wrongdoings really preclude an economic analysis of law. On the bright side, our understanding of the linkages between judicial reasoning and decisions with economic governance and growth is much deeper now than what it was 3 decades ago when the Indian economy opened up. The question for the distinguished panelists for this inaugural session is whether we are looking at economics in judicial decisions or rather a possible judicialization of our economy. To deliver the welcome address, I invite the Founding Vice Chancellor of OP Jindal Global University, who is also the Founding Dean of Jindal Global Law School, Professor C. Rajkumar. Professor Raj, over to you.
Thank you very much, Ashish. Very good morning to all of you, and thank you for being here with us today. Well, as the tragedy of the global pandemic crisis and its extraordinary impact on India is being witnessed by all of us, I can only hope that those of us who are battling with it, those of whom who have lost their families can, take the willpower and the ability to overcome this extraordinary challenge that all of us are facing. I sincerely hope that you and your families are safe during these very difficult times. In fact, some of my friends and colleagues had asked me in the last week when India was already facing this crisis, that whether we should even have this conference at this time. And my response to that question was that universities have a larger responsibility to think about the future. A conference of this kind and magnitude is important at any point of time. But even during this time, it is absolutely important because it is about the future of institutions. And one of the institutions that we'll be talking a lot today and tomorrow is the institution which is involved in the very idea of what has been talked about as the theme of the conference, which is economic dimensions in judicial decisions, or the theme of the inaugural session itself, whether it is contributing to the judicialization of the economy itself. I would like to welcome all of you to this National Virtual Conference on Economic Dimensions in Judicial Decisions, co-organized by OP Jindal Global University and Cuts International. My special and warm welcome to Mr. Pradeep Mehta, the founding Secretary General of Cuts International, Dr. Francis Julian, Senior Advocate, Supreme Court of India, Professor Sudarshan, Dean, Jindal School of Government and Public Policy, and Professor Ashish Bharadwaj, Dean, Jindal School of Banking and Finance. Also my own colleague, Professor Srijit, Executive Dean of Jindal Global Law School. Today, there is a lot of emphasis on collaboration between economists and lawyers to cross-apply theories, particularly application of empirical and quantitative methodologies, more commonly known to be used in the area of economics to make legal systems more efficient and more effective. Over time, this role of economics has become stronger, particularly in relation to the calculation of damages, for example, in tort, contract, and securities, and a wide range of other type of cases. But regardless of that particular evolution, there are serious issues that have been raised with regard to the role of the judiciary itself when it comes to its ability to contribute towards policy making. There are serious forms of principles that have been discussed when it comes to what is at stake and how do we enable institutions of government to exercise their powers in an effective manner, respecting the separation of powers doctrine. I believe there are possibly three principles that one could think about. First, law and policy and judicial intervention. The separation of powers doctrine is about the legislature having the prerogative of making laws, the executive being entrusted with the responsibility to implement laws, and the judiciary vested with legal and constitutional powers to adjudicate disputes and review both legislation and the executive actions for their compliance with the Constitution. The judiciary, of course, needs to evolve a robust set of principles on the basis of which it will, on its own, differentiate its interventions on matters which are not related to law and are actually policy questions. While this is somewhat easier said than done, the question is, what are the kind of mechanisms that the judiciary need to invoke? Elected governments are best suited to make policy choices. They are better placed to determine the suitability of particular policy choices. But the judiciary must intervene if any or all of these powers are arbitrarily exercised. It is not at times all that difficult to tell a priori what is law and what is policy. The real difficulty arises when enforcement of law and implementation of policy results in a clear violation of fundamental rights enshrined in the Constitution, arguably at a time when we are facing the global pandemic itself. Second, constitutional norms and institutional limitations. The judiciary is vested with the obligation to ensure that all the wings of the government follow constitutional norms. Our courts have intervened in many matters that appear at first blush to be substantive questions of public policy as opposed to law. In such matters, the judiciary interprets issues from the standpoint of upholding rights and values of justice. The judiciary must recognize that there are inherent limitations to the exercise of judicial powers when it comes to its policy questions. We are familiar that in the landmark case S.R. Bommai versus Union of India, the Supreme Court in relation to exercise of the emergency powers under Article 356 observed, and I quote, "The opinion which the president would form on the basis of the governor's report or otherwise would be based on his political judgment. The temptation to dwell into president's satisfaction may be great, but the courts would be well advised to resist the temptation for want of judicially manageable standards," unquote. The third aspect is judicial restraint and executive accountability. The judiciary must show much more restraint when it is asked to decide upon questions of policy. Determining correctly what properly constitutes a question of policy calls for competencies that the judiciary may not possess. There are several instances where the Supreme Court may have crossed that delicate line, what Arun Jaitley several years ago had called the Lakshman Rekha. In 2012, the court ordering interlinking of rivers, and this was criticized as a disquieting judgment because it encroached into the executive domain. Even if it is argued that a citizen's right to water is a fundamental right that gives the Supreme Court some rationale to exercise executive actions to order the interlinking of rivers in the face of clear executive unwillingness to do so, which was supported by executive evidence, expert evidence, it is It's a clear example of the court overstepping its boundaries and getting into the domain of policy making. However, there have been other judgments, including a 2013 order directing the creation of an independent civil servants board within 3 months. This was positively received as it undid the injustice done to a civil servant while seeking executive accountability. So the big questions that we need to address is, why must the judiciary exercise self-restraint in policy matters without violating rights? Why must the judiciary bring in economic analysis in relation to adjudication? Possibly it lacks wherewithal and competencies to grasp all ramifications of economic and policy choices. A decision of the Supreme Court is the law of the land. When courts decide what policy should be legally mandated, it will need revision judgments to change those policies in the public interest. Hence, judicial calibration of policies is unfortunately need to be re-examined in its current status. So, in the current times of the pandemic, it's absolutely critical for us to discuss these issues. In this context, we welcome you to the 2-day virtual national conference where we will witness over 45 thought leaders, including judges, legal practitioners, experts from the government and regulatory bodies, representatives from the private sector, academicians and scholars, representatives of media and the civil society, including consumer protection groups, environmental advocacy groups, and trade unions. They will come together in 8 thematic sessions and 2 plenary sessions, including 4 keynote addresses, a book discussion, and a special judges colloquium to deliberate on relevant topics such as economic analysis of public infrastructure, trade, and constitutional law, law and economics approach to corporate laws and corporate debt restructuring in India, law and economics approach to competition policy, digital economy and new technologies, and economic analysis of industrial innovation and intellectual property law, economic analysis in public health and environment domains, teaching economics to law students and law to economics students in India. My special gratitude to Mr. Pradeep Mehta, who has taken the time out to share some deeper insights from his upcoming book, Supreme Court and the Indian Economy, in a special book discussion during this conference. I truly imagine that during these 2 days, we will collectively build thought processes that will enable a stronger judiciary in India. Therefore, without further ado, allow me to now call upon Mr. Mehta to share his views as we now officially commence this conference. Mr. Pradeep Mehta.
Good morning, Raj. Good morning, all the distinguished faculty of Jindal and all the distinguished participants in this conference. It gives me great pleasure in welcoming you all to this unique and much needed conference, which intends to tackle the contours of law and economics, as was vividly explained by Raj in his opening remarks. The debate, which at its very core addresses the complex issue of balancing lives and livelihoods. It has become nuanced over the past 1 year particularly. As we have entered the second and more severe phase of the COVID-19 pandemic, there are newer and greater realizations for the need of better governance frameworks, policy instruments, better management of supply and distribution chains, for the need of a more balanced, resilient, and equitable world. It is at the intersection of law and economics that these concerns find their roots. Although law and economics has often been promoted as a tool to be used by policymakers, there has been a growing discourse, although not a new one, that judges should be guided by economic principles when adjudicating matters. One prominent landmark judgment where such intersection was given due importance in India was in the Shiv Shakti sugar mills case, where the Supreme Court took a liberal approach to statutory interpretation. The apex court rightly opined that economic analysis of the law is a valid jurisprudential approach to interpretation. The exemplar bench of Justices A.K. Sikri, who's going to join us in this conference, hopefully, and Justice A.M. Sapre said, and I quote, the court needs to avoid that particular outcome which has a potential to create an adverse effect on employment, growth of infrastructure or economy, or the revenue of the state. This is not to say that economy, development, or growth trumps other disciplines, as was also asserted by Raj. Other disciplines such as environment, human rights, constitutional law, and others. Rather, the need is to strike a fine balance which can ensure that measures to protect or sustain the environment or uphold human rights should not cause an unreasonable adverse impact on the economy. The reverse of that has been fought and argued for a long time now, and rightly so. However, what we must realize is that the need to fight and stand up against environmental degradation and anti-human rights measures arose because of the skewed focus towards the economy. This is the other side of the coin. Turning the table and only focusing on the environment and other domains while ignoring the economy will not bear fruitful results either. We must not repeat our mistakes of looking at anything in silos, but realize that the whole of government's approach and the systems thinking needs to be applied and implemented in our day-to-day functioning. That is the way to a sustainable future. One of the better examples of law and economics is the domain of competition law, which is also referred to by, in passing by Raj. Unlike the common law, where the law is explained in economic terms, competition law derives itself from economics. In competition law, it is the rule of reason, which is more important than the rule of law. However, over the years, the need has been felt to extend such analysis to other domains of law, including trade, constitutional law, intellectual property, and corporate law, among various others. We are going to hear more about this in the validity session from Dr. Frederick Jenny, who has, as an economist, has served on the French Supreme Court and decided some wonderful cases, which is brother judges still sort of applaud. But in that context, courts and judges must familiarize themselves with economic analysis of law to ensure mitigating judgments which result in avoidable economic harm and absence of, let me underscore the word, comprehensive justice to the affected people. And which goes beyond just the parties to the case. It has thus become imperative to look at the costs and benefits of judicial orders with a simple purpose. Did the orders meet their objectives or not? How did they impact different stakeholders? And is it possible to design an efficient alternative mechanism or remedy to help the judiciary consider varied stakeholder perspectives before giving an order? Here, let me speak to you about a case that we analyzed for Niti Aayog. And we found that the outcome was absolutely zero. This was the ban on sale of liquor from 500 meters from the highways, which was done in a manner that defied any reasoning whatsoever. Not that drunken driving is the only case that they were trying to stop or would have happened, but in the ultimate analysis, there was a huge loss to the economy, running into tens of thousands of crores without the gain of a single life, particularly. I mean, death still continued, whether it was drunken driver or any other cases. That itself is a major issue in our road accident scenario costs nearly 3% of our GDP. In any event, we must also understand that we must not question the validity of a court's order. That respect has to be there inherently. However, let us not forget the fact that the judiciary is funded by public money, and thus public should have an opportunity to review the quality of orders. Of course, one may argue that examining the economic impacts of orders or conducting an economic analysis law is beyond the judiciary's remit. However, it must be noted that every order of the judiciary is likely to have an economic impact, big or small. Thus, an attempt to narrow the scope of judicial analysis to only environment or equity considerations is not only futile but counterproductive. One way for courts to undertake such economic analysis could be to appoint expert committees or experts to examine the issue in depth, analyze its enforceability, and then action, as it has done on several occasions. I mean, we're not suggesting something which is new. The judiciary is increasingly dealing with extremely complex issues, interlinking economics, environment, technology, intellectual property, competition, privacy, trade, and allied fields. An inability or unwillingness to take into account economic considerations is putting a significant number of jobs at risk and a substantial amount of existing and potential investment in peril. This impacts the whole economy, with the poor facing the worst burden. I mean, you look at the situation now, it is always the poor which face the biggest burden in the event of any kind of downturn which happens in the economy. If you look at the pandemic situation today, it's the poor who are suffering much more than you and I. In fact, there are several instances wherein the courts have been able to achieve such fine balance, such as the Supreme Court's intervention that led to the adoption of CNG and consequent economic benefits when it directed that overhead power transmission lines in Rajasthan and Gujarat to be laid underground to shore up the plummeting numbers of the great Indian bustard, a bird which is becoming extinct. The pressing question that needs to be answered is, how can this be done more often? While training judges on basic economic principles can be a medium-term strategy, a more immediate and practical strategy could be institutionalizing the mechanism of expert committees, which can aid judges in considering diverse perspectives and collecting desired evidence. This conference is a shared vision between JGU, a leading academic institution, and Cuts, they're a leading global public policy research and advocacy group, wherein we are hopeful that the discussions will draw greater attention to the need for imbibing and regularizing such analysis by courts. Of course, there are limitations that must be addressed and proper frameworks implemented to ensure that adapting such analysis does not slow or skew our justice delivery system. As we all know, I mean, there are parties who know how to game the system. So this could be something which has to be kept in mind. Much before the pandemic, we at Cuts International have been trying to unearth the facets of law and economics by studying and analyzing various judicial decisions by the Supreme Court and the National Green Tribunal. The objective and the intent have been to push for a balance between environment and economy, lives and livelihoods. This is the same balance that various critics have been demanding during the peak of the spread of COVID-19. I mean, we're not asking for anything new. We're all seeking goodwill. This conference is one such endeavor, and I'm pleased to inform that our efforts in this discourse will not end here. Exactly after a year, we are all once again experiencing unprecedented worries and failures in our governance structures. I hope the discourse in this conference gives us a chance to take back something which is more relevant and applicable now than ever. With that, let me also welcome you all once again and to thank Raj and all the others for having helped us to organize this wonderful event, which is going to be, in my opinion, a milestone event. Thank you, Raj.
Thank you very much, Mr. Mehta, for that fascinating introduction to the theme of the conference and some of the most critical issues that the conference is going to be discussing in the next couple of days. It is now my great pleasure to welcome and introduce my colleague, Professor R. Sudarshan, the Dean of Jindal School of Government and Public Policy. Professor Sudarshan has led a distinguished career in the domains of research, development programming, and governance. After he obtained a master's degree in economics from the University of Delhi, the Delhi School of Economics, he was elected to a Rhodes Scholarship. He joined Balliol College at the University of Oxford and obtained a master's degree in politics in 1977. He was then elected to a research fellowship at St. John's College, University of Cambridge, where he studied judicial review of economic legislation by the Supreme Court of India, specializing in the interface of law and economics. In many ways, long before many parts of the world had developed such a research interest. In 1983, he was a visiting scholar in the School of International Development at the University of East Anglia. In 1984, he served in the Ford Foundation's South Asia office in New Delhi as Assistant Resident Representative and Program Officer for Human Rights and Social Justice. In 1991, he joined the United Nations Development Program in India as Senior Economist and Assistant Representative for Governance and Public Policy. In 2000, he served UNDP in Jakarta as its Senior Governance Advisor. In 2002, he was appointed as Policy Advisor for Justice and Governance at the United Nations Development Programme's Oslo Governance Center. In 2005, he was further transferred to the UNDP Asia Pacific Center in Bangkok, where he was Regional Policy Advisor for Governance, Human Rights, Rule of Law, Justice, and Legal Reforms. In 2012, when we were establishing the Jindal School of Government and Public Policy, he took up the position of the founding dean of the Public Policy School. He has an impressive track record of publications comprising books, articles, UN policy reports, reflecting his interdisciplinary research, teaching, and policy experience in development programs, human development, law, governance, institutions, and policy. With those words, I'm going to request Professor Sudarshan to deliver his keynote address.
Thank you very much, Vice Chancellor, for that rather long introduction. Which establishes that I'm senior, at least in age. I'm very honored to be asked to speak and deliver a keynote to this very interesting and important conference. I started taking an interest in the judiciary and its understanding of economic issues when I joined St. John's College in Cambridge. And that's because at some point, one of the key figures in a whole field called law and economics was at one point a fellow at St. John's College that was Ronald Coase, and who then moved from the UK to Chicago. And Ronald Coase wrote a very important article on the nature of the firm, but that's became the centerpiece for this new field, which in academics called law and economics. What Ronald Coase was doing there was asking a very commonsensical question, which is who is external to whom? So if you have a road, all of us assume that it's meant for motorists and pedestrians who jaywalk and cross the road arbitrarily are a nuisance. On the other hand, if you think the road is meant for the pedestrian, the motor car is the nuisance because it comes hurtling down and causing a danger to the life of the pedestrians. So the question really is, how do you then allocate rights? And one of the important discoveries, which is known as the Coase theorem in economics, is, and it's mathematically proven, that's why it's called the theorem, is that if there was no transaction costs at all, if transaction costs were zero, transaction costs are those costs that you need to get something off the ground. Anything to do with procedure, clearances, whatever, settling of disputes, all of that. If there was zero transaction cost, then the activity that is economically more rewarding will win out. That's what the theorem says. Now, one implication that people drew from this theorem, and that was done mainly by American scholars. Richard Posner was a professor at Chicago, who later became a judge in the circuit court, the Federal Circuit Court. Guido Calabresi in Princeton. They drew on this insight from Coase, which is the problem that causes inefficiencies is transaction costs. And so it's important to minimize transaction costs in order to have more efficient outcomes, meaning outcomes that cost less on the whole to the economy. And that means you must assign rights in such a way that you reduce transaction costs. So, for instance, when the American railways opened up the country from the East Coast to the West Coast across the prairies, where wheat was grown, the steam locomotives threw out cinders, and they caused damage to the wheat crop on either side of the permanent way, the railroad. So what the railway company owned was the land and the railway tracks. He didn't own the land on either side of the railway tracks. And when these cinders, these embers of coal, burning coal, flew out in the air and damaged the wheat crop, obviously the railroad company has caused damage and it must compensate for this damage. That would be the legal position anyway. The problem is that there are hundreds of farmers along the way, and if the railroad company had to negotiate with each one of them as to how much compensation they should give, then obviously it's an inefficient outcome, because there would be a court case with respect to every one of the farmers, and that would be inordinately wasteful. So the logical reasoning there would be assign the right of permanent way to the railroad, but do something else to compensate the farmers, so that you don't have to have, the railroad company doesn't have to get into a dispute with each one of them. Now that's a kind of commonsensical solution to what's seen as, because it's possible for the railroad, being the more profitable enterprise, to actually compensate the farmers for their loss, or compensate them not to grow wheat for some distance away from the railway track, even if the land belongs to them. So this is the kind of basic insight that is the foundation of this discipline called law and economics. But it's based on a very neoclassical assumption of economics as well. It's based on the assumption that every individual is setting out to rationally maximize their utility or get the preference of their choice in any choice set. And this field has influenced a number of judicial decisions in the United States. So much so that, Richard Posner did a study of the common law, and he showed that the common law, as it evolved from case to case, had evolved in exactly the way that an economic logic might have warranted. And therefore it should continue to do so, or the legal system ought to establish that it does so. So the question that arises is, it's all right because the principal value here is efficiency. But what about equity? What about fairness? And this is a concern. And the critics of the academic economic analysis of law point to this fact, that the legal system, its role is to do justice. And that entails attention to issues of equity and fairness, and not simply economic efficiency. That shouldn't be the predominant consideration. There was a wonderful piece of historical research in the United States by Morton Horowitz called The Transformation of American Law from 1760 to 1860, 100 years of US history, where what he shows is that the judicial system in the United States enabled the flourishing of capitalism, and that they changed many common law principles in order to enable that economic activity to be facilitated. For instance, if in the earlier versions of English common law, if you caused damage to somebody downstream, because whatever you did upstream, you would have to compensate that person for that damage. But in the United States, the courts began to make decisions where they said this activity, such as establishing a sawmill upstream, contributes to economic growth. It creates jobs. It helps wealth maximization, and therefore it shouldn't be hindered by the protests of somebody downstream. Now, in a way, that was a change in an equity principle in common law to this new idea that you should let the economically dominant activity prevail. So this has been the background to economic analysis of law. And I don't think that we are particularly concerned in that sense of applying the theoretical framework where economic analysis of law ought to come in and inform how our judiciary makes decisions. I don't think that's quite what we are at. I don't think that's the thrust of Cuts and Pradeep Mehta's work in analyzing judgments. That's not what it is. What it is that you have to be mindful of the consequences of your decision, the economic consequences of decisions that courts make. They all have economic consequences, and it's important to be mindful as to what they are. We are not advocating here an ideological buy-in to the Coase-inspired Richard Posner, Guido Calabresi, and so on contributed field of economic analysis of law. You get some very peculiar kinds of studies in that literature. For instance, you send people to prison because they've caused damage to somebody, they've murdered somebody, and the family of the person murdered wants the murderer to suffer for the crime they committed. So they expect that the person should have a very long sentence. So in commonsensical terms, we associate a long sentence with a more heinous crime. But in reality, if you examine what happens to prisoners with long sentences, the pain of deprivation of liberty is only for a short period, maybe a year or more, in some cases, maybe 2 years. But quite soon, people adapt. These prisoners who are lifetime prisoners adapt to the fact that they are going to be there for the foreseeable future, as far as they're concerned. And they, in fact, adapt so well that they become kind of lords of the prison. They dominate fresh prisoners, young prisoners. They put fear in the wardens, and they pretty much run the prison, and they're not actually suffering in remorse for the crime that they have committed. So the economic analysis would say then why bother that the state should spend money looking after them for such a long time, because the pain of deprivation of liberty is short-lived. The adaptation to a long-term prison sentence is fairly quick. So it's economically efficient then not to have long-term prison sentences, to give short-term sentences, because that's when the pain would be most acute. And you save a lot of money in terms of prison populations, and you save a lot of trouble because these people on the life sentence are very powerful in most prisons. And this is an example of what economic analysis of law produces. But this is completely, in a way, antithetical to what a common sense, common man perspective would be. That person would say, lock him up forever. I don't care whether he is adapted hedonistically to prison life or not. Justice demands, and this is retributive justice, demands that the person should get a long prison sentence for a heinous or a more serious crime. So this is why I'd say that we have to be a bit cautious about this field called law and economics as is developed in the United States. And we should remember that if the law in the United Kingdom, in Europe, and in the United States has been favorable to capitalism, that's not necessarily because these judges had internalized the Coase theorem and were operating on that basis. It is simply a question of powerful interests, powerful lawyers, and judges coming from a particular class background, if you like, deciding in favor of, other members of their club more often than not. But the issue there is, in spite of that, in spite of the fact that the law favors the rich and the powerful, and in most poor people in the world do not have the protection of the law, and that in fact was the substance of a major study supported by UNDP on legal empowerment of the poor, it was called. And the commission was headed by an economist, Arnaldo Di Soto, and co-chaired by Madeleine Albright, who at one point was the US's UN ambassador and Secretary of State. And she and the committee included Arjun Sengupta from India. And they found that some 4 billion people don't have the protection of the law. And the law works mainly for the well-off and the well-heeled, people with long purses, as Justice Chandrachud once put it. So that's a fact. But nonetheless, even though that is a fact, there is something important about the rule of law, even if it is somewhat biased in the way, quite largely biased in the way in which it supports people or protects people. And this is a point that was made by a very great Marxist historian, E.P. Thompson. E.P. Thompson did a study of what is known as the Black Act in the United Kingdom. This was a law that was passed which provided for the death penalty for anyone who would steal or trespass into lands belonging to the lords. So there's the lord of the manor, and there's the peasant at the gate, and the peasant's place was to stay outside the gate, were he to go into the land of the manor and steal a deer, shoot a deer or hunt a bird to take home for the family supper, he became liable to the death sentence. And so it is this law that Thompson wrote about, how unequal it was, how the House of Commons was so dominated by these interests that they produced a death penalty for someone taking something for their livelihood from land that belonged. And the land anyway had once was commons. There was an enclosure movement where common common property was made into private property. All that happened. In spite of that, at the end of that book, E.P. Thompson writes, for all this, the rule of law is an unqualified human good. Now, for a Marxist to call the rule of law, which is supposed to be an epiphenomenon dictated by economic terms and economic interests and class interests, to call it an unqualified human good is really something. And he added that that the law, if it has to be a mask, it cannot do that unless it has some legitimacy as a law. It has to give justice at some point. And he laid a lot of emphasis on the procedural protections of the law and gave many instances of ordinary, humble people who had been arraigned under the Black Act, who, because of the procedural protections of the law, were able to avoid being sent to the gallows. So it is this emphasis on why procedure is so important in law comes not just from legal scholars who, of course, know the importance of the Civil Procedure Code and the Criminal Procedure Code, as they are called, but from a Marxist historian. And this is a point which is important because our courts, in an effort to reach out to the poor and to do justice unto them, have given somewhat short shrift to procedure. They make up their own rules as they go along, and they justify it because we are listening to the voiceless. The Supreme Court is the Supreme Court for Indians, not the Supreme Court of India, and and Indians by and large are weak and vulnerable, and we will protect them. So this was opening this is public interest litigation that I'm talking about. It had this noble motive that it will protect, but then in that process, if you give short shrift to established procedures of the law, you are doing some harm to the principle of the rule of law itself. And this is something we must be mindful, because what's actually happened is that in the early cases, the court had a lot of sympathy. It gave freedom to bonded laborers. It gave better humane conditions for women in the Agra Women's Home, which was run by the government of UP in very shabby and inhuman conditions. These people were forced to live, and Professor Upendra Bakshi and others brought the case to the court, and Justice Bhagwati and Justice Krishna, sitting as two judges, handled many of these matters, ordering reforms in Bihar jail and so on. But if you look at the consequences of this some years later, the bonded labor that Swami Agnivesh was able to liberate after a few years went back to the quarries and sought work from the very people who had held them in bondage earlier, because there really wasn't any other means of livelihood that they could have. The Agra Women's Home, which had been on the orders of Justice Bhagwati, been spruced up, and fans were installed, and toilets had been installed, and everything had been cleaned up. The UP government simply declared that the lease on that building came to an end, and it was not going to renew the lease, and it was going to hand over this well-furnished property now back to its original owner, and they will find another place where these Agra women would be relocated. Now, God knows what conditions they were living in. So, while the intention of public interest litigation originally was good, it was meant to help the voiceless. In fact, because it is a judicially mandated decree, you didn't really follow up and get the consequences that you really wanted. And what has happened since is that the courts have entertained all manner of cases where people claim it's a public interest. So the original intention of helping the underdog and the poor, which even though it meant taking liberties with procedure, it still enabled the court to order commissioners to go and investigate, to find out the facts, create an institution of amicus curiae to help the court find out what's actually happening. All that happened, but the liberties with procedure is a matter of some concern. And many of the cases that are now have deleterious economic consequences for the country have originated as public interest litigation. The case that Pradeep Mehta referred to about banning alcohol bans within 500 meters or 200 meters of a highway was brought as a public interest concern about road fatalities caused by drunken driving. And you entertain that, but that's got nothing to do with anyone like bonded labor or child labor, which was the earlier concerns, or people being treated inhumanely by being blinded in prison, which was one of the early public interest cases brought by Kapila Hindorani. And the case on coal blocks and the allocation was also supposedly in the public interest. That somebody says, oh, the CAG has said that the revenue loss has occurred to the state and therefore this must be investigated because these coal blocks were allotted illegally. And the court entertained these as matters of public interest. So that meant that they continue to take liberties with proper form and procedure, with finding out what should be properly proven in a court of law. So normally, say in the coal blocks case, the people who got the coal blocks, they were not if somebody committed a wrong, it was the government. If somebody benefited by a wrong committed by the government, they didn't, unless you can prove that they persuaded the government through illegal and corrupt means to benefit them, unless you prove that, you cannot penalize them on the assumption that the government did a mistake and you benefited by a windfall. And even then you could have investigated each one of those coal blocks to find out what was really the cost of the coal, instead of having an arbitrary uniform fine for anyone who mined coal, regardless of the quality of coal or regardless of what it costs to extract that coal. None of this, these are all matters of detail which legal procedure would have protected. If only the courts did not take liberties with these procedures by deluding themselves that they are acting in the public interest, and in the process causing great economic damage to the country, not just to the immediately affected parties, but because of a multiplier effect, a larger damage to the economy. So this is what we need to guard against. So I conclude by pointing out that we must be very careful not to mix up economic and law and economics as a discipline that is taught in many universities now, which makes economics the basis for legal decisions. In fact, in the discipline of economics itself, there is a serious soul searching and a questioning whether its fundamental assumptions that people go about trying to maximize their utility and so on is valid at all. And after the 2008 financial crisis, there's been a lot of churning and soul searching within the discipline of economics, because many people feel that economics and welfare economics began with a concern for the common good and for the welfare of the common people. That's the origins of it. Adam Smith's Wealth of Nations is about caring for the common good. Adam Smith pointed out that you wouldn't need a law of contract if had to be enforced by the state if people kept their word, if they were moral and good, if they were good Presbyterian Christians, according to Adam Smith, they would know that you made a promise, you keep it. But since human beings are fallible and would like to deviate from a moral principle, you need the force of law. That's the argument. So the entire concern initially in economics has been about welfare. It's later with the late stages of capitalism that you get an economics that makes efficiency a value. Now, why would you make efficiency a value? What efficiency in itself is not a value. You have to be efficient at something. A sharp knife is efficient, but what are you going to use that sharp knife for? That's what values are concerned about. If you use it to kill somebody, it's a value statement that it is wrong to do that, right? So efficiency in itself is not a value or a virtue. And economics, by elevating efficiency to such an extent, and in the process, forgetting the other concern of economics, which is redistribution, which is equity, which is fairness among people, all of that has been forgotten by this law and economics analysis. It's invited a lot of criticism. So for the purposes of our conference, we are concerned that judges should be mindful that they should not take liberties with procedure, that there is such a thing, be you ever so high, the law is above you, and that applies to the judges themselves. And they must follow the principle and be obedient to the law, which they are supposed to interpret and enforce. So that's what I'd say, that we need to get our judges to be more mindful that their decisions have large consequences. They shouldn't engage in this trespass into the territory of other jurisdictions of the legislature and the executive, as the Vice Chancellor pointed out. But equally, the legislature and the political class must also be mindful that if you use the judiciary to solve political problems, such as we have done, and a long-standing dispute that was settled by the court was the Ayodhya Ram Mandir case. That is what I would call judicialization of politics. But if you engage in the judicialization of politics, you will get the politicization of the judiciary. And so there is a responsibility not just with the courts and the judges, but there's a responsibility in the political class to give due respect and space to the judiciary and not politicize it to meet its short-term ends. So thank you.
Thank you very much, Professor Sudarshan, for that fascinating and comprehensive tour de force on the very different dimensions relating to law and economics, but also its huge implications when it comes to adjudication itself. I'm grateful to you for that comprehensive keynote address. Let me now quickly move to the next phase of our program. I have great pleasure in inviting Dr. Francis Julian, Senior Advocate, Supreme Court of India, to deliver the inaugural address. Dr. Julian holds an LLB and LLM degrees from the University of Madras. He has a Master of Laws from the Southern Methodist University in the United States. He also has a Doctor of Juridical Sciences from Tulane University in the United States. Dr. Julian has a vast experience of being a lawyer and working in areas of civil and commercial litigation, as well as one of the pioneers in maritime and shipping arbitration. He has been functioning as a maritime arbitrator and on the panel of maritime arbitrators in the Indian Council of Arbitration. Having a keen interest in academia, Dr. Julian is also an adjunct professor of law, teaching Admiralty and Maritime Law and International Commercial Arbitration at Jindal Global Law School of OP Jindal Global University, of which he's one of the founding members as well. After completing his SJD in Tulane University in the USA in 1985, Dr. Julian has been practicing in the Supreme Court of India and the High Courts of India and was designated a senior in the year 2006. Dr. Julian served as a standing counsel to the Food Corporation of India and has been actively involved in a number of issues relating to arbitration, particularly commercial arbitration, as well as shipping and other areas. He is also widely published and has been one of those few lawyers in India who constantly engages and quite substantively in legal academia. With those words, I request Dr. Julian to deliver his inaugural address. Can you please unmute yourself, Dr. Julian?
Okay. Thank you, Professor Rajkumar, the Vice Chancellor, for the nice introduction. Today, I'll be dealing with the economics in judicial decisions, the topic of today's program. And being a lawyer for the 40 years in Supreme Court, I thought I would make a narration of the Supreme Court decisions dealing with economic issues, starting from earlier days and the current situation during the pandemic which we are facing. The role of the Supreme Court has been really moving from active participation in economic issues, then slowing down, then again taking an active role, and again the approach is one of reservation. Maybe this is due to the type of cases faced by the court, a different type, and also depending on the philosophy of the judges who dealt with the cases. The courts in India today, especially the Supreme Court of India, have been more and more adjudicating issues of economic significance. Therefore, there is an increasing relevance of the interface of law and economics. This interface had raised some important issues on the role and functioning of courts, on issues pertaining to economics in judicial decision-making process. The major issue which has arisen in this context is the respective roles of the judiciary, the legislature, and the government in economic policy decisions. In the Constitution of India, the doctrine of separation of powers has been well enshrined. Under this doctrine, the role of judiciary is only in rendering decisions on the application of the principle of rule of law. The economic policy making and its implementation is the function of the executive. Therefore, the crucial issue has arisen as to the scope and extent to which judiciary can take decisions which involve economics or having economic implications. Another equally important issue is the extent of expertise and the competence required by the judges when they have to take decisions involving economic issues and the process to be adopted in such decision making. I will attempt to deal with these issues on the basis of the decisions and the legal principles evolved by the Supreme Court of India. Globalization and Supreme Court of India. In the 1970s and 1980s, when India was following the socialistic approach in its economic policy, courts upheld the policies of the government. The land reform laws, the abolition of privy purse, and bank nationalization were upheld by the Supreme Court. Economic legislation enacted to implement socialistic ideology were held to be constitutionally valid. Courts did not apply economic principles to judicially review the economic laws passed by the parliament or state legislature. In fact, in this period, courts played very little role in dealing with economic issues in decision making. The increasing role of the judiciary in dealing with economic issues began with the economic liberalization and privatization in India in the 1990s. Soon thereafter, the process of globalization took its root in India. The phenomenon of globalization attained judicial recognition in India. The Indian Supreme Court accepted the legal and economic changes brought about by globalization and took judicial notice of the same while deciding cases. Consequently, the Supreme Court recognized the phenomenon of globalization while deciding cases involving education, reservation, payment of wages, land acquisition, and in the interpretation of laws. In 2004, while applying the doctrine of judicial precedent in deciding cases, the Supreme Court took note of the changes in law caused by changed conditions brought about by globalization. The court in Devan's modern brewery case said that the principles laid down in the old decisions of courts may not be the correct law in view of the changes brought about by globalization. The court stated as follows, to quote, the doctrine of precedent is a well-accepted principle. A ruling is generally considered to be binding on lower courts and courts having smaller bench structure. However, although a decision has neither been reversed or overruled, it may cease to be law owing to changed conditions and changed law. There cannot be any doubt whatsoever that a law which is at one point of time constitutional may be rendered unconstitutional because of passage of time. This is reflected by the principle cessante ratione cessandi ipsa lex. With changes that are bound to occur in evolving society, the judiciary must also keep abreast of these changes in order that law is considered to be good law. This is extremely pertinent, especially in the current era of globalization, when the entire philosophy of society on the economic front is undergoing vast changes. Similarly, in 2007, in the JK Industries Limited case, the Supreme Court brought into focus the globalization impact on the context of upholding adoption of international accounting standards in India. The court stated as follows, to quote, with globalization, India is required to face challenges in various forms. Corporate India has been acquiring companies in India and abroad. Indian companies are partners in joint ventures. They are part of the international consortium. Therefore, Indian accounting standards have to harmonize and integrate with international accounting standards, by which harmonization of various accounting policies, practices, and principles would take place. Similarly, in the Reliance Energy case, in dealing with global competition in the context of judicial review of government actions in contracts and commercial matters, the Supreme Court stated that government actions have to be tested from the yardstick of economic principle of level playing field to deal with global competition. The court said as follows, the quote, when Article 19(1)(g) confers fundamental rights to carry on business to a company, it is entitled to invoke the said doctrine of level playing field. We may clarify that this doctrine is, however, subject to public interest. In the world of globalization, competition is an important factor to be kept in mind. The doctrine of level playing field is an important doctrine which is embodied in Article 19(1)(g) of the Constitution. This is because the said doctrine provides space within which equally placed competitors are allowed to bid so as to subserve the larger public interest. Globalization, in essence, is liberalization of trade. Today, India has dismantled licensed Raj. The economic reforms introduced after 1992 have brought in the concept of globalization. Decisions are acts which result in unequal and discriminatory treatment would violate the doctrine of level playing field embodied in Article 19(1)(g), unquote. Apart from the Supreme Court, other courts in India have also taken judicial note of the globalization phenomenon in several decisions. Then regulatory legislation and quasi-judicial bodies. The post-globalization trend in taking decisions involving economic issues continued even in the new millennium. Following privatization and economic liberalization initiatives, the Parliament enacted several regulatory laws in the field of telecom, electricity, insurance, ports, building construction, real estate, and other fields involving economic activities. In such of these areas, regulatory bodies were created with quasi-judicial powers. Supreme Court was vested with the final adjudicatory power to examine or review the decisions of these quasi-regulatory bodies. In deciding matters arising out of the decisions of these quasi-judicial authorities, the Supreme Court had to apply economic principles. Another major controversial issue was the cancellation of telecom licenses and coal mining leases. In 2012, the Supreme Court, in far-reaching decisions, canceled large-scale allocation of 2G telecom licenses and coal mining leases granted by the government. These decisions had caused severe economic implications. The court canceled 2G license issued by the telecom department on the ground that the allotment of 2G licenses were arbitrary and violative of Article 14 of the Constitution of India, since the proper method by which the national resources should be allocated was by public auction. The contention of allottees that the allotment of telecom and coal mine licenses were based on policy decisions of the government in adopting the best way to allocate natural resources on first-come, first basis was rejected by the Supreme Court. However, in a subsequent decision arising out of the presidential reference in this matter, the Supreme Court clarified that public auction was not the only method of allocation of natural resources. The court clarified that, to quote, there is no constitutional imperative in the matter of economic policies. Article 14 does not predefine any economic policy as a constitutional mandate. Hence, it needs little emphasize that disposal of all natural resources through auctions is clearly not a constitutional mandate. However, the decisions involving cancellation of telecom licenses and coal mining licenses attracted large-scale criticism on the ground that while taking these decisions, the court had failed to consider the large-scale economic impacts of these cancellations. These were mainly the huge economic loss suffered by the allottees, the loss of their investments, and large-scale unemployment generated by the cancellation. Acceptance of the economic principle in judicial decision-making. In 2017, in Shivashakti Sagar case, the Supreme Court in so many words acknowledged and reiterated the need for applying economic principle in judicial making. Maybe it is for the first time that Supreme Court by Justice Sikri laid down some specific principles on this issue. The Supreme Court stated as follows, to quote, it has been recognized for quite some time now that law is an interdisciplinary subject where interface between law and other sciences, social sciences as well as natural, physical sciences came into play, and the impact of other disciplines on law is to be necessarily kept in mind while taking a decision, of course, within the parameters of legal provisions. The interface between law and economics is much more relevant in today's time, and the country has ushered into the area of economic liberalization, which is also termed as globalization of economy. India is on the road of economic growth. It has been a developing economy for a number of decades, and all efforts are made at all levels to ensure that it becomes a fully developed economy. Various measures are taken in this behalf by the policy makers. The judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in this direction. It calls for an economic analysis of law approach, most commonly referred to as law and economics. In fact, in certain branches of law, there is a direct impact of economics, and economic considerations play a predominant role, which are even recognized as legal principles. Monopoly laws, popularly known as antitrust laws in USA, have been transformed by economics. The issue arising in competition laws, which has replaced monopoly laws, are decided primarily on economic analysis of various provisions of Competition Commission Act. Similar approach is to be necessarily adopted while interpreting bankruptcy laws or even matters relating to corporate finance, etc. The impress of economics is strong while examining various factors of the issues arising under the aforesaid laws. In fact, economic evidence plays a big role even while deciding environmental issues. There is a growing role of economic in contract, labor, tax, corporate, and other laws. Courts are increasingly receptive to economic arguments while deciding these cases. In such an environment, it becomes the bounden duty of the court to have the economic analysis and economic impact of its decisions, unquote. Thus, the economic analysis of law has expanded beyond the original focus on competition laws, taxation laws, and other areas of economic regulation. The new economic analysis of law embraces torts, family law, intellectual property laws, regulation of health and safety, laws forbidding discrimination in employment, to name a few. The recent trend, the current trend is that the judicial restraint in cases involving economic policy is continuing. In recent decision involving tax laws, the court has left it to the legislative judgment on economic issues on the ground that legislature has the affirmative responsibility to take decisions. Therefore, court actually went back in applying economic principles in decision making on the ground to quote, in the utilities, tax and economic regulation cases, there are good reasons for judicial restraint, if not judicial deference to legislative judgment. The legislature, after all, has the affirmative responsibility. The courts have only the power to destroy, not to reconstruct. This is the decision by Justice Chandrachud. So similarly, when dealing with constitutional validity of recent bankruptcy court, the Supreme Court reiterated its limited role in interfering in economic policy decisions of the government. However, in the context of human rights, the Supreme Court has reiterated in the current pandemic situation the need for considering economic situation of the individual affected in the light of the directive principle in the light of the directive principles of state policy and Article 21 and 23 of the Constitution. To quote, the Constitution allows for economic experiment. Judicial review is justifiably held up in matters of policy, particularly in economic policy. But the directive principle of state policy cannot be reduced to oblivion by a slight of interpretation. To a worker who has faced the brunt of the pandemic and is currently laboring in a workplace without the luxury of physical distancing, economic dignity based on the rights available under the statute is the least the Supreme Court can ensure that. Judges must constantly remind themselves of sentiment of the sentinel on the quay way if the call of the constitutional conscience is to retain the meaning. The right to life guaranteed to every person in Article 21, which includes worker, would be devoid of an equal opportunity and social and economic freedom in the absence of just and humane conditions of work. Actually, this judgment in the context of pandemic, where the government actually withheld many benefits to the workers on the ground due to pandemic, the factories had to stop functioning. So the Supreme Court intervened in this context. What are the contentious issues in this particular topic? The following are some of the contentious issues involved in applying economics in judicial decision making. One, whether judiciary should deal with economic issues in judicial decision making. If so, what should be the decision making process or approach? 3, what parameters the judiciary should adopt while taking decisions applying economic analysis? 4, which economic principles the court should apply? 5, to what extent this would be consistent with the doctrine of separation of powers under the Constitution. My conclusion is that the courts today are increasingly involved in taking decisions involving economic issues. However, the judges are aware of their limited role in taking decisions involving economic policy matters. In matters pertaining to human rights and economic regulatory laws, the court's role in dealing with the economic issues has increased considerably. However, in India, the judges need sufficient expertise and knowledge to deal with economic issues while taking decisions. In matters involving larger public interest, especially in public interest legislation, courts play more proactive role in the decision-making process by applying economic analysis. Courts may often exercise broader powers of judicial review, including limited economic analysis in their decisions, especially in the matters involving large-scale violation of human rights and environmental matters wherein the beneficiaries are poor and downtrodden who belong to economically weaker sections. The polluter pay principle evolved by courts in environment matters is one such example. But in private disputes where larger public interest is not involved, and in matters pertaining to interfering with powers of other two branches of the state, namely legislative and executive actions, the application of economic principles while exercising the power of judicial review require much care and caution. This may involve some judicial review, sometimes judicial review and examination of policy issues which are in the domain of the legislature and executive. It is necessary to evolve legal principles by jurists and legal scholars to assist the court in evolving principles, the application of economic principles or economic analysis while taking decisions. Unfortunately, in India today, such information is not available. There is little legal literature available to assist judges to apply economic principles in decision making. Legal research should focus more attention in this area. The initiative today, focusing discussion on this topic, is a much awaited one. I appreciate the organizers. Thank you.
Thank you very much, Dr. Julian, again for a fascinating and very comprehensive evolution of the history and indeed the various jurisprudential developments that has happened in relation to law and economics, and also the implications of the court's decisions on policy and governance. So I truly appreciate the time that you have taken to deliver this inaugural address. I think both the keynote address and the inaugural address has set the stage for the next 2 days of deliberation. With those few words, I'm going to request Professor Ashish Bharadwaj to deliver the vote of thanks for the inaugural session.
Thanks very much, Raj. I completely agree with you. It was such a delight to hear all the speakers. I mean, their views not only signify the relevance of the theme that we have selected for the conference, but it really tells us what is really at stake in all these discussions that will take place and their impact on our society, on our judiciary and economy. So I completely agree with all the speakers. Economics, as an economist myself, I can say that the discipline indeed has a lot to offer to law, to public policy, to judicial decision making. The speakers talked about several noted economists. The proposals suggested by Arthur Pigou, Dr. Julian just mentioned about the polluter pay principle. Professor Sudarshan talked about Pigouvian tax. I mean, some of these things are accepted and implemented even today. So that our participants know, the carbon taxes to address climate change, the so-called fat tax on sugary drinks, which the state of Kerala imposed on fast food a few years ago, they're all in the same category of Pigouvian taxes, taxes on tobacco, on alcohol, and even subsidies on vaccines that are being rolled out today as we speak are all examples of Pigou's visionary model for taxes and subsidies. The speakers also touched on the concept of externalities, which was again introduced by Pigou. And there's a very interesting and a very light story that a German professor of mine had shared with me, which I would like to share with everyone. The concept of externalities was universally accepted by economists about 50, 60 years ago. Economists who generally don't agree with one another. But there was one interesting evening in 1960. This is documented when the British economist Ronald Coase, the name came up in the addresses by the speakers, he came to the University of Chicago to present a paper. This is the same paper that Professor Sudarshan also mentioned in his address. He spent the evening at the house of Aaron Director, who was the founding editor of the Journal of Law and Economics. Now, counting Coase, 14 economists were present, half of them were future Nobel Prize winners. When the evening started, the 12 angry men, so to say, in that group from the Chicago school, they grilled Coase academically, intellectually, and they fiercely supported this conventional view of externalities which Pigou had described. When the evening ended, none of them was willing to stand by the same argument that Pigou had proposed. Coase had successfully persuaded all of them that this Pigouvian analysis had deficiencies, not in one way, but in 3 to 4 different ways. He said that the problem is not externalities at all, but it is really a problem of transaction cost. And if one thinks about it, these costs, transaction costs, are one of the key reasons why several nations stumbled in the COVID vaccination drive. But that's, of course, a separate discussion. This paper that I'm referring to, that others also talked about, is a paradigm shifting paper published soon after this famous dinner meeting. And it remained till 2013 the most cited law review article of all time. The interesting thing is, most cited law review article written by economist Ronald Coase. So as I close this session, I wish to also thank, of course, the speakers of the session, but the work of the remarkable legal scholars and economists who started this revolution called law and economics. We heard from each speaker in this session that completely overlooking economic considerations and in judicial decisions may have significant economic and financial implications, including making several stakeholders economically quite fragile. Therefore, a lack of economic analysis of some form or lack of reliable data-driven assessment in judicial decisions may result in intended and unintended consequences for not only employment or consumer prices, state tax revenues, but also for infrastructure, hospitality, tourists, real estate, and other economically relevant sections. Now, these are some of the areas that are going to be discussed in this conference, including a conversation tomorrow with Mr. Mehta, which we are very much looking forward to, on his highly awaited book, Supreme Court and the Indian Economy. So once again, Dr. Julian, Professor Sudarshan, Mr. Mehta, Professor Rajkumar, thank you very much for your remarks, for your views. We can now close this inaugural session, and after a 10-minute break, we return to the first plenary at 10:55 a.m. India Standard Time.
Thank you very much, Ashish. And once again, I thank all of you.
who's moderating?
A very good morning to all of you. I would like to extend a warm welcome to all of you to the first thematic session of this national virtual conference on the theme Economic Dimensions and Judicial Decisions. We just had an inaugural session which focused on the economics of judicial decisions or judicialization of the economy. We are beginning the first thematic session on the theme Economic Analysis of Public Infrastructure, Trade and Constitutional Law. We have with us a very distinguished group of individuals who have taken time from their precious schedule and also battling with these extraordinary circumstances under which all of us are living to take our time to be part of this particular panel. Let me begin by welcoming my own colleague, Professor Dr. James Nedumara, Professor at Judicial Global Law School and Director of the Center for Trade and Investment Law, who has kindly agreed to moderate this panel. We have with us my dear friend and mentor, Dr. Pinky Anand, Senior Advocate, Supreme Court of India, former Additional Solicitor General of India. We have with us Dr. Aruna Sharma, former Secretary, Steel Government of India, Member, Digitization Committee of the Reserve Bank of India, Mr. Bipul Chatterjee, Executive Director of Cuts International. As you know, Cuts International is our co-partner and organizer in this conference, and also Dr. Surat Singh, Senior Advocate, Supreme Court of India, another very dear friend and mentor who will be joining us soon. With those words, I'm going to extend a warm welcome to all of you and hand this over to our moderator, Dr. James Nedumara. Me and my colleague, Dr. Srijit, are indeed available, and we will be listening to all of you during the course of the session. Thank you.
Thank you, Dr. Raj. Dr. Srijit, and I would also like to welcome Dr. Pinky Anand, Mr. Bipul Chatterjee, Dr. Aruna Sharma. In fact, I was supposed to be a speaker in this session, but I turned out to be moderator. But I would also like to add a few, comments about the economic analysis, especially with respect to international economic law. So when we look at the economic analysis of law, it is not a new thing. It has been there for a fairly long period, especially since Richard Posner's book came out in 1974. And when we really look at the economic analysis of law, it is basically focused, traditionally looked at some of the private law domains like a law and contract. So when private parties interacted, whether a party can actually breach a contract if it is leading to certain kind of efficiency, or in certain situations, how can responsibility between two private parties can be assigned or allocated under the law. But in recent times, this debate has also become particularly relevant with respect to constitutional law. Sometimes who believe believe in utilitarian concept of consequentialist legal theories may believe that economic analysis is actually a far-fetched idea. But at the same time, if you really look at the Pareto optimality principle, which finds a very important expression in John Rawls' theory of justice, ultimately the entire purpose of law is to make somebody better off without making anyone worse off. But in every domain of law, this has actually found a very important place. And the two important areas which Professor Raj alluded to is one, construction and infrastructure law. We know that whenever we conduct major infrastructure projects or even construction projects, sometimes people have to be displaced. And in a country like India or maybe in a city like Bombay, we know that this is an acute problem. So even individual rights and liberties come into the picture. And there are many other issues as well, like taking land and other holdings. So when it comes to these matters, to what extent the typical Kaldor-Hicks concept of economic efficiency matter is a moot question. But at the same time, we also know that the courts in India will have to deal with this kind of issues on a regular basis. Think about a situation where someone has actually constructed a condominium and the cost of construction is very high, but it was found out later that it was actually an illegal construction. Should it be demolished or turned to rubbles? Or can there be some effective method of disciplining this kind of illegal behavior? Ultimately, if you look at economic analysis of law, the basic assumption is that everyone has to actually become a rational economic actor. It doesn't mean that everyone has to be a well versed in economics, or maybe extremely competent in doing this very complex econometric modeling. That is one area which I would like to mention also. If you look at some of the statutes, so being a trade lawyer, I always think about the safeguard statute. According to the safeguard statute, if imports come in large quantity, sometimes it may cause injury to the domestic industry, then of course there is actually a trade remedial provision. But the reality is that the imports are actually coming in because the domestic industry is not in a position to compete. So sometimes the economic analysis, not the economic analysis, the economic approach may not be there in the original statute. Sometimes it is an antithetical concept as well. So in these kind of issues, what does economic analysis actually matter? So we have got an extremely knowledgeable group of people here. Dr. Pinky Anand, I think I will start off with Dr. Pinky. Given your experience of handling very complex litigations in the Supreme Court, would you like to touch upon the role of economic analysis of law in the decisions of higher courts in India? And to what extent courts can actually use this kind of a concept while delivering decisions? Over to you, Dr. Pinky.
That's a very tough question in a way. All said and done, we have a constitution. All said and done, we have statutes, we have legislations. They've incorporated the basis on which lawmaking or law and justice should prevail. So basically, the entire enumeration of analysis by courts of rights is based upon the legislation as it is provided, and of course the test of the legislations against the constitution as and when required. Having said that, I think the real domain when we enter into this discussion, and you're right, there is this entire conflict as to what is a better model to look at. Social welfare is inbuilt into our constitution, and all kinds of legislations have taken that into account. The constitution and the courts increasingly have been enlarging the compass of Article 14 and 21 to heighten human pleasure, if you like, or human welfare, public welfare, social justice in all manners. Infrastructure and construction possibly are a different domain. Workers is another domain. Migrant workers is another domain. COVID situations is another domain. Healthcare is another domain. So, you have this entire paradigm of issues. So coming to the question back at hand, you have legislation which incorporates the rights on the basis of which judgments are rendered. But you have another domain, which is where the courts step in. Now, these are two basic dimensions. So the second dimension is public interest litigation, Article 226 and Article 32. And the third is Article 142 of the Constitution, which allows court to do, and the Supreme Court to do complete justice between the parties. So broadly speaking, it is only in these three domains that courts can enter into an economic analysis in any manner whatsoever. Otherwise, frankly speaking, according to my understanding, and according to my understanding of the law as it has happened, the entire interpretation of law is based upon the existing laws. But when you come to the areas of public interest litigation, which is of course manifold at this point of time, right from 1980s onwards, I think we've been experimenting, and this stretches across all domains. So for example, in issues where you're talking about industries, let us say closing down. Now, as an example, or you're talking about firecrackers industries, you're talking about Diwali, you are talking about Arjun Gopal's case, which was given, I was a party to that case also. And the whole question was, can you, in the interest of the public and health and environment, shut down the firecracker industry? And indeed, the court did do so. The pollution levels in Delhi were so high that it was killing by itself. So even at the cost of an industry shutting down, the entire basis was made. So courts also, I might say, do lean more in favor of social welfare than in favor of possibly sheer economics of industry. And I think that indeed is a thing that we require in this country. In India, we are dealing with a 1.3 billion population. We are dealing with a class difference between different classes of people and status in terms of whether economics or whether living or whether availability. So the essentials that are being taken into account by the court in economics, if at all in the jurisdiction of PILs and other jurisdictions that I mentioned, it is still veering more in the line of social welfarean economy, which is the manner in which we proceed. So you will find several examples, particularly in these COVID times, As I said, whether you talk about the Vande Mataram flights that are which are going to bring in children across from other countries or people across from other countries, whether you're talking about the safety and welfare of healthcare workers, whether you're talking about the availability of vaccines, whether you're talking about oxygen supplies. So the entire focus broadly in this jurisdiction is of social welfare in nature, and possibly that is the right thing to do. As far as issues of economics is concerned, sheer economics and commercial, there I'll bring in two aspects. One, again, in the current context of COVID, it becomes rather imperative to be constantly talking at this point of time because we are dealing with the situation. The government, for example, so the first leg is the government. The government took into account the difficulties that were confronted on account of COVID conditions and came out with several circulars and guidelines, which dealt with COVID as a force majeure condition. So force majeure kicked in to help people in terms of commercial or other transactions which were economic in nature. Two, again, the government came out with construction contracts and the question of extension of infrastructure projects, because ultimately it was realized that the benefit to the economy would be on account of infrastructure projects which could carry on rather than any kind of termination which would come on this account. So in these two domains, the legislature and the government and the executive came out with its policy as far as economics was concerned and law was concerned to alleviate the difficulties that happened. As far as the courts are concerned, I have already mentioned some of the features that the courts have gone into. But currently, I'll just talk about one of the cases, which is, for example, just now, which came up before the court, the Vedanta case, for example, which talked about setting up an oxygen plant to supply oxygen at the time of crisis and the unavailability of oxygen to the hospitals and the patients, the COVID patients. That is again a question which needs to be considered. There are several other issues that I've been hearing about. For example, setting up additional healthcare facilities by private citizens who want to cooperate and collaborate with the government in order to provide assistance. There are hiccups in that direction. And the third direction that I think I'll just flag for the time being is the crisis always between social justice and development. Now, that is a constant kind of conflict. For example, in construction projects, the displacement, as you mentioned, the construction of buildings. So you require roofing or you require a roof over the heads of people, whether it is employees, whether it is government employees, whether it is private citizens. And B, you have the question where there's a conflict with the environment or other conditions like traffic, congestions, which also lead to pollution and other environmental issues. So these are the kind of questions that are confronted by us all the time, and we are actually grappling with it. But the jurisdictions within which we can do, as I mentioned, is the jurisdiction of PILs, 226, 32, Article 32, and then again Article 142, where the court can kick in justice to bring in parameters. And there you can consider other aspects of law.
Thank you, Dr. Pinky. I think that was a very insightful observation, actually. So what you're trying to say is that in India, most of these actions, especially through Article 32, Article 142, and all these instruments are basically used in order to advance the social welfare. But sometimes the social welfare may be concentrated, sometimes it may be diffused in nature. So you spoke about a decision to, open up an oxygen plant in one particular place. And the local community in that area may be rather opposed to that idea. Or maybe, it's very similar to a situation where someone actually set up a waste disposal plant. The local community is up in arms. And that waste disposal plant was actually, it was shut down. And there are, of course, negative externalities. I think people are throwing the waste, the garbage into the public area. So there could be consequences as well. So in this kind of matters, I just wanted to ask you, when multiple interests, multiple stakeholders are actually involved, and when a court like the Supreme Court of India exercises the jurisdiction, which may have a pan-India impact, to what extent it is actually possible to take into account the various categories of interest vis-a-vis the concentrated interest? That's
not an easy task. In a diverse country, in a country such as India, where you have all classifications of people and all classes of people, and I mean this in economics, in sheer terms for the time being, or in terms of facilities or utilities being available. So it's a very tall order. But I think, let me give you an example of what I think the Supreme Court or any other court can and does do when you evaluate interests, the question is of balancing interests. You can't have absolute exercise of any right. So, for example, when health issues come in, when security issues come in, now these are just two concerns that I'm flagging for the time being. If you talk about health and security, they have to take precedence. So you have to have the health and security as primary considerations, particularly for a sovereign nation like India. I keep coming back to health. I can't avoid that focus. But as I said, even security, for example, for security, if anything is required, whatever means are required to adopt to gear in that direction is something that we need to step towards. Whatever directions we need to head as far as health is concerned, I'll just tell you for a moment. I was actually, this question I was confronted with in Arogya Setu as an application, and the question was of other concerns, divergent interests like privacy and other issues which were coming up. Now the question really is then, and this came to my mind, that there cannot be any ambiguity in this direction. You have to give precedence to health, and if any method is adopted, which for the time being in such a crisis and emergency can alleviate misery in any fashion or help the people in any fashion, that has to be given precedence. It has nothing to do, and this is not economic, I'm so sorry, this is another concern. So these are the kind of grappling issues that the court has to grapple with at times. Now, for example, the supply of oxygen, the interstate movement of oxygen across hospitals. These are all the issues that the court does deal with. And you are right, at various times, the court has its own limitations in the sense of how to balance the interests, how to consider the balancing of interests, the question whether it is policy making and the courts can enter into that domain or should they enter that domain. But I think there comes a benchmark. There comes a Lakshman Rekha, so to say. And at times you have to cross the Lakshman Rekha because there is an emergency situation which can't brood any delay. So you have to take action at that time. But in normal circumstances, what happens? But let me just give you an example there. What the court very frequently does, as it has done in the case of transport, pollution, environment, is have an amicus to assist the court. And it has happened in several cases. I myself have acted as amicus in several cases which involved either water distribution or literally the interwater situation as far as the country is concerned. So the court very often takes the assistance of an amicus to take the issues of various interests into account. But believe me, it's a tall order. I really struggle myself at times because it would be such a hard position to take that you take one interest in that sense and you balance it against the interests of certain other stakeholders. So somebody or the other is always unhappy. But the point is, you have to see the social good. That you take the public good. This is the typical Socratic kind of an Aristotelian concept. Public good is what has to be seen. And as long as that is done, even if there is some possible harm or hardship caused to the other section, that has to be for the time being bypassed.
Thank you, Dr. Pingy. In fact, very useful. I think you spoke about the importance of prioritizing interest, and some interest like health definitely will trump over other rights, and they will have to be actually given certain amount of importance and weightage. So very valid point in terms of the obligation of the courts to balance various categories of interest. So now let me turn to Mr. Bibul Chatterjee with Cuts International. And given the field that it is, this is actually my own field, international trade law. And one of the maxims is that in international trade, neither law nor economics matters. It is basically political expediency. What works in a particular negotiation will ultimately decide the text of the agreement for that matter. So, Mr. Chatterjee, in your experience of handling trade, international trade and economics for a fairly long period of time, do you feel that the existing mechanisms, the courts in India, or maybe even international tribunals for that matter, are competent to provide an economic analysis of trade agreements or in the context of the domestic statutes and interpretation of the domestic laws? Over to you.
Thank you, James. I'll stick to the question which you have posed to me. But before that, let me very briefly talk about one very important point, and that is also related to the question which you have just posed, that any law should be made in a manner that it is Pareto superior. That nobody, at the end of the day, the net benefit should be there. Of course, there will be some losers, there will be some winners, but there should be net benefit. At the same time, we have to also keep in mind that those who are losers, how are we going to compensate them? Is there any provision in a particular law to compensate the losers in the short run and also in a dynamic manner over the medium to long term? So that's the basic premise which we have to keep in mind. Now, coming to your question, I agree with you that, and also disagree with you in another sense, that it is true that when it comes to international trade, economics sometimes doesn't matter. And that is evident from the various negotiations, trade negotiations with which we have involved with. At the end of the day, what matters is the political economy of the subject. And also you have to look at various subjects together. I can give you one or two examples that when the TRIPS agreement was being negotiated at the CAT, we were aware of the fact that it is going to be harmful, at least in the short run, it's going to be harmful. We are going to face a lot of cost as a result of that agreement. Then it was also pointed out to us, by us, I mean India, that we'll get compensation, we'll be compensated through the gains that you are going to get from the agreement on textiles and clothing. So this is the balance that we are talking about when it comes to international trade agreements. Now, it is easier said than done. How are you going to reach the balance? Let me give you one personal experience which I encountered in 1997, the winter of 1997, during my first visit to Geneva. There was a meeting at the WTO's building. And after that meeting, there was a session. A number of very eminent speakers were there. I couldn't gather much courage to pose a question to one of them. So that question was bothering me much. But after the session, I could meet him in the lobby, Ambassador Julio Lacarte, one of the stalwarts of international trade negotiations, trade agreements, one of those three who drafted the Havana Charter in 1948. So I asked him, Ambassador Lacarte, what you have discussed is not making much of economic sense in terms of economic theories which you have studied. And his answer was simple, that my son, in this building is the politics which matters, not economics. So that is something which you have to keep in mind. Therefore, James, I agree with you, but at the same time, you have to keep in mind that how are you going to marry law and economics together? And there, I think we have a long way to go. I studied in one of the best institutions in India, which teaches economics. There's a course, Economic Development and Planning in India. And you'll be surprised, or may not be surprised, to know that nothing was taught about economic laws. So that's, if not the best, one of the best institutions in India. And that was more than 30 years ago. Now today, when I look at their course structure, still it's more or less the same. So my point is, our economists, they do not know much about the laws. Even when we are taught social welfare or issues which are very much competition issues, for example, we are not at all aware about the legal implications of various provisions which are there in our laws, or the economic implications of those provisions. And therefore, I don't know about the law schools. I shouldn't speak about them since I don't know from inside. So, so this is where the system is. So what I think which we require is systemic reforms in our education system in general, but in terms of of the teaching of economics as well as sports. And only then we can have a better understanding before passing any judgment on an issue which have various conflicts of interest. So there will be costs, there will be benefits. I don't know whether cost-benefit analysis is done before passing any judgment on specific subjects like this Starlight case. Have we done any cost-benefit analysis? I don't think so, because systematically it is not. We are not taught, or we are not tuned to do such kind of analysis. So therefore, I will end by emphasizing on this point that, and this is also related to our trade agreements or trade negotiations. Before entering into any agreement while negotiating, do we look at the kind of changes which are required in our laws? Or are we making our commitments without understanding their legal implications? To tell you honestly, James, I don't think we look at that holistically. That requires a lot of work. And not just the work, it has to have a system in place. And some of this system, not just the whole of government approach, that's one part of the story. The system which includes the involvement of not just the executive arm, but also the judiciary arm, the administrative arm, the industry, the academia, the whole ecosystem, which is still very much missing in our country. And I think that's the root cause of all problems, all issues, knee-jerk reactions that we are facing today. And unless it's not going to change over time, we have to have a vision for over a period of 10, 15 years to overhaul this system, so that we can have a much more holistic understanding about issues. And going back to your initial point, to make laws in a manner that they are Pareto superior. Thank you, and over to you.
Thank you, Mr. Bibir. In fact, I will have a follow-up question, and of course, I will have more questions later. So you made some very valid observations. And the first point which you mentioned is that in any kind of a trade negotiation, obviously it is basically a matter between accommodating the interest of the losers versus the winners. But as a think tank, that advise the industry, the civil society on the possible outcomes of trade agreement, do you often anticipate difficulties in telling the losers that you are likely to be a loser in this particular trade negotiation, but there are overall economic welfare gains from the country signing that agreement? So maybe I think that is a very important issue, and that is why we are facing huge amount of backlash against various international trade agreements. There are so many examples in recent times. And second, the point which you mentioned, that the economic analysis of law in the current context is always spoken about providing a kind of an interpretation which is informed or inspired by economics. But my own understanding is that when we think about economic analysis of law with respect to trade agreements, there has to be an ex-ante analysis of the negotiating text. And that negotiating text will have to, I just try to predict or project what kind of, consequences or good effects will come out of the agreement. So, being a central figure in the civil society movement in India, how do you basically communicate with the concerned stakeholders about the outcome, the economic outcome of a trade agreement that is actually in the making?
On both points, I agree with you. The answer is yes. But how do we do it? That's the question. We do it in a transparent manner. Your questions are related to each other. For example, in case of you India FTN or BTI, whatever you call it, we did ex-ante analysis, sector by sector analysis of what will be the impact of this agreement on these sectors in India, and what will be the impact on household income. The tools are there, the data are there. It's not difficult, it's time consuming, it's laborious, but it's not difficult. Now, based on that, you have to do, which we always do, and Commerce Ministry also, they also do. You have to do stakeholder consultation, large scale stakeholder consultation. I'll give you one example. You remember during the peak of the Doha round of negotiations, there was a discussion in case of industrial goods, the so-called NAMA, which is known as NAMA, non-agricultural market access, which effectively means industrial goods. There is a proposal by the United States and many other countries to have a sectoral approach. 0 on 0, 5 on 0, that you reduce your tariff to 0 on certain tariff lines, certain products. We will also reduce our tariff to 0. You reduce your tariff to 5%, we will reduce our tariff to 0%. So before taking any position, I'm sure James, you are part of that UNCTAD project. Huge amount of consultation. First, the groundwork, the research work, secondary database research work. Then extensive consultation was done all throughout the country, led by the Commerce Ministry, supported by both FICCI, CII, other business associations, and civil society organizations like us. And at the end of the day, we found that there are certain sectors who are open to this, there are certain other sectors who are not open to this. But net on balance, most of the sectors are not open to this approach. So that's how we took our approach. Now, when you talk to losers, the most important thing we need to understand and do that what about the adjustment program? In a country like India, after 70 years, after doing so many negotiations, we are yet to come out with a trade adjustment program. And this is the point which you have been conveying to the Commerce Ministry for a long time. But some bits and pieces are happening, but you have to have a very holistic approach for a trade adjustment program. Many countries in the world, including developing countries like Kenya, like Ghana, they have this kind of approach, like South Africa, like Malaysia, Indonesia. So they have, if not robust like United States or many European countries, but at least they have that. So we have to have data-based trade adjustment program. It's not a difficult thing to do. You can also ask for revenue compensation for running such a program, that you can build in that kind of a provision for a program like that, so that over time, losers can gain new skills, new employment opportunities, new livelihood opportunities. And there is an overall consensus in the country before going into any trade agreement. Over to you, James.
Thank you. Excellent point. Again, I think the point which you mentioned about the trade adjustment program is absolutely valid. In any way, it is actually part of the political bargain. And my own feeling is that if anyone has actually lost out, then, like the social benefits they get in their bank account, those kind of losers should be given a cash grant. I mean, that's an idea worth exploring in a way. So now let me actually talk to, let me bring in Mr. Surat Singh, again, a very eminent attorney in the Supreme Court of India. So my question is specifically with respect to some of the procedural issues, like, the interim applications, interim stay, one major complaint about our own legal system is that the proceedings never get completed on time. So generally in the economic analysis of law, we look at the outcome, basically the approaches taken by the judges in their final decision. So Mr. Suraj Singh, can you actually talk about the interlocutory orders, the kind of delay and other kinds of embedded problems within the system that actually lead to loss of economic welfare? Can you touch upon these issues? Are we having some kind of a technical glitch?
Can you hear me?
Yeah, I can hear you.
Yeah. So when people say, oh, in India, cases take so long, 10 years, 15 years, then the question is, why people go to court at all? If it takes that long. And the reason is simple, that great lawyers like my friend Pinky Anand, they get you the interim relief on the very first date. So if you get what you wanted after 10 years on the very first date, you don't mind the delays. And that's why interim application, as I was teaching a course at Jindal University itself, are the critical aspect whether a lawyer is a great one or not. But then, of course, there are consequences. Those who benefit from the interim injunction, as Professor Chatterjee rightly said, they are losers. Those who keep on waiting till they are heard. Now, when we talk about economic dimensions of judicial decision, I totally agree with my predecessor speakers, Pinky and Mr. Chatterjee. However, let's go to the first principles. What is economics? Economics is when there's a choice between competing interests and what is the best use or optimum use of scarce resources. So whenever any intelligent, rational choice is involved, economics is involved. So now question is whether judges are making intelligent decisions, at least where economics is involved, with great respect. Yes and no. Like, for example, let me start with my Harvard Law School experience. During New Deal era in 1930, when President Roosevelt said that, look, we have to change the laws and we have to come out with the new regulations limiting hours of work and others. Supreme Court said no. In Shelter Poltering case, Supreme Court in 1935, American Supreme Court said, we are asked to look at the economic realities of the country, but we have to look at the Constitution and the exact language. The exact language of the Constitution does not allow us to look at the economic facts. And they decided against the Roosevelt administration. And when this entire thinking of packing the court started, then same judges, one judge, Justice Sutherland, changed his attitude because he was about to lose his job. And he said, we cannot shut our eyes to the economic realities. The same law was there, everything was there, but the orientation was changed. Same Supreme Court said, we cannot shut our eyes to the economic realities of the country, and laws should follow what the realities are. And Justice Krishna Iyer in Indian Supreme Court over and again said, law must always follow life. And life means economic realities. Like, for example, and unfortunately, our judges are not oriented like that. Our judges are oriented thinking like a lawyer. We look at the black letter of the law, or what I call text, instead of context. Mr. Chatterjee invited us to look at the context, look at who are the winner, who are losers, how to compensate that. That is really a functional approach. But I'm sorry to say, Indian Supreme Court for first 23 years did not adopt the impact approach at all. Their approach was, look at the text of the law, whether a law is valid or not, what will be the impact, we don't care. Thanks to great lawyer Nani Palkiwala, in bank nationalization case, he said that we have to see not the language of the law, but the real impact on fundamental rights. And then the entire approach of the Supreme Court was changed. Now that orientation is needed, that approach is needed, as Mr. Chatterjee rightly said. For example, I was arguing a case on behalf of power sector. And I said, we can have huge $16 billion investment in India, but the investors require internal rate of return at 16%. Judges at the Economic Electricity Commission said, wait a minute, rate of interest on savings in bank in India is 6%. Why we should give them 16%? They could not understand that risk is involved. In bank, savings bank, no risk is involved. That's why 6% is okay. But if you are inviting foreign investment in India, which was politically very volatile at that moment, then internal rate of return 16% should be there. But there was no appreciation of internal rate of return. So similarly, now we celebrate that Supreme Court intervened in 2G, 3G cases. I'm not a political person, but the allegation was that there was a loss of 1,71,000 crores. But when they were really offered in the auction market, how much profit came? Only 17,000. And the entire thing was stopped. We could have been ahead 5 years, 10 years, had the whole thing in 2013, 11 have been allowed. So, but court was not looking at economics. Court was looking at whether any irregularities were committed or not. So the approach of a typical lawyer and the approach of an economist are two very different things. And as famous economist John Maynard Keynes said, that a person who says I am legal, a person who says I am practical, and I will not look at the economics, is probably a victim of some defunct economist. Because you can't avoid the economics in life. Only thing is either you do in a self-conscious, well-informed manner, or you do it in a kind of intuitive manner, which is sometimes may not be well-informed. So my point is, let our judges be much more well-informed about economic aspect, about cost and benefit, so that they can come out with the best decision. For a better decision, we need law, we need economics, we need understanding of politics. And that's why legal profession, on the one hand, is a learned profession. On the other hand, it's a practical profession. So sound common sense should never leave us when we make judicial decision. And in sound common sense, economic dimension will always be included.
Thank you, Dr. Surat Singh. It is extremely interesting.
I want to add something here.
Please.
Surat, you and I have gone a long way and seen each other, but I have some comments on your statements. As I mentioned, James, in the first instance, my general belief is one, that we have a system in the country and possibly anywhere in the world, including America and all the very forward-thinking judges. When you have legislation in place, that legislation, as Mr. Chatterjee rightly said, that legislation must be considered and made keeping in mind all the stakeholders and consulting them. But once the legislation is made for law and the rule of law, you have to have an objective criteria. You cannot have a common sense or any other kind of approach which is a completely subjective criteria, because that variation is something that we cannot look for. What we can hope to do and what we should do, as we have done, for example, in the ease of doing business. Now we have jumped up several notches and we've come to the 63rd position as far as the country is concerned. And I'm definitely not talking about current COVID times. I'm just talking about the pre-COVID times. So India did pretty well on that respect. India took decisions, very strong decisions for demonetization. India took very strong decisions for imposing GST. So you have one tax, one country principle which prevails, which has alleviated the hardships of doing business. But having said that, the domain of the cost-benefit analysis would remain in the hands of the government and the legislature while doing so. The process of doing so may be improved, that is one aspect, but nothing beyond that. Second, I think what we have to grapple with is ultimately ensuring that India is a friendly destination qua business. Now, when we talk about either trade or we talk about contracts, the question one of enforcement, and two, as Mr. Chatterjee rightly mentioned or Surat mentioned, the question of ensuring doing away with delay. Our principal downfall, as the Whiten case has shown us, has been the delays in the system, which seem to evoke a number of responses from the business community, if not others, to say that India would have difficulties because of the enforceability. Again, to add a caveat to that, we have in the recent past made several discussions and come up with laws. For example, the Commercial Courts Act. For example, amendments in the Arbitration Act. That has been a major discussion that has been happening across board, both by the legislature and by the construction of courts, in ensuring that there is as minimal as possible interference in an arbitral award so that the same can be enforced. We've also had, for example, an executive policy called the Niti Aayog policy, whereby the amounts that were due would be paid pending the resolution of disputes. The fourth aspect, which I think has been flagged by you, the stays. I think that is something which has proved to have its own consequences. So, for example, in the case of stays, what happens is, by and large, there are stays, and I'm saying particularly in the context of infrastructure or construction or contractual obligations, where stays can harm economic benefits to any section of society. Aside from the social, I'm not going there for a moment. So on the economic aspect, the courts have been now time and again emphasizing. In particular, I was in fact a party to the case of the Asian resurfacing, which was decided by the Supreme Court to say that stays should not be extended beyond 6 months. And if stays are extended, the same should be by a reasoned order, which should follow. This was, of course, in the context of a criminal case, but subsequently the Supreme Court has clarified, I believe Justice Kaul has clarified that the stay would be not only for criminal matters, it should not be there for beyond 6 months in criminal matters as much as for civil matters. So the entire perception of the system, as I said, the first part being substantive and the second part being procedural. Yes, we have to minimize the delay so that the matters can get disposed of. According to me, certainty and disposal of matters results in much more satisfaction for the economic coefficient or the social coefficient. So just as an example, I was a member and a party to two of the cases that dealt with two huge construction projects in the city as far as Delhi is concerned. In both cases, the stays were granted for almost 2 years, and we were in fact fighting for the stays to be removed so that the work could go ahead. The projects were midway through. They were suspended during the hearing because of the stays granted by the courts, and the economic cost was phenomenal and ran into thousands of crores, as well as the hardship to the number of people. So I think that analysis is something which we have to definitely work on to ensure that whatever we do, for example, in a suggestion on that aspect, in construction projects, in infrastructure projects, there should be almost no question of stay beyond a very, very limited time, if at all. The idea and the perception should be to dispose of the matter without the legalese that might necessarily come in the way. The reason is that stays can be prolonged because of various reasons which we should avoid. So we need to have a quick, efficient disposal of system for the rule of law to prevail, and that would be economically extremely beneficial to all sections of society.
Absolutely.
Thank you. Thank you, Dr. Pingi. And again, I think this was one point which I wanted to ask Dr. Surath, because stays are actually given based upon the balance of convenience at that particular point in time. And if stays continue for a longer period of time, of course, it can have a significant economic consequence as well. So I think some of these points were already addressed. If you want to touch upon anything beyond that, please go ahead.
I just want to add that I think increasingly courts are becoming very conscious of the fact that stays granted by them in economic or commercial matters would cause hardship. So the current broad trend is definitely to ensure minimal stays. And as I said, for example, the example of Niti Aayog policy in arbitration matters, that you do have the system of the government and the courts collaborating to ensure that the various amounts are not held up and the projects are not held up on account of what is going on. So that consciousness is evident. I mean, I've done few matters, for example, where the courts have refused to grant stays in matters where there is a continuing performance, or there is, for example, a cancellation of contract, or for example, where there is a fresh tender to be invited. In all such matters, the courts are quite cognizant of the fact that this would have an economic loss to the entire situation. In one matter, for example, which was dealing with the highway across Bombay and Goa, as far as infrastructure project was concerned, and the highway was to be constructed, on the ground of the benefit and the cost benefit analysis, the court expedited. See, the court cannot go beyond what is provided. Now, for example, in environment matters, We do have an EIA, Environment Assessment Analysis, which is required as a matter of law, and we have certain criteria which are required to be fulfilled. So what Mr. Chatterjee said, possibly a cost-benefit analysis is something that should go, but that cannot be a factor in normal cases as far as law is concerned in courts. It can be a matter for the legislature, or as he suggested, a think tank to put into perspective what should be taken into account while making. But after having made a law, the same has to proceed on that basis, and that would be the only manner in which it can proceed. Economics being a factor in consideration for the legislation, but the enforcement of it being in principle based upon the letter and the context of law, no doubt, but nothing beyond that.
Okay, Dr. Suraj Singh, do you have anything to add?
Yes. Two points. First of all, as usual, Pinky has given extremely insightful view at the entire picture. And one new development is that now arbitration is turning out extremely helpful in reducing the delays and also in dealing with stays. For example, in recent one project, arbitrator gave a substantial amount to our client and whatever other party wanted so that the customers do not suffer. Now, court would have taken a long time, but arbitrator did it. So I strongly suggest that economic aspect is most relevant in arbitration issues, where judge informally can consider what are the costs and benefits regarding. So that's one thing. Another thing about, as Pinky pointed out, environment. Environment I have done on the side of environmental preservation. But so I have been much more pro-environment. But now I am realizing that in the name of the environment, economic development suffers. For example, I did a case where because of loss of 5 lakhs trees, the entire project of 862 crores was not only stopped, but quashed. Now, since I was on side of the environment, I was quite happy. But today now I realize that had Supreme Court been more sensitive to both environmental preservation as well as economic preservation, economic development, things would have been better. For example, they could have asked the builder to grow more than 5 lakh trees instead of stopping the entire project. They could have charged them with the responsibility that, okay, you are taking away 5 lakh trees, you now do at least 10 lakh trees and court can supervise. So then economic development would have taken place as well as environmental preservation, because I believe nothing is more polluting than poverty. And creating prosperity, what I'd say, shared prosperity, should be declared a fundamental right in that sense. Shared prosperity, it means not just prosperity, because in America there's a lot of prosperity, but the benefits are not going to various sections of society. So I call it shared prosperity should be a goal which Supreme Court should consider along with other goals. And that sensitivity is required, because had the Supreme Court paid attention to economic development, they could have very well said, okay, Dr. Singh, you are saying loss in 5 lakh trees. All right, we order them 10 lakhs, let the project go, and employment for thousands people will continue. So more sensitivity is required towards this striking of balances, taking them together, harmonious interpretation as far as possible. But I totally agree with Pinky in the sense that it is not just common sense in isolation, in vacuum. Common sense in the light of the text. So that's why both text and context are important. Text is a good starting point, but the journey should not, interpretation should not end there. It should look at the context and try to make sense of the text as much as possible. Looking only at the text at the beginning and the end is not the right approach. Purposive approach, why the laws are made for legislature, what purposes they should satisfy, what are the best ways to satisfy those goals, would be a much better approach.
Thank you, Dr. Suraj Singh. Extremely interesting points, that law should not be interpreted in a pure textual manner, but you have to take into account the overall well-being of the society as a purpose of the law itself. That is a very valid point. Let me now turn to the next speaker, Dr. Aruna Sharma, former secretary to the Government of India. ma'am, given your experience of working in the government and also working with some of the regulatory agencies under the government of India, do you think that a cost-benefit analysis can be undertaken before preparing government policies and plans?
Absolutely. I definitely endorse, and I'll elaborate it, because now I've been taking up the case of Goa mining issue, and I'll take the example from there and build up the case. Now, if you look at the Goa mining issue, if you look at it, a state which had the highest per capita income and a state government which never had to borrow money, we have reduced it to a little less than the lower per capita income, as well as the state borrowing nearly 6,000 crores to run their business as a state government. Now, why did it happen? It is just that there are two cases pending in the court. One is when the Goa merged with India, what is commonly known as the Abolished Act, and the second is the interpretation of MMDR Act 2015. And the entire mining operation in Goa, which is 100% export business, because it is there is no issue of environment involved there, and they have got the certificate of best environment internationally of maintaining and doing the mining practices. But in spite of that, a sudden guillotining it because of the two interpretations, where in the erstwhile Portuguese state, they had a lifelong lease available. When the merger happened, it was committed to honor that. The MMDR Act honors it for those like Tata and SAIL, where they have got the lease for a number of years, but have not honored for Goa miners. And suddenly a guillotine has come. Now, what it requires is to do this economic analysis and the court to do a fast harmonization between these two judgments and then come to a resolution. Now, this kind of economic analysis is the need of the day. And with my highlighting this, now Niti Aayog has also constituted a committee to look at the economic loss which has come due to some of the judgments that has happened. Having said that, I will say that the mechanism in which the courts work, it is very important for somebody to bring this to the notice of the court. One could have been through the writings, because in the two parties it did not happen. And in the Goa case, they did have day-to-day hearing. But what is the end result? No judgment has come as date. It has not seen the light of the day. So the perpetuity and what was rightly said, the poverty is setting in. In a country like India, where 65% population is young, and we have to create the employment opportunities, this kind of a delay, which required just to sit down with these two acts along with policymakers and come up with a clear-cut interpretation, impacts adversely in the economics. Another example I'll give you of the Karnataka case, where there was an upper cap kept on the amount that you can mine, iron ore mining you can do. What was the impact? The iron ore was much more expensive in Karnataka than in Chhattisgarh and other states. With the result, the secondary sector who is processing the iron ore to make steel, you had more than 70% plants closed down, employment loss, business loss. Now, these are the kind of impacts why I'm highlighting these two cases to take the matter further. And today, and I'm taking the current live cases. I'm not going into the history of it. So it is very, very important to bring this economic analysis aspect into it. And this also builds it in the Constitution. If you look at Article 41, which ensures the right to work, or if you look at the Fundamental Rights, Article 37, Fundamental Duties of Article 37. Now, if you're looking at the fundamental duties, it is talking of inclusive growth, which they said the shared prosperity. So if you call the inclusive growth, then it is very important that these kind of delay in decisions, which is going to have an adverse impact on the economy of the state, or also the kind of decisions where you have a very, very serious matter, like you now look at the current status of e-commerce issues. Now, e-commerce issues is getting so complicated today because we are coming up with a new direction every time, and then people are rushing to the courts. Now, that is not the way, especially the COVID has proven the importance of e-commerce, and the digital payments which we were able to put in place has been like a boon to give a fillip to this e-commerce kind of a platforms. So therefore, it is very, very important that when we are looking at these kind of things, the economic aspect in the legal frameworks has to make an appearance in these kind of cases, which is going to have a very, very adverse impact into the economy of the state, as well as the economy and earning capabilities of the youth or citizens of that place. The delay in the infrastructure projects, right? The acquisition, the land acquisition. Of course, we have to protect the rights of the people. We have to ensure that proper compensation is being paid. But a delay in road construction, I remember once I've said, it is losing of an opportunity to the citizens there. We are not able to give them a connectivity. A delay in connectivity may just sound that, okay, the road project got delayed by 2 years, 5 years, 10 years. But we are forgetting that whole entire population could not have an easy access to the opportunities across, or to sell their commercial products easily, or to sell their produce easily, or to graduate up into their commercial product. So therefore, especially, I think the beginning point can come up from the point where there are the economic principles involved, the economic hit is involved, to have a look into these cases and put them into a fast track. I totally agree what Pinky Anand said, that while legislating, it is important to get the perspective of all stakeholders. But many a times I am finding, unfortunately, that they are trying to use the shoulder of the Supreme Court to decide the issue, what could have been decided by legislation or by the executive orders. So this also the court should discourage, which causes delays or results into a ping pong kind of battle. And the kind of examples I gave has having an impact into it. If you look at it, there has been some very, very good judgments from the court, which gave a trigger to the economy also. So these kind of judgments should be documented, should be highlighted, and should be used as an exposure to everybody. There was a mention about the forest and the trees being cut. It also needs a lot of education. I also got educated at a later space when I realized that, as long as iron ore is there in the earth, only blade of grass will grow. But the moment you take out the iron ore, you can have a thick jungle there. So 30 years down the line, we can have, or 50 years down the line, we can have a thick jungle there. So this kind of an understanding, even in the environment issue, is very important. When we are moving ahead with this. And I have found that when we brought this to the notice of the court, we were able to get favorable judgments or all comprehensive, holistic judgment. But then question comes is, should it be an auto route or should it be a special effort route? That is where I like to say at this moment of time.
Thank you, Dr. Shamil. I think, again, a fairly useful insight from you. One question which I have, basically you pointed out the issue of delay. And when you really look at delays again and economic loss, one major problem is that with respect to every government policy measure, there has to be some kind of an economic analysis. And if the economic analysis is actually based upon a sound footing, based upon data, clear data and analysis, then those kind of decisions being challenged before the superior courts in the country are fairly slim. What is the real large number of government decisions, economic consequences are getting stuck at the courts? Is it because we are unable to take up this particular line of argument to the court, the kind of analysis which we did before formulating a position? Were they not properly communicated before the court? Why are so many economic decisions being, I think, subject to litigation in India?
Unfortunately, what happens, the court cases, there are two parties. And many a times the government regulatory department becomes a party, not the department which is responsible for push on that industry. So the only methodology available is through an intervention there. And any legislation which comes is to be based on a thorough economic analysis of it, because any policy making is a very, very long-term measures. But many a times you have knee-jerk policies or a crisis management policies, and the adverse impact of it starts emerging at a later date. But whenever it comes, I totally agree that there is a strong need to have an economic analysis of it, and that paper should be put forward to the court at the desk. If you look at the cases, if you look at this common cause judgment case, so there were the minors, and then there was the interpretation of law of the Environment and Forest Department, where they interpreted that instead of Forest Act, you should be penalized under the Mining Act. So what was the resultant because of this? This kind of a thing resulted in such a way that the entire liquidity of the industry disappeared for a nearly 8 to 10 months. The government was very happy because there was an additional amount coming in their exchequer. But then that is not the way when you look at the holistic way of the economy. There need to be a balance when we are working upon it, and then go ahead with it. A similar point I will like to say is that when we talk about Make in India kind of projects, now in the IT, just because the Defense Act and the IT law were not in congruence, the Indian maker was pushed back, and then we were forced to import the goods. Now, these kind of things, now that there is a clarion call of Make in India, there is a capability in this country, and we have to fend for 65% youth. We have to, we have to create 18 million jobs per annum. So with that kind of a challenge, any this of jerk, what is moving smooth, really you see how much back we go into the whole process. So therefore, it is very, very important that any such case coming, maybe, a week can be put forward to come to the economic analysis, and then a quick discussions and the judgment is going to go a long way and weave in this economic thought process into the entire understanding of the judicial judgments which are coming forward. Because otherwise, in this time, when we are 1.3 billion population, a huge market, the world trade is interested in us in the market, but we are interested to be a partner into that trade. And to be a partner into that trade, this kind of missing the bus or delays is having a very, very adverse impact. And I have given few illustrations. I have a long list of such illustrations. But then the point is very, very short, that judiciary is to interpret the legislation, not create a legislation. And while interpreting, the economic analysis has to be a part, at least for consideration, even though it may not be guiding the judgment completely.
Thank you. Thank you, Dr. Sharma. In fact, we have got another 20 minutes, but I would like to have one more round of short questions and then give some time for the audience to ask their own questions. So I'm just taking the point which Dr. Sharma just mentioned right now and asking a very practical question. So we know that a little knowledge is a dangerous thing. So in the context of India, assuming that the courts are going to apply this economic analysis of law or the economic approach of law, I think there are pitfalls as well. Even in the United States, if you look at the practice, only a few circuit courts, the 7th Circuit Court where Richard Posner and Frank Easterbrook, or the 2nd Circuit Board, where Justice Calabresi was there. These are the judges. Very few judges, even in a highly sophisticated legal system like the United States, have been able to apply this kind of an approach to judicial decision making. And we know that in the context of even those countries, traditionally a JD holder will also have a PhD in economics. So the judges will have very sound backing and background in the disciplines of both law and economics. But when it comes to India, assuming that the courts are actually going to apply a law and economic approach, do you think that there will be more problems than good? Because sometimes the judge may apply their own subjective method of economic analysis and come to a particular good, which may have a serious, foundational problems. So let me actually start with in the reverse order, starting with Dr. Sharma.
Right. I'll put it this way, that yes, half knowledge is dangerous, but you have a lot of in-service courses for the judiciary. And there I found generally they are addressed, the judiciary addresses the judiciary, or the lawyer addresses the judiciary or judiciary. So it has become more an in-house kind of an exposure. It is very important to get the sectoral experts to come and talk there as well. And, these kind of cases can be then hair split. So that will make them to be updated as to what is the thinking process or what are the impact process that are emerging under the different places. Then another thing, what you have rightly said, like you have a system of appointing an expert. And who is supposed to guide the bench and the various issues. Now, that expert table or that expert's insight is an opportunity to listen to the different stakeholders and bring out the whole thing in front of the bench. So these two institutional arrangements are already there, which needs to be strengthened by bringing in this thought process in the mind to have an economic impact outlook also, especially because they are the trade judgments, any judgment which is related to commerce or which is going to hit the employment in this country. So these kind of issues at least should be having this kind of an arrangement, and this kind of a breather is going to go a long way to help and strengthen the legislation, correct the legislation as well as take care that the judgments don't become like an impediment to go ahead with.
Okay, thank you. Now let me give the floor to Dr. Surat Singh.
Well, little knowledge is a dangerous thing, but wrong orientation is more dangerous. What is missing is the orientation. If you say that I look at the black letter of the law and I refuse to look at the big picture. See, the difference between Harvard Law School and Harvard Business School is, I was at law school, I took a course at business school. First time I heard the word big picture, which I never heard in 5 years at Harvard Law School. So looking at the big picture so that we can see the interrelationship between things. And there is a problem, which Pinky rightly pointed out, that in our system of separation of power, we say that the policy decisions are to be made by legislature, executive, and only interpretation of the law is given to judiciary. Now, in this separation of power, the idea was power is not abused. But I am sorry, being a Supreme Court advocate of more than 25 years of experience, separation of power has resulted into separation from power. Nobody has the power to do anything. Court will only order, oh, this is wrong, go back. Only procedure is followed. After 10 years, the case goes back, same officer decides. So it's only a procedural formality. Legislature feel we make the law, but judiciary can strike it down. So it's what kind of strange system we have got, where instead of doing justice, and when we say justice, I have personally Vikramaditya in mind, who you may be saying that all power is concentrated, but who could deliver the justice immediately? In India, so much time is wasted whether this is the right forum, whether the case is maintainable or not. Like after 5 years of hearing, court decide, oh, this court does not have the jurisdiction. What kind of thinking is going on? So I go back to Justice Krishna Iyer. In fact, before Justice Krishna Iyer, famous judge of America, Oliver Wendell Holmes, Pinky will approve, our fellow Harvard Law School judge. He said in 1884, life of law is not logic, but experience. I repeat, life of law is not logic, but experience. Felt necessities of time, prevailing dominant interests, prevailing morality have much more to do with law than the language of the law. So we need to look at the what I call big picture rather than black letter of law. Of course, we can start with black letter because legislature have said something, but then we have to make sense. And interpretation requires the keeping in view the integrity of the whole system. What is the best possible interpretation we can give looking at the big picture, which makes sense? And if you look at the big picture, in an environmental case, you look at environmental laws, you look at laws of employment, you look at laws of economic development, you will look impact on other things. So when you look at the big picture, and big picture means looking at the purpose, the goals for which laws are made. You know, Indian Supreme Court, I teach courts, 70 years of Indian Supreme Court. You would be surprised, same language, Pinky, Article 21 has not changed in 1950. In A.K. Gopalan, same language, that nobody shall be deprived of his life or personal liberty except procedure established by law. Just one line was interpreted very differently in 1950 in A.K. Gopalan case, where it
Dr. Surat Singh, sorry to interrupt you because we are running a bit short of time.
So I am concluding. and it was interpreted in Menaka Gandhi in 1978 very differently. Approach was different. So we have to look at the impact rather than only the language of the law. So the context, big picture, and purpose, all these are to be taken into account while giving interpretation, which will include economic interpretation also.
Thank you. So now let me turn the floor to Bipul.
Thank you, James. Let me answer your question by posing another question. Why can't we have economists and other professionals as judges, at least in high courts and Supreme Court? There are examples from around the world. I can give you one example of the most eminent competition economist in the world, Professor Frederick Jenny. He was appointed as a judge in the French Supreme Court. And if we look at some of the judgments which he has given, many of the things which we are discussing today are reflected in his judgments, of course, along with other judges. So can we have that? Is our system going to allow it? I'm sorry to say this. I'm sure there are other examples also. He was there in the French Supreme Court as a judge for, if I remember correctly, for 2 terms. Now, I'm sorry to say this, but is our system going to allow this? To have economists, then you have environmentalists, you have political scientists, sociologists, engineers, doctors, as judges in our system, in high courts and Supreme Court at least? Is it possible? That's the question. Now, I mean, you may call me pessimistic or even anarchist, but if I look at one news item since yesterday evening or today morning, that there is a privilege system has been created or is being created in Delhi for the Supreme Court judges and other judicial officials. I'm ready to face anything by commenting on a matter like this.
Thank you, Bipul. I think, in fact, we're running short of time. So,
James, is it required? I want you to answer it.
No, I will. Let me, as a moderator, let me actually answer at a different time and location. So now let me go to Dr. Pinky Anand for any comments with respect to my question.
I stay staunch on a couple of viewpoints. I think the way separation of powers, which was also highlighted by Sudhir, the way we have to adopt and run our country is that we choose a separation of powers. So you have domains for exercise of powers. What I do think is important is that everybody exercises powers within that domain. Within that domain, there are areas. So let me come to law and justice for a moment. So law and justice itself, only where discretion is possible within the legal system and the law as it is defined, yes, it could be interpreted and should be interpreted, take into account each of the factors that are important. Not only economic analysis and cost and benefit analysis, but there are social analysis, there are economic analysis, there are environmental analysis. But when there is discretion, only then you can allow these factors to prevail into the judgment-making process. But otherwise, to say that within the legal system as it stands, we can actually import into it a cost-benefit analysis, aside from the discretionary areas, I think we would be heading in a way which possibly I would not understand would be conducive to the rule of law. There is a certain purpose. Mr. Chatterjee's suggestions about having appointments of economists and other professionals, so to say, which is prevalent, of course, in the world. And I was surprised. I remember when I was at Harvard myself, and the professors said they were, appointed as judges, or they would give even legal advice. So the whole question of having such system is something that would need to be examined. But the principle of people who are appointed as judges, or who should be appointed as judges, is the fact that they have general knowledge and experience in the world to interpret according to their conscience and according to the law as it stands. And to that extent, I think we should stand with the system. What we do need to deal with is twofold principles, I think, at this point of time, in commercial or economic laws. One, we definitely need to see our international obligations and the enforcement of contracts at the quickest possible time. Two, we do need to weed out delays in the system which are really antithetical to the rule of law.
Thank you. So we have got a few questions actually. So maybe I will direct to the speakers. And
I'll have to excuse myself, James.
No issues actually. So maybe the first question you can answer and then you can exit. The question is, can the judiciary, I mean, while referring to Vedanta, force a private company to function for the public goods, even if it is temporary in nature? So can you address that question?
Even if it is?
Even if it is temporary in nature.
Temporary?
Yeah.
Well, as I said, emergent situation require emergent relief measures. And in the jurisdiction of, let us say, PIL or the concerns of health, there are various possibilities that are there and will be there. I mean, you have, for example, today health camps set up, you have hospitals set up, you're having NGOs, other organizations setting up plans. So yes, everything is possible in those circumstances. And definitely those are extraordinary positions and emergent positions which come within the realm of, let us say, PILs. As I mentioned to you, that's a different domain from the strict letter of the law or the content of law. So yes, it is possible. Whether it should be done or not be done, I leave it to the courts to decide, and then we can see what to comment on.
Thank you. Thank you for your participation. And I've got a follow-up question maybe to other participants.
Thank you.
Thank you. So the question is, please discuss the rehabilitation of affected public due to big projects. How can we make sure that the competing economic and social rights are balanced? So maybe either Dr. Sharma or Bibul, I mean, one of you can answer.
Okay, I'll take this question. There are very sound principles of rehabilitation, and we have examples where rehabilitation has been done very, very well under some of the irrigation projects which has happened. New townships have come up, compensation has been given to them very well, and the new township had better infrastructure, better facility, better access to them. What is important is to observe and a third party to monitor that these rehabilitation process is quick, better, and it improves their quality of life. Another example I'll give you of the Gurgaon. You know, a Gurgaon model where land was acquired, but they also had a share in terms of getting some flats in the housing projects. So in the sense, their income was not one stroke, but they had a multiple strokes of income. So we have this evolution of the rehabilitation package, and I totally agree that if anybody is disturbed, the rehabilitation should not be only at the current cost, but also the futuristic economic losses they will be incurring because of this move. And this calculation of the amount should be given to them and a hand-holding to them so that they can restart their life in the new process. Absolutely no compromise of them, but the entire process has to be quick and to be monitored by a third party.
Thank you, ma'am. So I have a question for Mr. Bibul Chatterjee. The question is, how can we go about training and making sure of a cross-disciplinary approach to judicial in a uniform way?
We have to have a system in place. I understand that some of the law schools, they are trying to have that system in place, and you have to expand it. You have to expand its scale and also its operations. Now, going back to your earlier question, James, if I may answer it or address it, that 3 quick points. First, we have to understand that sustainable development is not just about environment. There has to be a balance between economic, social, and environmental equity while interpreting or while talking about sustainable development. We tend to interpret sustainable development only through the lens of environment. And that is one of the reasons where many of these problems are arising. Secondly, we have to, very briefly, very quickly, we have to look at, talking about this rehabilitation, compensation, things like such issues, we have to look at them dynamically, not in a static manner. At the moment, we are not even looking at them in comparative static manner. Forget about looking at them in dynamic manner. Thirdly, and perhaps most important, we have to understand that the person, for example, let's say you are an environmentalist. You are making certain points, and there are merits, some merits in the points that you are making. I am an economist, I am making certain points. You have to understand that there are some merits in the points that I am making. At the moment, the things have come such a pass, I would say, that I am right always, you are wrong always. And unless as a society we address this, we will keep discussing all these things for the next 20-25 years and we will not be able to arrive at any conclusion. Thank you, and over to you.
Thank you. So now I have got a question for Dr. Surat Singh. The question is, there is a direct correlation between social justice and economic justice, and a very large gap between developed nations and impoverished countries. Does social justice encompass economic justice? A fairly broad question. Can you give a fairly short answer to this?
Well, when we say social justice, it includes everything. Economic aspect is part of that. For example, what kind of a justice a person will have if the person does not have access even to the basic needs? So when we say social justice, of course, generally social justice means no discrimination, but it is bigger than that. And economic justice means at least equal opportunity to compete, equal opportunity to learn, earn. All these things are important, and where Dr. Sharma rightly said inclusive growth, that is the aspect. Growth is yes, but at the same time, make sure that as many participants are there as possible. That's why I use the word shared prosperity. Shared prosperity is something which should be declared fundamental right, as earlier right to property was. Otherwise, as in American Declaration of Independence, life, liberty, and pursuit of happiness. Life is there, liberty is there. Where is pursuit of happiness? Pursuit of happiness will come through right to shared prosperity.
Thank you. I think we don't have too much of time to take further questions, but from this discussion we have I think discussed so many issues, starting from constitutional interpretation to using law and economics approach in trade agreement, in construction and infrastructure matters, and also with respect to social justice and other related matters as well. The one important point is that the economic analysis of law is not a very simple matter. It is a fairly complicated matter. Sometimes it may have to be done in an ex ante manner. Sometimes the judges, while interpreting statutes, will have to apply economic approaches to it. The most important point, I think, that came out from the discussion is that the text of the statute should not be interpreted in a wooden way. That means the text has to be interpreted by imbuing the spirit of the Constitution, and also by looking at the social welfare, or maybe the shared welfare of the citizenry, as an approach to preserving the law itself. The other important point that came out in the discussion is that the economic approach to law cannot be a static matter. It has to be looked at in a very dynamic manner. And we also need to invest heavily in terms of having trained judges and lawyers who can interpret these provisions while at the stage of preparing the statute and also while implementing the statutes. So we had a fairly good spectrum of views coming from the legal community and also from the administrative side. Thank you to everyone for participating in the discussion, and I think give the floor to.
Thank you.
Thank you, James. Thank you very much.
Thank you, everyone.
Thank you, Mr. Sharma. Mr. Sharma, for your valuable comments. Thank you, Dr. Surat Singh, and thank you, Mr. Chatterjee, and of course, I also appreciate Ms. Pinky Anand. This session, of course, threw open many new questions as well, because the delicate balance between what constitutes legal analysis and economic analysis as opposed to administrative analysis are not necessarily in straight jacket frameworks, and there's a lot of overlapping. And when such overlapping is there, what becomes the role of the judiciary is so critical. So I am grateful to each one of you for sharing a more nuanced understanding and appreciation of these issues. Thank you very much for your time. This session is ended, and we will be starting our next session exactly in 10 minutes on the second thematic session of the day, Law and Economics Approach to Corporate Laws and Corporate Debt Restructuring in India. We'll take a short break and we'll see you in 10 minutes. Thank you very much.
Right, thank you.
time out of your very busy schedule to be part of this. Many people have asked us that why are we even doing this now? And our response was that universities have some duties and responsibilities regardless of any situation.
Sir, we are live, sir.
Great. Srijit.
Good morning, everybody. Welcome to the second session of the National Virtual Conference on Economic Dimensions in Judicial Decisions. I'm Srijit SG. I'm the Executive Dean of Jindal Global Law School. As part of the ongoing discussion on the various dimensions and possibilities of the economic analysis of law, our second session is themed Law and Economics Approach to Corporate Laws and Corporate Debt Restructuring in India. Our distinguished panel for the session include Ms. Pratibha Jain, Group General Counsel and Head of the Corporate Affairs, Everstone; Mr. Surendra Kanstia, Practicing Company Secretary and Fellow, Cuts Center for Competition, Investment and Economic Regulation; Professor Dr. Ajay Shah, Research Professor of Business, Jindal Global Business School; Ms. Bhargavi Zaveri, Senior Researcher, Finance Research Group; and as the moderator of the panel, my colleague, Professor Shuchi Sinha, Professor of Legal Practice, Jindal Global Law School. I welcome everybody to the second technical session, and over to you, Professor Shuchi.
Thank you, Professor Srijit. It's my privilege, my pleasure to get this opportunity to be part of this event and to moderate this very distinguished panel. So I'll take this opportunity to start off with a little introduction about the themes of our discussion today, about the background, about the concept of this entire event and this discussion. And then we'll move ahead to this very exciting set of concepts and theories and questions that we'll be putting to the panelists, and then we'll see what they have to say on this. So, just to start our introduction into this entire theme and this concept, the idea behind today's event, what we want to really start off the basis of the discussion is that interface between law and economics in the domain of corporate and commercial laws in India is increasingly becoming more and more complex. That's understandable as we develop our legal and regulatory frameworks. Now, in addition to the existing regulators, you have your Ministry of Corporate Affairs, the Reserve Bank of India, you have Securities and Exchange Board of India, those classical regulators. We are also having new regulators like the Insolvency and Bankruptcy Board of India that are being constituted to meet different needs as they are coming up in our very sort of fast-paced economy for many years now. So similarly, just as we have these new regulators to deal with different forms of commercial disputes, new dispute resolution, grievance addressal forums have also come up in the form of commercial courts, commercial divisions of high courts, and so on. And these have been set up in addition to existing bodies like our debt recovery tribunals. So what has happened is that these bodies are required to function in an environment where specialty or specialized experience or specialized knowledge is actually more of an exception rather than the rule. So and additionally, these independent regulatory agencies also have to work in coordination with government departments, and presumably there would be some political interests and political sort of thoughts that go behind that coordination as well. So, and similarly, if you look at these expert dispute resolution bodies, they do function amidst these civil and existing constitutional courts that are overburdened by this very wide variety and spectrum of civil and criminal matters, right? In all this, in the background of all this, the government also continues to experiment with the jurisdiction of appellate tribunals, and that adds to these multiple layers of regulations, regulators, forums. So there is more and more of uncertainty with all these developments. given that more often than not, the individuals managing all of these bodies would be coming from a pool of generalists, right? They would not necessarily be specialists. They would not necessarily have the domain expertise or the experience. So if we have an expectation from such bodies that they may perhaps break new ground, that may be a little far-fetched. But nevertheless, the operation of such different bodies related to commercial and corporate matters does have the potential to result in the development of divergent jurisprudence, right? And that will always, we have seen it in the past also, it will result in inconsistencies, in ambiguities. And if you look at the situation today, such inconsistencies, particularly if you have sensitive issues like corporate debt restructuring, you have a loan moratorium. Now we have had one going on for some time. And the scope of what the creditors can do, especially in light of this current pandemic situation, can have a very significant economic impact, can have an impact on the financial health of key stakeholders in our entire, economic ecosystem. So if we look at examples, for instance, the Supreme Court, which has allegedly been overstepping into the domain of the executive on various issues, recently it did refuse to interfere with the government and the RBI's decisions relating to moratoriums, for instance, loan moratoriums, and referred to it as a policy matter. But previously, the Supreme Court had prohibited classification of accounts as non-performing owing to the pandemic. So on that occasion, you could say it did step into what could be considered a policy matter. Then Supreme Court also ordered waiver of compound interest of all borrowers availing that loan moratorium. So in the past, RBI and central government have also differed with each other on the policy, for instance, regarding recognition of non-performing assets or the mechanisms to deal with them. And then if we think back, the Supreme Court had actually struck down a circular issued by the RBI, so that February 12 circular, for instance, on this very issue. So in light of all this, it's a very sort of constant developments going on. In light of all this, it's become very relevant to adopt a very coherent approach to law and economics in corporate and commercial matters to ensure that the interests of stakeholders are taken into account, so that there are appropriate capacities built into these various forums and these various regulatory systems to deal with these complex matters where economics and law are not necessarily separate. And we need this capacity to look at them in a holistic way, perhaps, or to be able to look at the interactions between these fields as well. So that was just a little, a background from my end, just to bring us into the far more exciting sort of next point in our event today. And that is to really get some insights from our very distinguished panel to get their thoughts, to get their response on some of these matters. So I'm going to now move ahead and just put a few questions before our distinguished panel. I would request, as we come to you and we ask you a question, to try and have a nice detailed kind of discussion on it, and we'll try and keep each answer maybe between 3 and 4 minutes to the extent possible, of course. So let us now move ahead, and I will start by putting my first question to Ms. Pratibha Jain, right? So Ms. Pratibha Jain, I had, so the question that I really wanted to bring up to start off our discussion, and it's a slightly sort of a broad thematic question. It's a little bit of practicality and maybe the philosophy of law and economics coming in here. So if we think about it, a very important, a very key prerequisite to an economic analysis of law is to allow discretion, right? That opportunity to regulators, to quasi-judicial authorities to have that discretion to analyze. But, do you feel that such authorities have been able to use their discretion appropriately, particularly in commercial matters? We would love to, hear your thoughts on this, Ms. Pratibha Jain.
Thank you, Professor Suchi. Actually, I am a financial markets lawyer. I'm not an academic, so I'm going to leave it to the academics to tell us, what the solutions are. What I will like to raise is the issues that the financial investors, and that's the area where I mostly work in, getting foreign investment into the country. The concern that it is increasingly becoming a problem in attracting foreign investors is the uncertainty in law. So there was a lot of talk about, retrospective amendments to regulations, which, the current government then said, as a policy that they will not make retrospective amendments. However, that is just one aspect of it. I think the uncertainty, and that uncertainty is the one word underlying, your brief of what you've just talked about in the Indian context, which is you don't know which authority or which court is going to interpret which regulation in what manner. It's as simple as that. So there is no certainty of law currently. And there's no underlying policy as investors that we can decipher in which way either ultimately the central government will look at it or the courts will look at it, right? So you have various financial regulators. It's a regulator's prerogative to have discretion. You cannot function an economy without giving some delegated legislation power to the regulators and to a certain extent, the quasi-judicial authorities, whether I put CCI in that bucket. However, that discretion has to be exercised. Let me quote Cuts paper itself. They say there are three justifications for regulatory intervention: prevention of market failure, restriction or removal of anti-competitive practices, and promotion of public interest. Now, when there is an discretion that is applied by a regulator in terms of, let's say, prevention of market failures, it'll be a broad policy like limitation. Today, we have a limitation in India on what the overall limit of corporate bonds that the private sector can raise. Above that, you have to go back to the RBI and get fresh limits. That's an overall market issue, and that's a policy discussion. And we don't we can argue on whether the market should be open, more open, not. But that is, that falls in that bucket. Similarly, anti-competitive practices, both from a regulatory perspective, though, again, the private sector would prefer that if you've got a body like CCI and appellate bodies above it, you leave it to them, right? You've made the law for anti-competitive actions and you let that particular regulator to deal with it. But you still, sometimes when you have an amendment in foreign investment laws which says, okay, it's to ensure that there is a level playing field among players, you can still digest it. The problem comes, everything else falls in the bucket of public interest. And that overreach is so significant that in the private sector now, with the foreign investors, it's called the India risk. Just the uncertainty of how we have a law today, but how, just yesterday I was on a call where we were trying to explain to a real estate investor who's looking to make a huge investment, talk about, we don't know how the courts are going to look at home buyers tomorrow as creditors. So we said, no, that issue is done with, yes, they intervened and allowed them to be financial creditors, the courts, but then, there's a 10% rule. the investors had a very good question. How do you know that the courts will not again tomorrow take this project and say public interest and interpret again in a different manner what the policy in this regard is? So that those kind of interventions, whether at a regulatory level or at the court level, is what is really killing business for now.
Correct.
I'll stop there for now.
Yeah, no, I think, the point is actually very well taken. The points that you were making it's a good point. That yes, the whole idea of having those regulators is, of course, that they need to have that discretion. But then there is a requirement, if we want that development of the legal framework to be in a way that genuinely encourages that investment or encourages that growth, that it needs to be perhaps consistent with economic principles a bit more. And, as you mentioned, that very often we sort of circle back to this point of public interest or what seems to be perhaps equitable to the regulator in that particular circumstance, as you mentioned, the home buyers being financial creditors, and we'll come to that in a later question. We do have, we want to come back to that point, so we'll be coming back to that. So point very well taken there. So maybe perhaps, as you mentioned, we academics look at this, we analyze this in various ways as well. Perhaps Dr. Ajay Shah, could I come to you to expand on this a little further?
So everything that Pratibha said resonates with how I think about it, with just one difference. This is a problem faced not just by foreign investors, but by all investors. Okay? So everybody doing business in India today faces the difficulties of an Indian state that intervenes in business activities in many questionable ways. With the rise of an administrative state where legislative and judicial functions are increasingly being given to officials who ultimately obey the present political leadership, whatever it be. Elections come, elections go. Ultimately, officials have tremendous power, and oftentimes legislative and judicial functions are being concentrated with officials. And the third problem, which is a certain erosion of the rule of law. So different people are treated differently, and that generates very high uncertainty. So this is the big question that we face in India today, that how do we become a mature market economy is about addressing these three problems, about creating laws and norms through which the state will retreat from excessive intervention in the country, and restoration of the legislature, the executive, and the judiciary as co-equal branches of government with well-established roles and functions, and great emphasis on the rule of law, of equal treatment, of fair play in how the laws are enforced and implemented against different people. This is a singular question that we face in India today. Private investment in India peaked in 2011. We've been on a decline for 10 years now, and it is not possible to be a high growth country. It is not possible to create jobs without having buoyant private investment. So this is the most important question of the age that all of us should put our minds to.
Okay, thank you, Dr. Shah. I think that would resonate actually with all of us, at this event who have been following the economy as well. That to get to that mature level as an economy, and we have been a high growth economy in the past. We have really sort of been a cynosure really for global economists to look at because of our fast-paced growth for quite some time. But then independent of that, we also need to turn into perhaps a mature economy and a mature, have those mature practices, not just in the market, but with the regulators as well. And perhaps that's the next step to be really focusing on. So thank you so much, Ms. Pratibha Jain and Dr. Shah, for your inputs on this one. And I think from this very, perhaps it's a slightly generalist and a holistic question, let's move to maybe a little, let's explore a few more specific aspects of this entire, issue. And I'm going to move, and I'm going to come to Ms. Bhargavi Zaveri with my next question. And this question basically relates to this point that has been observed by many observers and commentators, that in the past we have witnessed what you could say are inconsistent approaches to corporate debt restructuring, right? And corporate debt restructuring has really been top of mind for a while now, given the problems, of non-performing assets, of bad debts, willful defaulters, and so forth. And the judiciary has, in fact, invalidated some regulatory notifications. And at the same time, it appears to be hesitant to interfere in other matters, citing policy decisions. So does this create inconsistency and ambiguity with respect to corporate and commercial issues in India? What's your view, Ms. Bhargavi Zaveri?
Thanks, Professor Shuchi. Pleasure to be here. I think the timing of this question is fantastic. It would have been as good a question on any other day, but particularly now, as we are just emerging from the lockdown and, economic activity has started resuming, and people are now wondering to what extent they can honor their debt obligations versus not, now that the IBC is back in operation, right? So I was thinking we could think about the judicial intervention in debt contract enforcement a little more holistically than just thinking about corporate debt restructuring or the CDR scheme or something like that, right? There are two aspects of intervention that I really wanted to speak about. One is where the judiciary intervenes in contract enforcement, and the second is when the judiciary intervenes in, regulatory actions with respect to corporate debt restructuring. So let's start with the first one. So I thought 2020 was a fantastic experiment in a way. I don't mean to sound insensitive, but what I'm trying to say is all courts generally enforce contracts in the good times. In the good times, I mean, frankly, contract enforcement doesn't even come up much because most people actually like resolving disputes outside the court, and they really come to court when push comes to shove. 2020 was the year where push did come to shove, and we saw a lot of debt contracts being litigated before the courts. Three examples come to mind. Okay, so in the beginning of 2020, March 2020 exactly, there was a case which came up before the court which involved pledge of shares. And if you remember, there was a sharp drop when the lockdown was imposed. There was a sharp drop in the valuation of all asset classes that were being traded in India. Therefore, the loans which actually were secured using equity shares were most precariously located because the value of those equity shares were falling. So the lenders wanted to invoke the pledge as per their contract terms. So one such case was the future retail case, where future retail shares were pledged, I think, to a particular lender. And the debenture trustee said, look, my bondholders are right now sitting on the, they're possibly staring at a default because the valuation of the security has dropped drastically, almost by 60%. And they came to the Bombay High Court, and they, the promoter, the borrower actually sought an order from the Bombay High Court saying, please do not allow the lender to invoke pledge of shares because actually the valuation of shares has dropped and this is not fair to me. This is where the court's propensity to intervene in contract enforcement was truly tested, right? And what we saw is that in that particular case, the Bombay High Court actually ordered the debenture trustee from not invoking the pledge of shares. This was repeated by the Delhi High Court in a couple of other cases where pledge of shares of infrastructure companies or real estate companies where pledge of shares was actually stopped by the court, where the court actively intervened and said, no, it's a bad time right now. It will be unfair to the borrower if you actually invoke the pledge of shares. as per the contract terms because the value of the shares had depleted drastically. And we saw this in almost 4 to 5 cases where the judiciary actively stepped in and practically rewrote the terms of the contract. Now note, in at least 3 of these cases, the default was committed in January before even a single case of COVID was detected in the country. So, it's hard to imagine when the court will intervene in a contract enforcement case versus not. Like Pratibha mentioned in the beginning, this is the uncertainty element, right? One is the uncertainty element whether the regulator will seek to regulate something, in what proportion of regulation will be applied. And the second is the court interpretation of contracts itself, where court actually ignores the terms of the contract and says, I don't care what your contract says, I'm going to actually indulge the borrower a bit. All right, so that is one part of it. And I wonder what kind of precedent that sets, because we equally saw examples where after a point, I think after April or May, the court stopped intervening. And the court said, no, but this is RBI's policy. The RBI has given you all a moratorium and we will not intervene and we will not indulge the borrower anymore. So how do parties to the contract know that when the time comes to actually use the security that they have built in for themselves in the contracts, will that security be invoked or not, right? So that's one thing. Then coming to the extent of judicial intervention in executive policy, in matters of executive policy, which is what I think your question is more directly related to. And there, like you rightly mentioned in the beginning, of course, the most canonical case is the compound interest waiver, right? So just to take it sequentially, what happened? There was a moratorium that RBI imposed and announced and said that nobody will be declared a defaulter or if they default on their loans for a certain period, which was extended from, I think, 3 to 6 months. Okay. Then there was a public interest litigation filed before the Supreme Court, and where the relief that was sought was that actually all interest should be waived and people shouldn't be asked to pay interest that accumulates during these 6 months. Eventually, the scope of the waiver was restricted to just compound interest. The Supreme Court went one step beyond, right, and said that, okay, not only what did the Supreme Court do? I think they constituted a committee comprising of central government nominees and I think RBI nominees. I'm not too sure what that committee looked like, but the committee recommended that, look, the central government will absorb the loss for all compound interest that is waived for small ticket size loans. Okay, but beyond that, we will not be able to absorb the loss and people will have to pay as per their loan terms. The court actually rejected that suggestion and said, no, we are going to ask for a waiver of all compound interest, irrespective of the size of the loan. So the extent of loss to be absorbed by the executive, because the central government will have to pay the banks or recapitalize the banks, went up much more, right? So you see those kind of interventions. So there's contract enforcement, and then there is intervention with executive policy. Now, I'm sure this is not a problem that is peculiar to India, right? Everywhere there are regulators, and some of them are financial sector regulators, and all of them enjoy some sort of discretion. And I was wondering, how do courts really interface in other countries which have much more matured judicial systems and more mature regulators? And, if you look at the academic literature here, especially, the legal literature, you'll find that actually post-2008, courts have started intervening in judicial decisions, in the regulatory decisions much more than what they used to do in pre-2008. So if you look at the United States, at least in the last 2 years, you will see at least 3 big decisions that were taken by a financial sector regulator in the United States, where the court has overturned in or stepped in. But on what grounds? On grounds of due process, on grounds of proportionality, on grounds of, whether a consultation process was done or a cost-benefit analysis was done. Those are the grounds on which those courts have intervened with regulatory decisions. And that is precisely because, like you rightly mentioned, it's inevitable that regulators will exercise discretion. What can you control when this discretion is exercised? You can control the boundaries within which it is exercised. You can measure whether the discretion was proportionate, disproportionate, etc. So one example comes to mind. I'll just spend 2 more minutes on this because then we go back to India, is the MetLife case. So there was this large financial institution, which was declared as a systemically important financial institution in the United States, which means that it's subjected to much more regulatory scrutiny. And the court actually overturned that decision, although it was a purely regulatory decision, on the ground that actually you didn't meet due process norms. Now, in coming back to India, it is true that even Indian courts have started intervening in regulatory decisions on grounds of proportionality. So we've seen some fantastic examples last year itself, right? So if you remember the cryptocurrency related prohibition of RBI, where the Supreme Court stuck it down only on the ground of proportionality, right? Similarly, if you, the Feb 12 circular that you mentioned, that was struck down, I think, on the grounds of excessive delegation of power, right? So those are due process related grounds. And there again, if you just see sort of the history, you find that courts are much more open to intervening with non-financial sector regulators' decisions than with financial sector regulators' decisions. So for example, a court has intervened much more with a TRAI or ERA's decision than with an RBI or SEBI's decision. So if you remember the call drop circular, okay, TRAI had issued a circular saying penalizing telecom companies for call drops. And the court actually said, you haven't done appropriate consultation, and it struck it down. Now, can you imagine a SEBI circular being struck down or an RBI circular being struck down on the ground that there was not enough consultation? I really doubt that would happen. So I think when we talk about judicial intervention, we should, segment it into sort of three. I can think of three sections. There may be more. I may have missed something. One is contract enforcement, and there we find that courts have inconsistently enforced or chosen not to enforce contracts. Second is intervention with executive policy, such as, what does the central government choose to waive versus not, your compound interest waiver. And the third is intervention with regulatory decisions on due process grounds. We have to, once we, compartmentalize these three kinds of judicial interventions, a useful way of then thinking what Indian courts do versus not.
So thank you so much, Ms. Bhargavi Zaveri. And really, I think that was a very, that really gives what you just said. I think that really helps us to look at this in a much more focused way, I would say, and particularly looking at the sort of the way we can differentiate between those interventions on due process, which I think that is what you would expect in a mature market regulator or in a mature markets judiciary, that yes, where there is a due process issue, then that perhaps merits an intervention because there is a consistency in how that would be applied. Whereas on the other two categories, I would say that is where you are wondering in each case how that is going to go, because is it just going to be something that is decided on the issue of, let's say, the public interest or what would be equitable or what seems fair to the parties, or is it going to be on the basis of the policy that is being developed due to the economic developments in the market? So what is it going to be? And I think that is where probably we are looking for a little more consistent growth in terms of intervention being on grounds of process or being on grounds of what the regulation is providing. And that's what the judiciary should be there for, probably, to just look at it that way. So that was very, very interesting. And thank you so much for your inputs there. I was just wondering, Ms. Pratibha Jain, would you have anything to add on that point, on the points that Ms. Bhargavi was speaking about?
I think, all the points she made are very valid. All I'll say is, the reason you don't see that many challenges to RBI SEBI circular is SEBI has its own appellate body, and SAT does tend to overrule a lot of SEBI decisions. So they don't come that much to courts. And RBI, the private sector is just scared of challenging them. So that is purely the reason. It's not that, there is the courts give any more leeway, I think, to the financial regulators. The courts that ways are not very discriminatory between the regulators, at least in India. I think also I do recognize the courts and the need in India for the court to intervene in terms of either due process, proportionality, or even arbitrariness, right? Arbitrariness is also very important. Actually, the CDR circular that was overruled by the Supreme Court was actually something that we all were very happy about. So there is a need for that. I think the recognition, especially what the difference between looking at a policy and deciding whether or not the court should intervene is very different from looking at contracts between two parties and overwriting that given the existing laws. If I have made a contract within existing laws of the country, and then for court to intervene on the basis of public interest, it's not really public interest, it's private interest, right? For example, the example in the previous case was on future. That's a private interest. There's no public interest really there. I think the courts need to really ensure that they distinguish between intervening on policy matters, whereas upholding laws with relation to contracts that have been entered into. I'll stop with that.
Correct. Yeah, no, I absolutely.
Just give me 1 minute, right? So it is absolutely true that there is a Securities Appellate Tribunal, which actually maybe, brings in much more accountability at SEBI than what you would see at RBI, for example. But I want to say one thing. So if you remember in 2016, there was a judgment of the Supreme Court. I think it was a call drop circular judgment itself, where the question was that is a regulator supposed to conduct public consultation? Is it required to conduct public consultation by law? And can a circular be struck down simply because the public consultation conducted was not adequate? And, I think it was Rohinton Nariman's judgment. And he said, look, normally a regulator is not required to conduct public consultation unless the statutory mandate requires it to do it. So unless its governing law requires it to do it. Now, incidentally, the TRI Act and the ERA Act actually require TRI and ERA to conduct a public consultation before they issue regulations. Now, we don't find that equivalent in a SEBI or forget banking regulation, or even in a PSS Act. But that tells me that actually, if that mandate is missing, then it is, regulators like the financial sector regulators, which don't have this mandate inbuilt into the law, will likely not be questioned. So that was just a limited point. It is possible that previously they have been questioned and, maybe we're not taking into account those judgments. But it seems like at least the precedent suggests that, a TRI or an ERA regulation will be held to much more higher standards of scrutiny before the courts than an RBI or SEBI regulation. So just a small point there.
No, very interesting point as well. And I think that's actually, it's something to perhaps in future also just take note of when we are looking at these kinds of interventions and we are seeing how the court steps in. So very interesting point that, certain regulators are subject to that requirement, let's say for public consultation, whereas others are not. And that also factored into that judicial intervention that you were mentioning. And precisely the point that actually, if we look at SEBI orders, so many of them are overturned at the level of their own appellate tribunal. And I completely agree that in terms of RBI and private sector, very few people would really want to be challenging RBI in particular on its decisions. And, this is something that I can speak to from my background in corporate law. And I spent so many years in a corporate law firm that this was something that all our clients were like, okay, even if there is a question here, let's just accept it and move on. And let's not try and bring any kind of questions about what the RBI is saying. If at all, we wanted to even question it, would be done very gently through some kind of a submission made or something like that. But when it came to challenging the RBI, yes, I completely am with you there, that would be something the private sector certainly would not want to get into. So excellent, really wonderful pointers here. So I'm just going to move to the next question. Sorry, yes, please, Dr. Ajay Shah, you had something to add here. Sorry, you're on mute, Dr. Shah.
This is a great discussion. I just want to broaden the scope of what we are doing. I feel that at the foundations, we have some deep difficulties in the way regulators have been established in India. So I find it very concerning when Bhargavi feels that the standard of due procedure for the creation of subordinated legislation at ERA and TRI is superior to the other regulators in India. I mean, as the people of India, we need to have high quality regulations in all areas. And when checks and balances are lacking, we will get bad quality regulations. Okay. Similarly, it is extremely concerning that people feel afraid to question an RBI order while people are more comfortable questioning a SEBI order. This raises basic questions about rule of law. It is an absolute foundation of liberal democracy that a private person should be comfortable and have efficacious review of orders that are considered wrong or unjust or in any fashion inadequate. It is a very dangerous place for liberal democracy in India if we are afraid to challenge a regulator. So I feel we've got to go to the foundations. That is, the parliamentary law should establish procedures for the legislative and executive functions of the regulators. Every single section that gives a power to a regulator to write regulations needs to clearly articulate what those regulations have to be about and show the balancing considerations where the regulator is expected to find a middle road. There should be no sweeping powers to make regulations. There needs to be due process on how investigations and prosecutions are done. There needs to be a proper hearing where separation of powers, which is in the basic structure of the Constitution, needs to be fully adhered to, and there needs to be an efficacious process for appeal. These are basic foundations of regulation, of economics in a mature market economy. And we in India have a problem on all these issues.
Fair enough, well said. And in fact, sometimes I wonder whether the roots of all this perhaps somewhere lie that originally our economy was, perhaps organized on more socialistic lines, and the let's just call it a philosophical position of the regulator was more about being a little bit paternalistic and looking at the perhaps the interests of what they considered were the ordinary people or the economy as a whole, rather than perhaps the integrity of a particular contract or anything like that. And if we look at the rules or the regulation, like regulatory regimes in the past, which were a great deal more restrictive, I think that's where this whole attitude also of not questioning the regulator or the regulator being seen as a sort of a very larger than life presence on that ecosystem that they are regulating.
There are two phrases that are exactly what you were saying just now. One element is central planning, that in the olden days, the government was supposed to tell all of us what to do. And the second is the whole thought of being subjects and not citizens. When you are a subject, you just accept some maibap, somebody tells you what to do and you obey. But in a liberal democracy, we are citizens and not subjects. And the government is not some absolute feudal power, and obeying the government is not the way to organize a market economy.
Fair, which hopefully there's going to be more movement hopefully in that direction, and our role as people as stakeholders is perhaps to nudge that along from whatever we can do at our end as well. So that's a neat sort of segue into our next question, which in fact, Dr. Ajay Shah, I'm going to come to you for this. So, this is more of this is moving more away from, the approach or the attitude of the regulators or the judicial authorities, more towards another kind of a challenge, right? Which is that there, while we may come up with, good path-breaking ideas on perhaps cutting the clutter in the courts or having specialized fora for different kinds of disputes, but several of our quasi-judicial authorities, like the debt recovery tribunals, as an example, they have faced severe, I would say, infrastructure constraints, capacity constraints, and therefore there have been a lot of feedback that they are unable to resolve disputes within the desired timeframes, which was exactly at the core of why they were set up. So would you say with this backdrop that these kinds of tribunals are being able to serve their purpose, Dr. Jisha?
You're on mute.
Sorry, you're on mute, Dr. Shah.
Whenever there's a discussion about the judiciary in India, which includes courts, tribunals, and the quasi-judicial hearings that take place inside an organization like SEBI, we should distinguish between two rooms in the house. One is foundations of how a hearing is conducted and questions like judicial independence and so on. And the second is the mundane aspects of operational procedure, of just process engineering, of how documents are handled, about how scheduling is done, and so on. My colleagues and I have actually worked extensively on the second problem, which is about procedures, processes, automation, improved process engineering for the courts. And there are two key elements of intuition that we would like to bring to the table. The first intuition is the intuition of a heart surgeon. Okay, so imagine a judge is like a master craftsman. A judge is like a heart surgeon. Okay, so now how does a heart surgeon work? There's an entire support staff which does an array of the preparatory work on a patient. The patient is made ready, the anesthesia is done, an electric saw is applied to open the chest cavity of the patient. And then at the very last minute, the master craftsman comes in 15 minutes, does her work, and steps away from the operating theater. And then again, the support staff does everything else. So that's the first point, that judges should do the high intellectual work of judging. And there's a whole bunch of process overhead that at present is being placed upon judges, which is not efficient. And please note that one heart surgeon finishes one heart surgery within one session, that we don't fragment it across many sessions, and we don't have many different people coming and doing pieces of the same work. So it just improves the quality if there is focus, that if the entire 4 hours on one case took place as 2 hours on Monday and 2 hours on Tuesday, heard by exactly one bench, you'd get much better outcomes because the mind would focus and it is more feasible for people to actually understand the case. Instead of it being dribbled out as 20 hearings where there are different people who are hearing elements of the case. The second big idea in this field is TCS Passport Seva. Okay, all of us have seen the miracle of quality that took place when the operational process engineering of passport applications and passport handling was shifted from mainline government bureaucracy to a dedicated process engineering organization. So civil servants and only civil servants make the decision about whether a person gets a passport or not. But a lot of the processing work is being done by a computer system, being done by a private player. So my colleagues and I have pulled all this together into a proposal that we call ICTS, the Indian Courts and Tribunals Service, which we think of as a process engineering organization that will build and operate the machinery of courts at a high level of efficiency. As an aside, this is the kind of arrangement which is found in most advanced countries, that judges don't do court management, lawyers don't have skills on process engineering. It's a process engineer that knows how to do these things. It's a different skill, and this is the kind of work we need in India also.
Absolutely. I mean, I think that is something which is possibly, it flies a little under the radar, I would say, this kind of problem. The larger sort of, other issues that we were discussing about intervention and, how the court is approaching something or the regulator, that is still being noticed, I feel, a bit more than, and it's really a wonderful input to hear from you that you have done that work on it. Because exactly as you mentioned, that if you look at, for instance, a UK, where you have Her Majesty's Judicial Services, but there's a separate set of services whose job is to do that logistical infrastructure admin work, so that the judiciary is not doing that, right? And I think that's exactly the point that you mentioned. And over and above, of course, the issue of just the whether the courts have the capacity, whether physical infrastructure is there. Probably it's a twofold issue, that as we have developed these specialized fora, side by side, this is something that perhaps has kind of got lost as a really critical priority, and that needs to be addressed as well if we are really going to increase the efficiency, because exactly as we were saying, the timeframes are not being met, and it's not just a factor that there is any kind of inefficiency or unwillingness. It could be precisely this, that judges are also dealing with, or the officials who should be giving orders or hearing the matter are also then looking at the allotment of the matters, or when the timings of the hearings will be, and so forth. So that is definitely something to consider, I think, very seriously moving forward. So that was a great input to get from you. So such a it's wonderful that we are having this very, very vibrant discussion. We do have some more very interesting questions, and time is not that much. I think we've had such a vibrant and dynamic discussion that now there are a couple more very interesting questions that I did want to put to the panel before we take open questions, from everybody gathered here. So I'm going to move on to my next question. Okay, and I'm going to come to Mr. Satyendra Kastia, where, I want to look at now a different aspect, right? Which is that, look, a lot of all of these initiatives are really aimed at improving our ease of business standing and attracting more business into India, right? And so while on one hand, the government is pursuing ease of business, ease of doing business, they're even looking at decriminalization of offenses. If you recollect that proposal that came from the government, that statement of intent that really came from the government about decriminalizing offenses under corporate law. But if you look at it on the other hand, it's a very contrary kind of a position. They are actually looking at introducing new provisions which make directors and senior officers personally liable for non-compliance with regulatory provisions. So do you feel this could have a chilling effect on the innovation, on the and that it could have an economic impact, that there are some quite avoidable compliance costs on particularly, I would say, the startup ecosystem of the country? So Mr. Kastia, we'd love to hear your thoughts on this.
Thank you. Before I respond to your query, a footnote to what Dr. Ajay Shah has said. We have a very interesting order by the Supreme Court under the Consumer Protection Act, where we have the district commissions and the state commissions. A petition was filed by a citizen saying that there is not adequate infrastructure available to these forums. And again, the capacity and the strength of the benches is not according to the desired level. So I will just read a sentence from the Supreme Court order where they have directed all the state governments. It said, issue notices to all the respondents to show as to how many posts are occupied, how many are vacant, and what is the nature of infrastructure which has been made available as consumer rights are important rights, and non-manning of posts and inadequate infrastructure would deprive the citizens of the redressal of grievances. Now, if this kind of order has been passed by the Supreme Court, converting a petition into a suo motu application, I'm sure this model can be followed with reference to other regulatory or quasi-judicial bodies also, because it's an open secret that we have so many vacancies in practically all possible tribunals and all. Coming to your specific query about the ease of doing business and the decriminalization. By the way, this word ease of doing business has now been added by another phrase, ease of living. And ease of living is mainly for the directors of the company, which again happens to be a part of your second query. So they are basically interrelated. To give you a background, actually, this word decriminalization in the corporate sector came into from Company Law Committee report, which was submitted to the Ministry of Corporate Affairs in the year 2019. And the ministry took quick action, immediately prepared a bill, presented it to the parliament. It was approved in the September 2020, and it has been notified also. Now, pursuant to this bill, the Companies Act now has been amended, and a large number of provisions have been shifted from fine category to the penalty category. And what happens is, when the fine is sought to be imposed for contravention of a particular provision, the matter has to be determined by the court, and then sometimes the imprisonment may also follow. Whereas wherever the penalty has been prescribed, the matter is generally examined and determined by the in-house adjudication mechanism of the Ministry of Corporate Affairs. Of course, you are talking about the corporate law in general, but the moment we talk of corporate law, the first act which comes to our mind is the Companies Act, which is the most important law for a company. Of course, in addition thereto, there are important laws like security laws and tax laws and industrial laws and labor laws and all. But Companies Act is supposed to be the prime act. And I just took a statistics today morning. As on 28th Feb, we were having about 13,29,000 companies. And all these companies are supposed to comply with this huge voluminous act, which is known as the Companies Act 2013. To give you an idea about this law, in this act, we have 500 plus sections. That is a small law. But in this act, we have a very strange term called as may be prescribed. And this term appears in almost 65% of the sections. Now, wherever you have this term as may be prescribed, you have to refer to the relevant rules. We have about 41 rules prescribed and notified under the Companies Act. I'm talking of just one act. And these rules have been amended 219 times in last 5 years. Now, if you have to comply with all these rules which have been amended so many times, and in addition thereto, we have about 170 notifications, about 170 circulars, it becomes a huge body. And as Pratibha as well as Bhargavi suggested, there is an uncertainty about the volume, about the interpretation. When you have such a long document which needs to be complied with, the contraventions are bound to happen. And for that, for the process-related contravention, if the directors are held accountable, it will make the life miserable. And that's why they have come out with this concept of decriminalization based on the report from the Company Law Committee. And practically now, 85 to 90% offenses under the Companies Act have been decriminalized, resulting into imposition of just penalty, which also we gather from the media report that would be a faceless exercise. And if it happens to be a faceless, then again, the another fear which Bhargavi advised with reference to RBI, that you are afraid of objecting to certain issues. If the faceless mechanism starts, then again, the fear factor would be gone, and perhaps the life would be more miserable. So yes, we are moving from ease of doing to ease of living. But this large volume is definitely creating a problem. And because of this large volume, again, you cannot have one size fits all approach. You have 13,29,000 companies. So, and at times, the time comes when all these companies are supposed to file their documents within a period of 30 days. The whole system practically crashes. The authorities have definitely not taken adequate care of this. And the moment you fail, the penalty starts, which then result into huge fines and all. So there is still a scope for improvement so far as the infrastructure with reference to the Ministry of Corporate Affairs is concerned. Of course, they have announced MCA 03, the third version of changes which are to be brought into MCA system in very shortly. That perhaps would make the things still simpler. Yes.
Correct. Thank you so much, Mr. Satyan Kastia, for your input on the previous query as well. That was very, very interesting to see that point that you made, that if it could be done for one kind of fora, it can certainly be done for the other as well. And yes, I mean, taking into account what you just said in terms of decriminalization and whether that is what we have done so far, is that going to be enough? Because, you know, the statement of reason that the government, you know, came out with, rather the Ministry of Finance, you know, the Department of Financial Services, Ministry of Finance, you know, in mid 2020 had come out with this statement of reason where there were some 19 acts where they wanted to decriminalize. And this is, of course, in many ways a very welcome move, although there has been some, for instance, pushback even on decriminalizing certain offences like Section 138 under Negotiable Instruments Act for the bouncing of checks, where many traders are worried about it. So it's not so simple as well, perhaps even from the government side, to really get the entire raft of decriminalization done or accepted. You know, they, you know, in a democracy, perhaps they're also having to listen to various sides to this question, and therefore whether it is going far enough in terms of really decriminalizing these kinds of compliance matters or financial matters. It may be a complex question in that case, right? That whether enough has been done, that may be a complex question. So as you mentioned, under Companies Act itself, there are so many compliances, or if you, you know, despite this decriminalization initiative that is being taken, if you look at Factories Act or PF Act, or, you know, even sometimes insolvency resolution professionals might find themselves in jail, like we had this case in Uttar Pradesh with JP's resolution professional because of some crash barriers that were not properly installed. So there is some work to be done on it, but probably this is a welcome sort of move in the right direction to get that sort of encouragement without fear. You know, as you said, it's living for the directors and officers as well. So perhaps that's the right step. So thank you so much for that input. In fact, as I mentioned, we do have some really interesting aspects to explore yet, and we've had such wonderful input. So I'm just going to move to the next question for now, because we do have a few really good questions still to come up. And I'm going to move to Ms. Pratibha Jain. And the next question that I want to put to you, it's you know, it's now we're just going to touch upon this point of you know, a difference, let's say, in the insolvency regime, or let's say a difference in the government or the authorities' approach to insolvency between businesses and individuals, right? So, for instance, the commercial insolvency regime now has been operational for some time, for some years now, and in fact, even a pre-packaged insolvency resolution for, you know, medium and small enterprises, micro, medium, small enterprises also has been introduced. But we still have not had a notification on the individual insolvency regime. And therefore, do you feel that the fact that the individual's insolvency regime under the IBC, although if you look at it, that kind of directs you back to the DRT, but do you feel that the fact that it's not yet seen light of day has sort of it's working to prevent individuals from taking enough risks, from doing more entrepreneurship or economic activity? What would be your views on this, the fact that the individual insolvency resolution process is not yet introduced or implemented, and therefore does it have this kind of a chilling effect on the willingness to take risks and do more of entrepreneurial activity, Ms. Pratibha?
Sure, thank you. Actually, just a quick comment on the previous question.
Sure.
The decriminalization by the finance ministry was a great welcome move. But practically, it's not the Companies Act that you get pulled under. Very rarely you get for criminal acts pulled under, if it's a Satyam kind of a situation. Most of them, at least the 99% of the cases we are dealing with are under IPC for fraud, for corporate frauds. And you get pulled in either, politically exposed individuals are involved in a case, and then, the investors get dragged in. And there, unfortunately, the move or the position that ED and CBI have been taking is that because there is no individual per se behind the corporation, it's the directors who we are going to name. And not only the directors who were directors at the time that the alleged offense happened, but the current directors. So even if you were not there at the time of the alleged offense, and you're a director in a company now that gets somehow pulled into a IPC case, you're getting named, and sometimes getting named even in the charge sheet. So that kind of, and we, in certain of these cases, went to CBI and said that is not the current law of the land. There are Supreme Court judgments saying that you can't do that. There has to be a prima facie case against the individual to be named. And yet that's the position that they're taking. So how do you deal with that kind of uncertainty? So a lot of people, including lawyers, are saying we are just not going to get on boards because we know really where the liability can arise. And in those situations, the cases don't get resolved. In India, the other problem is the criminal cases just don't get resolved. They don't go away. There's neither conviction nor are you acquitted for decades at end. So sorry, just on that the real pain in that point. On the individual insolvency, I totally agree with you. Very valid question. Just based on my years of experience in the US as a US lawyer, the innovation there thrives on the fact that you can fail. That concept doesn't exist in India. If you fail, there are legal ramifications, of course, reputational ramifications. We don't have the concept of, yes, you could have, started a business and actually fail. It was a very welcome move when IBC had the provision for that. But I think the current provisions are also a little scary because, the threshold is very low. It's only, I think, 60,000 rupees, where somebody else can take you. So just like, in the home buyers case, we saw a lot of extortion happening. This can lead to extortions for individuals. So I think tweaking is required, but at the same time, I think voluntary insolvency by individuals need to be notified as soon as possible. I think if Startup India, Make in India, all of these have to actually thrive, I think this piece of legislation is required to be notified.
Correct. I mean, and I think that point that you made, that already we can look to existing regimes for this. Your point about, for instance, the US regime, where yes, there is a, it can be a very intimidating situation to be in, but there's a fixed process, right? That once you declare that personal bankruptcy, at the end, there is a fixed process you have to follow, at which you are debt free. Right. So there is a route to that, and it may be a slightly difficult route or even a slightly intimidating route, but there is a route to that. So, that could be something that is helpful in the Indian context as well. And I think what again would probably be the need perhaps is to make it very non-judicial and more of an administrative process, that there is a process to follow. You make that application and you get there.
The problem is, in India, there will be, unfortunately, it's a new legislation, right? So if you make it administrative, there will be fraud, there will be people who will take loans. And so we will go through that teething process. I think there is no doubt that, there will be cases that are not genuine. But that does not mean that we don't enable the genuine cases and, learn to separate the two. So it'll get there, and there will be pains and that's why I think they're scared to notify it.
Correct. So, Dr. Ajay Shah, it will be great to get your inputs as well on this.
I agree with everything Pratibha said, and she made a fascinating comment. People with knowledge of law think twice before they become a board of directors. Okay, I have one criminal case because of some experience on being a board of directors, so I know I've lived the story that she just said. I want to enhance this argument one step further. If you think of the old entrepreneurial culture of India, okay, you think of 50 years ago, 100 years ago, amongst business communities in India, there was a very comfortable and optimistic approach towards business failure. And the business failure is a part of life. That you try things, you fail, and you fail 5 times, and you figure it out, and on the 6th time you get it right. I feel what Pratibha just said is absolutely key to protecting entrepreneurship in India, because the way things are currently structured, if a person will try to build a business once and there is debt in the picture, and then things go badly, and that person's life is then chewed up for 5-10 years. So first of all, at a very critical age in the life of that person, 5-10 years are wasted in resolving the debt that could not be paid. And second, it leaves a bad taste, and the person is then less likely to do entrepreneurship. Actually, the learning by doing of entrepreneurship is key. Nobody is born a great entrepreneur. You have to try again. So I feel there's a huge problem that we need to create a world where it is not dangerous and it is not an unpleasant thing to attempt building a business. What we are doing in India is we are making it extremely unpleasant. So only a few people will try it. And if it fails the first time, you're then unlikely to try a second time. That's extremely costly for economic dynamism.
Very, very fair. Point well taken, Dr. Shah. So, I think this is something that deserves some attention and some analytical thought into what should be the best mode to encourage that entrepreneurship and that risk taking. Definitely agree with it. A great discussion so far, and we still have some very good questions to consider. So I'm just going to move on and, just a gentle request. Let's try and get through some of these other questions as well. We do have some excellent questions from the audience, and it's wonderful to see that engagement as well. But very quickly, let's get through a couple more questions with the panel, and then I'll take questions, from the audience as well. So my next question to Ms. Bhargavi, that and let's look at the fact that there is a suspension sometimes of this corporate insolvency resolution process. And while the basic underlying cause is absolutely understandable. So for instance, in light of the pandemic, the corporate insolvency process was suspended, but this kind of an approach, which is applied very uniformly without taking into account specificities of each matter, it's almost like a sledgehammer approach. Do you feel this would do more harm than good to the economy, Ms. Bhargavi?
Thanks. So it is true that with the with lockdowns, etc., every country experienced some sort, except perhaps the United States, experienced some sort of tweaking of their bankruptcy law or a suspension, nature of a suspension sort of a thing, coupled with a moratorium, right? But I just want to take a step back and think a little bit about what is the purpose of a bankruptcy law, right? The purpose of a bankruptcy law is that actually when a person is facing financial distress, what are the creditors likely to do? Each creditor is likely to pursue her own self-interest. So imagine you are at the start of a lockdown, you are a manufacturing unit, and you don't know until what point the lockdown will continue, and you have loans to pay. You have employees, you have suppliers, you have a couple of maybe financial creditors. What is each one likely to do in the absence of a bankruptcy law? Each one is going to try and recover the full amount that is due to her, right? So, for example, if it's a secured creditor, he's most likely to enforce his security, and maybe it's not a good time to sell then, but maybe he will still choose to sell because who knows how long this is going to continue, right? So the purpose of a bankruptcy law is to really bring all the creditors onto the table and preempt each creditor from taking self-interested actions that may actually reduce the overall recovery for the whole body of creditors. Now, when you take away the bankruptcy law, you actually take away the incentives to come to the negotiation table, and you are likely reducing the overall recovery that could have been made if each creditor wouldn't have pursued their own self-interest, right? So the bankruptcy law is triggered. And in our case, of course, the board is suspended. But more importantly, all the creditors come to the table and decide whether this is financial distress or this is economic distress. That is it likely that this is just a function of the lockdown, in which case the creditors are not likely to pursue their individual recovery routes. They are in fact likely to want to save the firm as a going concern, because each creditor actually recovers a little more by saving the firm as a going concern, as opposed to going and liquidating the only asset that he has, which may a standalone equipment or a standalone machinery. It is not likely to face the same value as when a factory is sold, when a factory is running and is doing business, right? So when you take away that bankruptcy law, you reduce the incentive for any creditor to come to the table, and you actually deprive the debtor of this, opportunity of getting a reset with everybody else. So I think what we lost sight of was the fact that the bankruptcy law is here to help debtors as much as it is here to help creditors. In the absence of a bankruptcy law, the debtors are at the mercy of creditors, or at the mercy of each creditor, most likely their largest secured creditor. All the creditors are at the mercy of the largest creditor because they don't know what is the largest creditor going to do. The employees have no clarity on when are their dues likely to be paid, even if with a haircut. So to come back to your question, yes, the sledgehammer approach, in my opinion, was excessive. It was maybe even inappropriate. One way of doing this, which is what I think many nations actually ended up doing, is you suspend creditor filings. You allow the debtor at least to file the voluntary, your Section 10 filings, etc. So that if the debtor is able to arrive at some sort of a settlement or resolution with his creditors, they have the choice to take that legal route and actually restructure their debts under the shadow of a law, as opposed to each creditor guessing what is the other guy going to do, or as opposed to the debtor going and pleading to each creditor that just hang on, just let's just tide over these 3-4 months, and we'll, at the end of 6 months, I'll pay you whatever was due with interest, right? So yes, I think we should have learned from what other countries did, which is that maybe creditor filings it was appropriate to suspend them, but the debtor filing route could have been kept alive for sure.
I think that's a good way to see how this could have been balanced, perhaps. That yes, while it was understandable to take that step, perhaps the other aspect of it, the interest of the debtors, creditors, both being a little bit more in balance, what could have been done, maybe that was something to take into account. And in fact, Ms. Bhargavi, the next question also had to you, and I think after we've had your take on it, I'll probably ask a couple more of the panelists to quickly give their view as well. And I just request a little patience from the audience because these questions are so good and we do want to take the audience questions, but we'll take a few minutes more and just finish off with our panelists' questions, and then we'll move on to the audience questions. And I do realize we are short of time, so we'll try and wrap this up really quickly. So I'm just going to move to the other question, and then I'll take a response perhaps from one of the other panelists as well, which is that the question that I wanted to come to is that a lot of this debt recovery process, I would say really a large portion of it, the attention is really to the private sector's debts and sorry, that is being enforced or recovered. But there is very often a huge liability of public sector or of government regulatory bodies to clear their dues in time, right? And this has a knock-on effect. It very often has a domino effect on the inability of the private sector, right, to repay their dues, right? But this, as an example, in that Dhani Sugars case, we saw the power sector, the power producers facing a lot of distress because the DISCOMs were in distress, which are public bodies or government bodies, and because they could not pay the power producers, they went into distress. So there is a knock-on effect from the public sector to the private sector, but a structural reform to push for public sector firms to make these kind of timely repayments has not yet been introduced. So in a sense, you could almost say it's a kind of a preferential treatment to the public sector. And does this do more harm than good for the economy, Ms. Bhargav?
So I'll just quickly, you're absolutely right. And this is a problem, like I keep saying, it's not unique to India. Everywhere, public sector bodies are known, or public authorities are known to let's just say, abuse their large negotiating power and delay payments. And still people keep doing business with the public sector simply because it's a lot of volumes or for whatever other reason, right? So I think in the MSME Act, a couple of reforms have been attempted where, a statutory interest payment has been provided for delayed payments. Public sector, every person who owes, every business who owes money to a micro or small or medium enterprise and is not paying its dues on time is supposed to report delayed payments. I mean, there are some compliances, etc. And the whole objective of this exercise is to generate transparency on how disciplined a payer are you, right? Because once you have that level of transparency, and I'm afraid insolvency law cannot fix the problem of public sector enterprises making late payments, right? Similarly, company law cannot fix it. What can fix this problem? In my opinion, it's about the counterparty factoring in the possibility of getting this delayed payment and factoring it in his cost of doing business with the government, right? But so, for example, when a private firm makes a bond issuance, or when you basically the risk that you attribute to that private firm is directly linked to his payment discipline. We are not able to do this with government. Why? Because government accounts are hard to understand. A government department financials, you don't really take it into consideration how delayed they are. Sometimes you don't even have the information of how disciplined a payer one government department is versus another. For example, is an urban local body, a panchayat, a municipal body, more disciplined in making payments than the central government? I don't know. I cannot say. Is Maharashtra government more disciplined in making payments, or is the UP government more disciplined in making? I don't know. I can't say. Right? It's hard. So except unless you are a person who deals with that government on a repeat basis, it's very hard to say how disciplined a government department is in making those payments. The point is, you have to incentivize, you have to force government departments to disseminate information about their payment discipline, because it is the only way to reduce the information asymmetry between the government and a counterparty who deals with it. Right? And then next time when I'm a vendor to the government, I will factor that in, that this guy has been paying late consistently. Why? Because I can see it in public information. He has been mandated to disclose, and I will increase the cost at which I price that contract in. And that kind of turns into a feedback loop for that government department, who in turn will be questioned that why is it that your contracts turn out to be so much more expensive? That's one way to sort of deal with this problem, because clearly providing statutory interest payments in the law, etc., I'm not sure if it really makes a difference. There is research to suggest in the EU, where such similar laws exist, that it makes no difference on payment discipline. Disclosure, the disclosure mandate has made a much more difference on payment discipline than the requirement to pay statutory interest.
A very fair point. And yes, I absolutely take on board the point that it's not an India-specific issue. Probably with public sector enterprises, in many jurisdictions, we would see similar issues. The The dilemma is then how to find some way to correct this very disproportionate, I would say, negotiating power and volume that the government represents, and therefore the private sector wants to work with them despite these issues. And also the problem of really trying to do some kind of a provisioning exercise of factoring in the delayed payments, whether all of the private sector would be in a position to do this. So, but very, very good points. And before we move on to our last question, and then I'll be taking audience questions. So we are almost there. I just wanted to very quickly check if one of the other panelists wants to give a very short response. Mr. Surendra Kanskaya, would you have any inputs at all that you have on this point of, private sector being the main sector on which debt recovery has hinged, but the public sector also has a lot of unpaid dues at any given time? Or would you like to talk about the fact that, the suspension of the corporate recovery process, whether that was too much of a blanket approach? Would you have any kind of anything to add? No?
Okay, I'm sorry.
Okay,
I have a previous commitment at 2:00, so I'm going to log off.
Sure.
Thank you very
Absolutely.
much for this amazing discussion. Thanks.
Okay, wonderful. Thank you so much, Ms. Pratibha. It was absolutely a pleasure to get your insights, and thank you so much for sparing time to join us. So thank you so much. So I'm just going to move on to the last question before we move to the audience questions. Now, this is a question for Dr. Ajay Shah. And here we'll just take on the point that, if you look at the way the insolvency and bankruptcy code has developed in practice, if we look back to, let's say, the SR case, 2016-17, of phoenixing, where the promoters wanted to come back and perhaps be one of the applicants to take the company. So there has been a kind of observation that the IBC, Insolvency and Bankruptcy Code, tends to suffer from, you could say, a promoter-averse approach, and then maybe a bias towards liquidation, although on the face of it, the statute is really all about preserving the operations or finding a resolution other than liquidation. So, and apart from that issue, there is also some kind of ambiguity around the classification of consumer groups as creditors. So the example that came up early in our discussion of home buyers, flat buyers in real estate projects, who have this dispute that they have paid the money and not received the houses. The classification of those kinds of consumers as creditors. Do all of these ambiguities, are they just a part of the evolution of the bankruptcy regime, or can they be avoided? Could they have been avoided through more stakeholder consultation, through more assessment of the regulatory impact? So, Dr. Ajay Shah, leaving this question open to you.
I can't see him on the screen. I'm not sure.
Oh, sorry. Is he? Okay, perhaps Dr. Shah has logged off. So in that case, Ms. Bhargavi Zaveri, would you like to take a crack at this question before we close out the panel discussion?
Sure, can take a crack at it. Okay, so I'll just divide your question into two parts, right? The first one you mentioned, that is the code really promoter averse or liquidation friendly? And the second is that what do we do about these special cases of consumers being classified as financial creditors and so on? Let's take the first part, right? So actually, if you go to see, the court disagrees with you overwhelmingly, right? The courts, if you see the Supreme Court's judgment in whether it is, I think, what is that case? Swiss ribbons. I think it was the SR case, where the court actually says that under the code, if you read the language of the code, liquidation is the ultimate last option. And actually the code, the first objective of any resolution professional should be to reorganize, because actually the code heavily relies on the language in the preamble, which uses resolution, but doesn't use the term liquidation. And therefore the court says that actually liquidation is the absolute last option. So the interpretation of the court is very different from what may be perceived as the factual reality. So I wouldn't say that there is a liquidation bias that is built into the code. I wouldn't say that there is a resolution bias that is built into the code. Actually, if you read the code as it is, there is no bias that is built into the code. It eventually leaves all decision making to the creditors, because actually they know best what is to be done with the assets of the firm, with the employees of the firm, with the contracts of the firm. And the decision making was, I think in its original, if you look at the report of the Bankruptcy Law Reforms Committee, was left only to the creditors. Subsequently, I think there was a section 29A that was added to the code, which you could argue brought in an anti-promoter bias, because promoters were excluded, not really promoters, but willful defaulters and their related parties were excluded from applying in the resolution process with a bid for taking over the firm in the resolution process, because the apprehension was that there is a moral hazard, that if you allow the firm to be taken to resolution, and then if you allow the bad promoter who did not pay you to bid for the assets of the firm, then it creates incentives to actually default deliberately and take back your firm at a much lower price. Right, so that is where actually the anti-promoter bias came in, and I think there is some logic to why we have the anti-promoter bias. I mean, in society, because we have actually seen Indian promoters and Indian businesses being shown indulgence by the banking sector over a very long period of time, and that creates natural apprehensions and anxiety for what the promoters would do to get their firm back. But I think at some point we have to decide, either we can have clarity in the law, and we can actually say that, resolution is agnostic to who takes over the firm. If at that point in time, the creditors believe that the promoter is the only person who will buy back the firm and who will clear that debt, so be it, right? Or we can choose to stick with, our old experience of how promoters may, sort of be incentivized to take the firm, strategically default and take the firm to insolvency and then take over the firm at lower rates. Right? So I think it's a trade-off. Right now, our society has made this trade-off where they think that promoters should be kept out of the bidding process. Willful defaulters should be kept out of the bidding process. It's a trade-off that we've chosen to make. But as the court's interpretation is that there is a resolution bias, you are saying that the reality on the ground is that there is a liquidation bias. I would say that if you actually read the letter of the law, it's left to the creditors. I don't think there is a bias one way or the other, and you will find that in the logic of the code in the Bankruptcy Law Reforms Committee report.
Correct.
On the second point, I honestly don't have views on whether buyers of homes, home buyers should be treated as financial creditors versus operational, because I think it's a function of the way the real estate financing structures evolved in India, which essentially allowed the entire projects to be funded with just advances from home buyers, right? I mean, given that was the financing structure at that point in time, maybe it's only fair to say that home buyers were not just consumers, they were actually lenders to projects. But now with RERA coming in, right, which requires some sort of ring fencing of the advances that is taken from home buyers, maybe we won't have that problem, or we will be able to mitigate the risk of those advances being used and siphoned off. And maybe this is a legacy issue. So I don't particularly have a view on the second question.
Okay. Thank you so much. I mean, that was really a very, very illuminating, set of points that you made out there. And it's a fair point that the statute itself doesn't really have any kind of a in-baked sort of a bias. It's more how it would be implemented that we'll see some kind of pattern emerging from there. So very fair point. I'm well aware that we've had such a dynamic discussion. We've exceeded our time that we had planned to do the panel discussion. I'll take a quick input. Professor Srijit, do you think we can take a couple of questions from the audience, or we are short of time? Okay, my apologies for this. We had two questions that I really wanted to take from the audience, but we are really unfortunately short of time, and we have a fantastic panel right after this. So, we'll have to log on here, and thank you so much to everybody who has joined to come in and listen to us in our discussion today on these very, very interesting points of, interlinkage between law and economic analysis and law and economic imperatives. And I thank all our panelists for joining us, taking out time from their busy schedules. Thank you all so much. And, we will have to end our discussion in this panel event right now. And, we'll be having our next panel. So, we look forward to seeing all of you in the next discussion as well. And thank you so much for the panelists. It was a great pleasure to get your insights today. Thank you so much.
Same here. Bye-bye.
Thank you, panelists. Thank you, moderator. So I also thank everyone who has been connected to us through the JGU YouTube channel. For our third technical session, Law and Economics Approach to Competition Policy, Digital Economy and New Technologies. Please stay connected. We'll commence in the next couple of minutes. Thank you, everyone. Good afternoon, everyone. Welcome to the third technical session of the National Virtual Conference on Economic Dimensions in Judicial Decisions. I'm Srijit SG, Executive Dean of Jindal Global Law School. This session is themed Law and Economics Approach to Competition Policy, Digital Economy, and New Technologies. The distinguished panel for the session comprises of Mr. Manas Kumar Chaudhary, partner Khaitan and Company, Ms. N.S. Napinai, Supreme Court of India and founder Cyber Sathi, Ms. Sakhi Shah, Senior Research Associate, Cuts International, Mr. Rahul Sharma, founder, The Perspective. And the moderator for the session is Professor Aviroop Bose, my colleague, Professor of Law at Jindal Global Law School. Over to you, Aviroop.
Thank you, Srijit, so much. I want to add my own welcome to Professor Srijit, and I want to, of course, begin by hoping that all of you, wherever you are safe and, in the best of your health. Just to, I think I kind of begin with Manas. I have the distinct sort of pleasure of actually working with Manas very closely for a very long period of time. Manas, as the topic suggests, the role of economics in judicial decision making. You have been not only a person who has been worked with CCI, the Competition Commission of India. You have been practicing before the CCI as well as the appellate courts for the last decade. In my experience, when I was sort of an expert with the CCI almost 7 to 8 years ago, it was a very tough uphill task to bring economics into the mainstream of decision making. Payal, myself, Geeta Gauri ma'am, we tried a bit, but there was some resistance. Over the years, in your experience, has that changed? How would you now look at CCI as a decision-making body? How much more economic approach does it adopt in its regular behavioral as well as merger control decisions?
Thank you, Aviroop. Thank you, Srijit and Jindal Global School and Cuts for giving me this opportunity. This is a very close and dear to my heart, this competition law. I bumped into this practice by accident, but over the years, I have now become fascinated about this because you tend to know the inside of an industry. And when I say inside of an industry, I mean, you know the conduct of the decision makers within an industry. That's what the Competition Act is interested in. They are not interested in a contract. They're not interested in an agreement which talks about contract law. They're interested in knowing the intent of the agreement. So that is the very interesting facet of Competition Act. The moment I talk about conduct, obviously there would be, as a practicing lawyer, I would like to see that my client is able to defend an allegation. How does one defend? The Competition Act itself provides a plethora of statutory principles in the law, which actually are safe harbors according to the advanced jurisdictions of European Union and the US. The question which Aviroop you have asked is very specific, whether or not the CCI is able to adopt those principles which are already inbuilt in the Act. I would be making a very candid submission that sometimes they are, sometimes they are not. It all depends upon a perception in the market. For example, when any authority dealing with, say, cement, tire, glass, sugar, they tend to believe that they're always in a cartel. They just cannot survive without a cartel. So these perceptions at times, also unnecessarily make inroads into the minds of the people who are making the decisions. They should be objectively understanding a particular issue. Say, for example, in one of the tire matters in the first initial rounds of the CCI, they did adopt a wonderful economic principle that the tire industry being an oligopoly, when I say oligopoly means few players in the market, and it is not that the few players by conduct are not allowing new entrants into the market, but the new entrants are not interested to enter the market because of the initial sunk cost. So the oligopoly continues to thrive on the oligopoly. So what happened in that tire cartel case, during the course of the investigation, the CCI found that the market share amongst the oligopoly was dwindling. It was not stable. So once the market share found to be not stable, CCI concluded that the parties were able to lower their prices, thereby gaining market share. And that's a typical economic principle. If a cartel is stable in terms of market share, it is presumed that the prices are perhaps moving in tandem. On the contrary, in one of the steel matters in the CCI's cartel case, because applying economic tools in cartel investigation is very difficult and very rare, but they did apply. What happened was, out of the 4 oligopolies who are involved in that allegation of cartelization in the price of steel plate and steel rods, CCI found one of the oligopoly member who was actually buying iron ore, and all other 3 were having their captive iron ore mines. CCI concluded that if the 4th player is able to find the market price through signals by market intelligence, that would not be a cartel because it wants to survive in the market, despite the fact its notional profit would be lower than the other competitors who have got the captive iron ore mines. So CCI had given a very fantastic ratio, saying that interdependence amongst competitors at times throwing up parallel pricing may not be a cartel. So this is a typical economic policy which CCI adopted. As late as 2020, when this COVID problem had struck India, CCI was actually disposing of 2 matters relating to cartel. One arose out of a leniency application and other was a non-leniency application. In both the cases, CCI concluded cartel, but did not impose any penalty, giving the reason that since the economy of the industry is going downhills, it would add miseries to them if we impose penalty. And they applied the market condition and did not impose penalty. So these are some of the issues in case of, say, antitrust issues, where CCI at times had applied economic tools, but many a times they did not apply. But in merger control, Abhirup, they do apply more often than not only economic principles. Even in Form 2, they tend to give the HHI. Sometimes they also talk about, say, for example, hypothetical monopolies test. They talk about many issues, which I think is a typical microeconomics. I stop here because I have consumed my 2 to 3 minutes time.
Thank you, Manas. I completely agree with your assessment of how the CCI is a kind of ad hoc movement along with the use of economics. There has been some decisions of the CCI which has been very, for a lack of a better word, in my analysis, very regressive in terms of a lack of an economic approach. On the other hand, there has been, a kind of a consistent movement, especially by some members, or often through dissenting opinions even, that a more economic approach should be required. Sakhi, if I could come to you, Manas has, given examples, good examples, but he has he has spoken about the cartel, a few of those cartel cases. As a scholar, as a researcher with Cuts, one of the leading sort of think tanks in this area, what is your opinion about the digital economy and the cases related to the digital economy, the new economy sectors? Do you see there being a trajectory of the CCI and having a more economic approach there, given the fact that many of the cases coming from platform markets, coming from network markets, requires a more robust economic understanding by the regulator?
Right. Thank you, Professor Bose. And I think before I get on to answering the questions, I would just like to say that I'm delighted to be here amongst the panel, and it's a pleasure to be speaking and discussing this with all of you. So thank you. Onto the question, I think Professor Bose, the entire concept of the digital economy, the entire concept of platform markets, zero price markets, the new kinds of economies, the new kinds of markets which are coming up, they in themselves are very complicated than we, I think, tend to understand or realize, given that there are multifacets to these economies, which is not only restricted to, let's understand, competition law, but there are various other aspects which do come into play. In that regard, I think I don't think there has sort of been a trajectory, so to speak, since that's how you asked me. I don't think there's a trajectory in the way that CCI has given its decisions, especially not lately. But however, there has been a lack of proper understanding of how these markets function when we talk about how the CCI has given these decisions. So when you start from the very, very beginning to the very latest things, you see that there has been a development in how CCI understands these markets and how these markets function. When CCI acknowledges the importance of data, when CCI conducts market studies in e-commerce or telecom, or comes out with a paper on blockchain and its effects on competition, or how these both how there's an intersection, you see that there is a nuanced understanding, an understanding which is still developing. But it's just that. It's an understanding which is still developing. I think we are very recently starting to see that the CCI is actually starting to take into consideration that these markets function differently. One of probably the best examples right now is the WhatsApp privacy policy case that's currently going on. But at the same time, you just go slightly back and you see that when there was a case in front of the CCI for WhatsApp and WhatsApp Pay, CCI took a step back and said that the introduction of WhatsApp Pay is not going to really hinder competition in the market. So you keep seeing these back and forths in, I think the word that you used was more appropriate than, and more best suited to what I'm trying to say, is that their approach has been more ad hoc. And I think the problem with this ad hoc approach is that it isn't necessarily providing India the country that the landscape that we are building into, the framework that we need to boost these digital markets and these digital platforms. Because what essentially happens when CCI takes a step back in deciding or saying that WhatsApp Pay is going to hinder competition in the market is essentially that you fail to understand that it's two different markets where it's the same company taking control. So I think I was just very quickly, I think I will, maybe I've overdone my time, but I will just conclude by saying I was just reading this article sometime back where it stated that all of these companies, they have started at one point, right? Facebook started with social, Google started with search, Amazon started with e-commerce. But now these companies are no longer in those particular sectors. They have gotten down. So the iceberg below the ocean is much, much huge than what we can actually see. So I think the approach of the CCI has been ad hoc, and I think there's a lot more that can happen, which will only come once the understanding of markets is more nuanced.
Thank you, Sakhi. I completely agree with what you kind of said, because I do see that CCI is trying harder, that's for sure. The recent amount of market surveys that they have done indicates a willingness to listen to the industry, as Manas was pointing out in his initial comments. Both Cuts and OP Jindal Global University are affiliated with the CCI as think tanks who work on competition assessments of regulation. So that's another area which CCI is looking forward and has actually kind of been more active in the past. Ms. Napinai, it's a wonderful time to speak with you. As Sakhi said, we have a new a report that CCI has come up on blockchain and competition issues, which is kind of course, completely, up your alley. And if you could kind of tell us, what do you think about CCI's move? Do you have concerns with that report? How you think blockchain and artificial intelligence and, generally speaking, that area of technology future works up with the current report that has come up from the CCI?
Thank you, Aviru. I have a few pointers or points that I would like to raise first before I come to your question. I'm going to start with the last first. I don't know about whether you agree with Sakhi or not. I completely disagree. Pardon me for a contrarian view, but then as a practitioner, I can tell you that to label something as ad hoc merely because two different stances have maybe taken is actually misleading. I felt that point has not come out clearly, so I'd like to start off with clarifying on that. Whenever we speak about adversarial litigation, everything is contingent ultimately on facts. The law is the underlying foundation, but the facts decide which is the course that underlying foundation takes. To merely say that a decision was taken in a particular way in the WhatsApp Pay case, as opposed to the Facebook and WhatsApp privacy issue, is like trying to compare apples with oranges. Okay, so that doesn't necessarily mean that a court or a tribunal is deciding something in ad hoc fashion. It is deciding on the basis of the facts before it, applying the law before it. So to say that it's ad hoc or it's just trying to find its way is incorrect. On the latter aspect of what I just mentioned in terms of trying to find its way, competition laws are still at a very nascent stage in India, but it is not new. It's neither new in terms of deciding antitrust, nor is it new in terms of deciding disputes in the digital domain. When we speak about Facebook or WhatsApp, it's a lot more public, and therefore you have heard of it. I wrote my book in, somewhere between end of 2015 to through 2016. I completed the script by about October or so. Some of the most interesting cases for the digital domain came from the Competition Commission. One of the most interesting, and in a way, this trajectory kind of like reflects my trajectory in terms of IPR to cyber laws. And that's how I moved to cyber laws. I used to handle a lot of IPR cases, and including software licensing. And software licensing took me from IPR to cyber laws, actually. Similarly, one of the most intriguing cases to come out of the Delhi High Court was with respect to the Spectrum case, okay? And about FRAND licenses, and it invariably went in favor of Ericsson and the Spectrum cases. And a contrarian view there again was taken by Micromax when it took the case before the Competition Commission to decide on antitrust aspect as opposed to the licensing issues itself. And one of the earliest decisions from the Competition Commission, which was then affirmed by the Delhi High Court, a real pleasure in terms of reading even the Delhi High Court judgment for any student of law. I can tell you, Vibhu Shankar's, if I'm not mistaken, Justice Vibhu Shankar's, is on the issue of when can something amount to an enterprise. So the same issue which was taken up as an IPR issue evolved as a competition law issue. And this is, I'm talking about more than 5 years back, when the Competition Commission in India took up this issue. So the point I'm trying to make, and especially for students who are very interested in this field, is digital law and or cyber laws, technology laws, call it what you will, and competition laws are not alien to each other. A lot of development happened, evolution of technology laws happened in the antitrust field. So this is a fabulous evolving field for youngsters, especially if they want to take it up. Particularly in the US, if you see, antitrust is a field which people specifically focus on. And it's something that's the future, and we need to have specialists in this field. And now moving very quickly to your question, any change, any development is always welcome. Blockchain is something which has been struggling because of its association with cryptocurrency and this natural disinclination then when we talk about policies to de-link cryptocurrencies from blockchain. So when we are talking about blockchain and competition laws, and as you rightly said, why only blockchain? I just spoke to you about Spectrum. We are already seeing about privacy policy. So you have data protection also coming into the picture. And data protection and artificial intelligence, again, cannot be spoken about, in isolation. They always go hand in hand. And then you now have blockchain coming in to kind of create a validation process. All of it taken together is something that we should welcome as we are only in an exploratory stage now. It's too early to start critiquing something, sometimes I feel when we start critiquing, we tend to miss the forest for the trees, right? We go into too many nitty-gritties, which may be problems with the policy statement, but the policy statement itself may not necessarily be wrong. So we need to now look at the broader picture and see where we can take this flow. Like I told you, law finds its path based on the foundational aspects that have been laid down. First principles still apply, and we have to wait and see how the competition laws are going to be applied further to technology disputes, and every single thing, whichever way the scale drops, is actually a progressional process and not really regressive, according to me. So these are exciting times, and we should actually be looking forward to progress now on this.
Thank you, Ms. Napinai. Before I go to Rahul, of course, Sakhi, when I'm presuming when you will be able to explain I'll come to you and give you an opportunity to kind of explain your background. Just before I go to Rahul, I kind of also use the word ad hoc, so I will very quickly add what perspective from the digital market I was saying. You're absolutely correct, Ms. Napinai, and I think Manas would agree with you, because I could see him also kind of nodding along that I was not suggesting at all that the outcome of the case, if it varies from one case to the other, there has to be kind of a difference in terms of sort of the way it has been appreciated. That's of course not the point of view. Actually, I wrote a paper with Professor Shah of NIPFP, who is also currently a research professor, Ajay Shah, and we worked on network markets. That entire paper was on network markets. What we found was the way, for example, relevant market was defined in some of the e-commerce cases, the way some of the AEC assessments happened. Again, you could reach a conclusion, but we found that it was not always the same standards. There was kind of appreciation of evidence differed. What form of evidence they looked into itself differed. Again, the Uber and the Ola cases, there's a couple of them now. But of course, you're absolutely correct. Just because the CCI reaches a conclusion which kind of is one-sided or the other, we should not conclude that they are ad hoc. I'm completely with you. And I will come back and we'll have a little bit longer discussion on that. Rahul, I know you yourself, you're a privacy expert, you are an advisor, sort of, and through the perspective, you do a lot of advisory work in this area. Again, it's a very interesting moment, as Ms. Napinai was suggesting. It's an area which has come into the play of CCI with the recent, you can say, some people will say usurpation, somebody will say appropriation of privacy into antitrust. I know I have friends in America or the US scholars who WhatsApp me aghast with such developments, being an antitrust puritist, that Puritarian, that we shouldn't touch privacy. What is your view generally from not only from a competition point of view? That's also a question that I have. But what do you think is happening with the concept of privacy and data, given that we still don't have a regulator in India, and you see an all economy regulator trying to provide some guidance in this area? What is your view?
Right. Thank you, Avirup, and thank you, Jindal Global Law School and Cuts for inviting me. And hope everyone is doing safe in these tough times, and condolences and belief to the people who are not doing well, whose families and friends are suffering. So coming back to this topic, the main theme. I think so like my background is I am not a lawyer, I am not an economist, but as an observer who has interest in the subject of technology, policy, the evolving ecosystem of regulations, and how these intersect to make our lives changed. And this is happening at a very rapid pace. So what we see that in this, if you look at just the last decade or 2 decades, the paradigm shift in terms of what technology, what data-enabled innovation is bringing to us, I think that's huge. And as Napinai said, that change is something, that sometimes looks to us that, are we going in the right direction? But, change, we need to embrace it and find what good can be derived from it, while, keeping the main objectives of stopping the harm. And, that's what the focus seems to be of the regulatory authorities, the governments, the policymakers, and, that's why we are where we are. There is an increasing risks, and, risks are always increasing if we do not give them important consideration in our decision making. And hence this particular theme of the conference is very important on how the role of judiciary becomes very important, because at the end of the day, these are new emerging subjects. Nobody can say they understand them comprehensively. We are all just trying to learn, and especially when a judiciary, when some cases appear before them, they are put in the spot. So like they have a tough task they're constrained to take decisions, because status quo also means handing over a victory to someone or the other. So, and in that process, what they're doing is they are sort of benchmarking certain principles, keeping in mind certain examples. As Napinai and you were discussing, there are nuances for every case based on the facts and evidence presented. But now, based on the legal framework, what we have said, and the judicial pronouncements, they sort of lay down, a basic framework or a benchmark that that needs to be followed or observed. That's a jurisprudence. That is a bare minimum that needs to be done. And given that this space is very very dynamic, and there are no fixed markets. Everything is like morphing continuously, given the the innovation, the adding on of services, the interoperability of things and how things work. So it's something that good to have a greater understanding and sort of try and develop principles so that when the matters land up with courts, so their task should be to make it apply and give a simple, fair, uniform, stable, and guidance in a way that that is also understood by non-legal experts, to say that that we have a common understanding of how things are. And in this particular dimension, so the important task before courts is how do you factor in the economic considerations, the business side of it, the labor, the market side, and also the welfare side, and what priority should it have in terms of the legal and administrative principles which are already laid down in the decision making for the courts. I think that's going to be very important, because as we were discussing, when the discussion started and this point came up, and this example just struck me on the economic consideration for decision making by the courts. And but the biggest example that I can quote is of the Volkswagen Dieselgate scandal in the European Union. When it broke out, the US, the South Korean regulators, and a few other countries, they imposed heavy fines on Volkswagen Group immediately, but Europe did not. And the primary reason for that is, one is the government's money was invested in the Volkswagen Group as one of its counties. Plus, if they had also imposed penalties at that time, the company would have gone bankrupt, and it would have led to loss of jobs, destroying of markets and all. So courts do have these considerations when they take or do not take any decisions. So we may try to see on how they are isolated, but I think in some cases they are being given considerations, especially in cases of well-established markets where the fear of changing is tremendous. But since this technology and the data space is something which is relatively new, so in that context, how do you translate the basic principles into something that makes meaningful sense? That becomes very important. And I'll just take a minute more to sort of talk about the primary or the base argument for having a regulator having a look at this space is one is to prevent the lock-in that there's no monopolization. There is the network effects are curtailed, and in this the role of platforms as well as in specific sectors, role of companies has to be carefully adhered to in terms of concentration of power, so that there is a level playing field for everyone. And one important point that Mr. Chaudhary mentioned in his important remarks was on perception, and I would say that in addition to perception, I would also add sentiments, because that is what drives the economic processes more often than not. And there is, sorry to say, there seems to be a lack of trust amongst stakeholders. So yesterday, interestingly, there was this interview that Mr. Pramod Bhasin, who is the father of the BPO industry and Genpact, founder of Genpact, and also is the director general for ICREER now. So he used a very interesting phrase that the judicial pronouncements when it comes to private sector where the cases are involved, so their decisions are, to quote and unquote, crouched in phrases which suggest enormous distrust. And if businesses have those sentiments, if investors have those sentiments that the lack of trust is leading to certain perception, and that perception is leading to certain sentiments, and that is driving the that's a cyclical process. So the basic understanding is to sort of bridge the trust deficits and gaps, and I think, given this space is rapidly evolving, I think there is a space for more, coordinated and comprehensive approach on how we approach this subject. Because once we sense the benchmark, and we are just in the initial stages of building digital blocks, and they will be the baseline for the future. So yeah, I think it's more required that we spend more time, more discussions, more dialogue, and come to good principles and evolved frameworks that can be applied. Thank you. I'll stop here.
Thank you, Rahul. If I could turn to both now the two advocates on our panel, Manas and Ms. Napinai. You both of you in your regular course of work regularly approach before courts. And one of the things which Ms. Napinai suggested in her initial remarks was the fact that in the United States, antitrust is not only a legal discipline, it's an equally economics discipline. You have firms which specialize in the economic analysis of antitrust law and issues, and those are routinely submitted along with the legal sort of files before courts for their appreciation. So if I could turn first to Manas and then to Ms. Napinai, when you go and appear before Indian whether it is the NCLT or whether it is the Supreme Court or High Court, apart from a few judges there who are known to be extremely I do not want to name certain people here, but there are certain judges of the Delhi High Court whom everybody knows they're fantastic in appreciation of economics and on issues of cyber law or of a particular area of a technical aspect of competition law. But what is your experience generally speaking? That how much do they allow you space to argue from a law and economics point of view? Are they open to discussions? Do they want to learn along with you, or do you find that it depends upon the bench completely?
So, Abhinav, thank you for that question. It's very interesting. It's mix of the two, because end of the day, every lawyer would believe that there is an element of subjectivity with a judge. Howsoever one may try to be Kelson's pure school of law, the element of the social upbringing a person has, that also gets reflected sometimes in their arguments. I will give certain examples that will, I think, clarify your position. First of all, I should start with saying that what is the aim of Competition Act globally? It tries to discipline the market which arise out of independent agreements between independent enterprises. Now, when I say independent agreements means businesses only run on agreements. Agreements under competition law is primarily horizontal, means competitors. So for example, pro-competitive competitors agreement can be a joint venture, can be a merger control, but it may not be an agreement between two parties trying to fix prices or allocate markets, which would be considered as most pernicious agreement under competition law. Similarly, if you have got an agreement which is vertical and where the person is able to dominate the wheel of the downstream market and is able to operate independently for a longer period of time, despite it is an agreement, it still smacks with the element of unilateralism by the person who is holding the market to ransom. So it is the conduct of the enterprise is more important in a competition law. The moment I say conduct, I am again going back to my old submission that it is nothing but economics. I am doing business for profit. I am not an NGO. I am not an old Section 25 or Section 8 company of the New Companies Act. My job is to earn profit. Competition legislation in India does not really control profit as any other sector regulator does on tariff. So Competition Commission is not bothered about whether you are making unlawful profits primarily, unless you are dominant and you are imposing some kinds of unfair condition on your downstream players and making exploitative profits. It may come within the ambit of profiteering, but mostly the Competition Commission is not mandated to look into the area of profit making by an enterprise. Having said that, having understood as to the conduct is primary, the judges vary. For example, I'll give you a live case of mine. Pharmaceutical companies typically in India mostly are branded generic. They face a very difficult proposition before the CCI that the distributors who are a downstream player, they are actually having a conduct which prohibits a new entrant into the distributors market in the downstream. They do not allow any new distributor to enter the market unless the new entrant pays a hefty sum of money, which is all handled by the distributor association in a manner which is not taxable. So they do not show that money received from a new distributor as income. In the process, what has happened, initially there was altercations between a new distributor trying to enter the market and old distributor association who are incumbent. They then start roping in the pharmaceutical companies, these distributors who are hugely popular and powerful people in the downstream market. They can just issue a boycott notice to a pharma company and the entire chain gets blocked. So the pharma companies were tacitly given a direction that unless a new distributor shows you a no objection certificate from us, you should not deal with this new distributor. Now this question is whether or not it is a competition law issue is $1 million question, because it is actually someone is trying to coerce a legitimate business of a pharma company not to deal with a new distributor. And CCI typically tells this as a tacit collusion between a primary pharmacy company and a distributor. In that analysis, CCI needs to also understand that in a given geographic market, if there are 150 to 300 pharmaceutical companies and each one is having about 50 distributors, a one-off distributor, if he is not able to enter the market, how would this become an effect in the market in terms of appreciable adverse effect? Can CCI address the issue of coercion, boycott? It can't. Then if it is not able to address the issue of coercion and diktat of the distributor companies, under law of agreement, it is not an agreement. How do you call it a tacit agreement? So in one of our appeal matters before the compact, Justice Singhvi had agreed to our analysis and completely set aside the order of the CCI that this tacit collusion, what CCI is claiming, is per se not an agreement since it is visited by coercion. So sometimes, we get very good order. For example, this liquid petroleum gas case in Supreme Court, at CCI and at appellate tribunal, this was held to be a bid rigging. But what Supreme Court has analyzed is something very nuanced view and very interesting. It said that IOCL, when it floats a tender, it actually asked all pan-India LPG suppliers to come and give a financial bid. It may be that all the bidders may have come to some kind of a collusive pricing. But when they submit the financial bid to IOCL in that matter, it was found that IOCL, in exercise of its countervailing power of a buyer, it directed all the LPG suppliers to supply at 11 rupees per cylinder less. And everyone had to agree, otherwise IOCL will blacklist that LPG manufacturer. The Honorable Supreme Court found that it cannot be a cartel because the agreement was alleged to have been entered into by the bidders, ultimately got distinguished by the Supreme Court, by the IOCL, which was an agreement which IOCL dictated upon the suppliers. How can that fall within the ambit of competition law relatable to bid rigging? So it all depends how does a judge perceive or an adjudicator perceive a particular problem with regard to how a articulation of an argument made by a lawyer. So I fully agree with Madam Napinai that it is an evolutionary process, and even in US, Avirup, you know, 1890, the Sherman Act had come into being, and the United States is still innovating new and new facets of antitrust. And I just conclude by saying that there are questions asked whether the digital economy can be adjudicated by the CCI, whether an amendment of the Competition Act is required, a comprehensive amendment of Competition Act required. I don't agree. Because Competition Act within its ambit has defined enterprise in such a manner that everything under the sun excepting the sovereign function of the state is all enterprise whichever is engaged in commercial activity. Am I going to say that the data companies are not making profits? Even if they're making zero pricing to their services, the answer is no. The moment they're making profit, you call for their balance sheets, you call for the ITO income tax return of the individuals, you will come to know where they are 2 years before and where they are now. If they're making economic advancement for themselves, and in the process they are actually growing up, they may have a defense of innovation. But at the same time, that is very much within the ambit and scope of the Competition Act. Even the decisional practice with the guidelines can lead in future rather than going for a comprehensive amendment. I stop here. I think I wanted to answer your question.
Yeah, no, thank you, Manas. If I could just add one more line before Ms. Napinai speaks. So my question, Ms. Napinai, I have is that in your I was trying to kind of figure out in your appearance before courts, do you find a Richard Posner in Indian courts? Will we ever find people of those type of scholars? I am asking this question not only because Manas is absolutely correct in terms of appreciation, but how do you write decisions appreciating foundational sort of theories of economics, which I think even Rahul was mentioning? Legal writing in India, judicial writing, do you think has developed, is developing? What do you think about that?
Avirup, your first question was difficult enough. Now you've added another layer to it and made it more difficult for me. So I'm going to go into first principles here. The very construct of adversarial jurisprudence is certainty. So when you're talking about the evolution of legal precedents, the assumption is that there will be some level of certainty and some level of, following a precedent for a substantive period of time. Through the years, and I'm now, I've completed 30 years of practice in my 31st year. So though the last 2 years have kind of merged into each other. But, one thing I've noticed is this, we are always talking about a dilemma here. We're talking about competition laws, again, an evolving field. We're talking about the intersection of competition laws with technology, again, an evolving field. So we're talking about change and in the same breath, talking about certainty in life, right? When it comes to legal precedents, etc. So how do you balance both? First principles are what matters. We cannot shy away. We cannot assume. So this is what, whenever I do a training for judges, police, whoever, I always tell them, when you talk cyber laws, when you say technology law, when you say whatever prefix and law, please take away the prefix and just say law. Because ultimately, whatever the prefix may be, it is irrelevant in terms of your appreciation because you're still going to apply first principles. And that is my concern when it comes to evolving fields, that everybody somehow seems to think that this is dehorse first principles, that anything that's evolving is supposed to be something new, something different. It has no anchoring to what we have used to and what we rely upon in terms of a very traditional profession, right? Something that's one of the oldest possibly. So the two difficult questions that you asked, India has always had a welfare state perspective. And then we evolved into the liberated economy. So, I come from the generation which kind of like, balances both. I come from the generation which was in the license Raj and then moved into the liberation phase. Most of you millennials have seen only the liberation phase, and it may not be liberation enough for you. It may still seem very constrictive. For us, any kind of freedom seems like a great thing to welcome, right? So when you look at it from this perspective or the lens of the pre and the post-liberation phase and where we are today, effectively, the judiciary is also struggling with that moving over from a welfare state concept to competition to now competition law, which is technically antitrust. So which kind of like tries to rein in competition. So imagine the kind of, variations that it has to take into account, even in terms of a mind space. And ultimately, you are absolutely right that individual perspectives may ultimately decide outcomes. But to obviate that, to ensure that this is not going to create what Saki mentioned earlier, and I don't even deign to speak for her, but from one perspective, if that was what she meant, I would totally agree with her on that, in the sense of that decisions should not be individual driven. Decisions should be legal framework driven. And therefore, it has to ensure certainty. And for that to happen, anybody who is in that position in whichever court, from Supreme Court down to the lowest court in the country, every single person has to decide based on the framework and not based on what their perspective is here. There, I totally agree that it should not be ad hoc. Merely because distinctions are there in different kinds of cases, I disagree in terms of it not being ad hoc. So I'll come down to this construct, therefore, of stare decisis. And why do we have this principle of stare decisis, which is that a precedent always takes priority, right? We have precedents as laws because that is what is supposed to create certainty. Every time a precedent is reviewed, every time it is overruled, that's why courts are very cautious to interfere. And we also have this construct of prospective overruling. Many occasions when even the Supreme Court failed to apply it and the nation suffered for it, including in cases like Bharat Aluminium, where there was a lot of economic repercussions. So actually in Bharat Aluminium, there was prospective overruling, if I'm not mistaken. But then it can have a repercussion if it is not done, as in Anwar versus Bashir. But in any event, the point that I'm trying to make is, yes, I agree with you that decisions cannot be individual based, but how can it become more broad based? And your second question on how can legal or judicial framing evolve? On a lighter vein, I can only recall this one comment by a Bombay High Court judge, as he then was, but he's now in the apex court. He said that he had visited the chambers of one of the US Supreme Court judges when they had these exchange programs. And he said, I saw the chambers and I then came back to mine. And I almost started feeling that I can fully understand how they write the kind of opinions they do. So from an infrastructure to support teams to how we do our own perception, because nobody stops learning, nobody stops reading. You may be the Chief Justice of India and you still never stop learning, right? You're continuously evolving, you're continuously reading and upskilling yourself. So that upskilling is what is going to and has in fact already to a substantial extent resulted in increasingly evolutionary judgments coming out from Indian courts, and I'm sure we can look forward to many more. We may have a situation of 1 step forward, 3 steps back, but again, that's bound to happen. That's no reason for us to get pessimistic. I think today I'm in my very optimistic mode, okay? So I'm like all for the assumption that we already have a very progressive move, even in terms of judicial writing and formation of opinions. Judicial opinions here. And I feel that there is a lot more coming our way, especially in the field of technology laws. And I would rather reframe it to say, I hope that we have a lot more coming our way. So thank you so much for those questions.
Thank you, Ms. Napan. I am so happy that you are optimistic in the times that we live currently. Such optimism is much needed. So I hope we can take some of those optimism along from you. I'll just come to Sakhi. I know you've been waiting patiently for a long time. Sakhi, I have a question, which is, you belong to a think tank, which is our partner today for this program, who is one of the oldest think tanks in this area of firstly consumer protection law and then progressively antitrust law. Cuts, Mr. Mehta has been writing since the early 90s about why Indian economy should open up and all of that. So my question to you, Sakhi, is that what do you think the role of research, role of think tanks like yours, like the several ones that's coming up in India currently? Even we in JGU have a dedicated competition law think tank. You might be aware, it's called Judicial, where we do dedicated research in areas of intellectual property and competition law. But I am not speaking from individual point of view as to what you are doing and what I am doing. What do you think of the role of research and the role of independent think tanks in this area of sort of improving or using economics in judicial decision making? The reason I ask this question, of course, is because as we see, the entire law and economics movement started in universities and then moved into courts. So what do you think about that?
So thank you very much for that question. And as you said, I was waiting very patiently. So I think before I move on to answering this question, I would like to make some thoughts out there. So I think going back to the very first intervention that I made. So I think Ms. Napanai, when I was talking about CCI taking an ad hoc approach, I think what allow me to clarify for a moment, and Professor Bose also probably allow me a minute or two than my designated time. So I think when I'm talking about an ad hoc approach by the CCI, what I'm essentially trying to say is that I completely agree that the times that we are living in, the competition law, competition policy frameworks, the digital economy, new technologies, data protection, blockchain, so on and so forth. I think in the next 5-10 years, probably there'll be 10 more things that will be added to this list, hopefully, preferably, you never know. But I think this entire list of things, which is so evolutionary in nature, which is so dynamic in nature, which is why I think that basing your decisions solely on a legal precedent and solely on a set law framework which exists probably is not the best way to go for it. And by that, I don't mean that our existing competition frameworks are not adequate to deal with these markets or to deal with these problems. I completely confer with Mr. Chaudhary and also with you when we talk about and when we say that our frameworks, our existing frameworks, whatever we might have in place, are adequate, at least partially adequate for us to be able to, in the nascent stages that we are in, deal with these sorts of issues. But I think when I talk about the fact that CCI is taking an ad hoc approach, what I am essentially trying to say is that it's not apples and oranges, according to me. I think the fact that probably the competition regulator of the nation was unable to identify the fact that probably lack of evidence or lack of facts or whatever it might be, that in the WhatsApp and WhatsApp Pay case, that there was an inability of the regulator to see that this could have a potential adverse effect, which, to be very honest, I think was very immediately seen in the WhatsApp privacy policy case. So I think that linkages that become very, very necessary in these kinds of economies and in these kinds of technologies that we are dealing with, because of which I think it's not apples and oranges, because of which I think the intervention that I made earlier, that these companies, they have entered the digital economies from one aspect, but now the acquisitions or the agreements that they've had, the way that they're moving through the market, through the supply value chains, going into different markets, going into different streams, that doesn't make it apples and oranges anymore. It probably makes it apples, but maybe of different states and different regions, but it is still apples and only apples. Coming to my next point, I also think that because it is so dynamic, because it is moving from markets to markets, from maybe sectors to sectors, where probably something that we are not even realizing just now, I think we've read that all of these big tech companies are now going to enter the medical space. So we need to understand that moving from a search engine, a social media engine, to a medical space, we need to first regulate where they started with. We first need to regulate their roots. We first need to regulate that point of that inflection point. We need to identify that inflection point which gave them that power to, get into all of these subsequent markets, whether they are related or they are not related. Because of which I think that sticking to the black and white letter of law in such situations, in such circumstances, is not the most efficient way to go about it. It's probably not the most adequate way to go about it. And when I say this, I don't mean, I completely agree with Mr. Chaudhary that we don't necessarily need a comprehensive amendment to the competition law framework. We most definitely do not. However, what we do need is for the regulators to understand and to interpret the existing framework that we have in the best way possible. And that interpretation, I believe, has to stem not from a point of view or a perspective which looks at the existing scenario. What now we need is to have a vision. What now we need is to have a futuristic approach, a futuristic perspective, where we understand that giving this decision today is going to have this effect 10 years down the line, or maybe not even 10 years down the line, 2 years, 3 years, 5 years down the line. And I think that is why we need to go beyond the black and white letter of the law and maybe look at the spirit. So I think when we're talking about the purpose and the aim of competition law, the Competition Act states that it is for to ensure free trade, it is to ensure consumer welfare, it is to ensure economic growth and development. All of these things are as dynamic, all of these purposes and aims in their spirit are as dynamic as these digital economies or as these new technologies are. In that sense, I think also this also brings me to my next point, that when we were Mr. Chaudhary and I think Mr. Sharma also talked about perceptions and how consumers view these markets, because of which then that sort of impacts how the economic analysis is done or how these decisions are made. I would disagree over there in saying that is what should be done, but I don't necessarily believe that is what is actually happening. Because I think when we talk about these digital markets, probably, and of course there is a very obvious lack from the point, I think, of information asymmetry, where we believe that the consumers and the end users themselves probably don't understand what and how these technologies function. But at the same time, the conduct of these businesses is no longer based on the perceptions of consumers. Rather, the conduct of these businesses is now manipulating the perceptions of these consumers. And I think that distinction is very, very important, because I think the moment we don't draw that distinction is where we fail to realize that there is a huge difference between the traditional economy and the digital economy. Of course, I again agree that our traditional economic principles, our traditional competition law principles are adequate. I agree that first principles are important. But again, the interpretation and the way we implement these first principles, the way we look at our traditional frameworks, they need to change. It needs to become more visionary. It needs to become more futuristic in our implementation, in the way that we do things. Again, I think Ms. Napina,
Saki, if you could just also turn to my question, because I think then...
Yes, of course.
I mean, you can use it in your closing remarks also.
Yes.
Yeah, sorry to interrupt.
No problem. I was just getting to that. So I think there was, this, when we talk about tacit collusion, when we talk about certainty, when we talk about following precedents, I think that is exactly where going, not against that, but I think what needs to be complemented, alongside using laws, the existing legal frameworks, the existing precedents that we have, is research. And I don't think I can emphasize the importance of research anymore. And to be very honest, I'm at a very, very modest stage of my career. I've just started working. I have, just entered into the entire think tank research institution space. But I think in this very, very less time, it hasn't taken me a very long time, even in this short duration, to understand the importance of research, to understand what is the importance of these independent, individualistic think tanks. And the reason I say that is because the moment I am sitting and reading, and the moment I am trying to understand how these markets function, I am also trying to understand from a very systemic approach, from a very systemic point of view, that we need to go beyond what we already have. What we already have is not bad, but we need more. And that more has to be research. Just giving a very brief example, I think, and this is something I think that even a lot of competition agencies have not fully understood the grasp of. And that was very, very evident at, I think, pretty much around the same time last year, when we were seeing all of these competition agencies allowing collaborations between different firms and different companies to combat COVID-19, to allow to fill the gaps of the supply and demand deficits and all of that, especially with related to essential items and medical supplies and PPE kits and so on and so forth. But I think even then, so I think that was when we at Cuts International, we wrote this paper and we sort of conducted this survey with competition agencies worldwide to understand what kind of collaborative agreements, these competition authorities are allowing competitors to get into. And the lowest, or rather zero leeways were given with respect to R&D. And I think that is very, very, that's sad, right? Because I mean, given the COVID times, and I think the COVID times are probably, it's a similar framework, it's a similar approach that we need to have when we deal with these digital economies. Because the COVID pandemic has been as new and as novice for us as the digital economies and these new technologies are. And we are seeing that it has been a lack of research, or probably a lot of research, which has helped us during these COVID times to understand what works and what doesn't work. Of course, research is not the only thing. Research has to be complemented by implementation, which is where I think think tanks come into play, who also, undertake these independent surveys, they undertake studies, they actually go on ground and see and talk to people that, if this is a policy, how does it affect you? Or if this is not a policy, would you want it to be there? So on and so forth. And so I think research, as important as it is, I think the role of think tanks is much, much greater, because think tanks are not restricted to research. There's advocacy, there's dissemination. You go and you talk to consumers. You go and you spread awareness. You talk about the importance of not only governments and businesses doing their bits, but also consumers knowing that this is what should be happening for them and this is what they should be doing. So I think I will just conclude by saying that, I do belong to the millennial age, and I will definitely agree with you, Ms. Napanai, that for us, at least for me, the liberation that we have as of now is not enough. But the only and only reason for that is because I truly, genuinely believe that the entire space around me is liberating at a faster pace than we can even fathom, that I can even begin to fathom. And so I think the moment we get, we get satisfied with the level of liberation that we have or that we are trying to achieve, it might be a disservice to the environment around us, to the economies around us. And I think that is where I will end my intervention. Thank you.
Thank you, Saki. Very briefly, Rahul, we have almost, I have one question for the entire panel, but I'll just give you a very it's not technically within our panel's mandate, but you are a cyber security specialist. So I want to just throw in a question there, because we've been talking about cyber law, we've been talking about data, of course, the panel looks at economic decision making, but what is equally important is protection on cyber security from that point of view. So if you could quickly add, as we evolve, as the regulation in these areas evolve, are people forgetting about cyber security because you've worked at the policy stage, you've worked with think tanks and research bodies like. So very quickly, Rahul, I can give you just 2 minutes because we have a list of questions, and I have one final question for all the panelists.
All right, thank you. So I'll divide 2 minutes into 4 parts of 30 seconds each, and answer all the different aspects I wanted to cover. So first is as Napina mentioned earlier about the changing language and the vocabulary of this new space, and how does it translate into judicial understanding, and how when the laws and policies are framed, they may have some spirit, but in terms of how it is understood, or how the lawyers make judges or clients understand, it may have a different interpretation or meaning. So in that case, those language, those principles, I agree that we have the foundational principles that can be applied. But if you look at, given this space is so rapidly evolving, I'll just take an example of, the liability of an administrator of a chat messenger group. We have had numerous court judgments which say admin is responsible, not responsible, is responsible, not responsible. So, we keep on fluctuating on those things. Because it's a new thing, because we do not understand it very closely enough. So we have conflicting views, even if, we are trying to apply the same principles in some cases. So that nuanced approach is very important. And now I'll just jump to the second part. I think which you initially asked, but I did not cover, on the aspect of data and the privacy, how the privacy and competition interface. By default, privacy is a fundamental right, and the economic principles, the competition principles should not trump the basic principles or the basic human rights of the individuals. But how do we make competition act in a way and apply those principles that there is an increasing competition, and if there is an increasing competition, there are lesser monopolies and lesser chances of increasing concentration of powers and abuse of personal data. So that from that viewpoint, I think on how these things interface are very important, and so is the interface between the regulatory authorities. We have specialist regulatory authorities. The DPA will come up once the data protection law is there. The Competition Commission will have its own say. So they will have interfaces, and that interdisciplinary learning, I think that's the way to go forward. And I hope that there is more that we can continue. And now to the last point on the cybersecurity. I think cybersecurity is the underlying thing. So I don't think that people have two different ways on cybersecurity, unlike privacy, we have different views, nuances, cultural views, understanding on how things are. Cybersecurity is the need to protect data and how it can be protected using tools, techniques, procedures, and different techniques that can be applied. So from that viewpoint, I think the stakeholders, it's very important. I won't say that we have got the due attention it deserves, but the circumstances itself are leading us wherein we have no choice but to give them careful consideration, be it be increasing hacking or espionage, or all those things are making us more aware and inherently insecure that we have to have this baked into consideration when we design policies. Thank you.
Thank you, Rahul. So I have this last question because we have like 3 or 4 good questions that have come from the audience. So like my last question, and anybody can comment on this. This is something that has bothered me for a very long point of time. And I wanted to know your opinion about it. Do you think that the people who become the bureaucrats or the lawyers who become a part of these regulators, or the people who become judges in our courts, which primarily recruits from the practicing bench, do you think that allows appreciation of economics in the judicial decision making? What I'm trying to suggest here is that unlike a United States, you will not find a practicing advocate or a practicing lawyer or a professor of economics who will become a part of the Indian Commission. It hasn't happened yet. It may happen in the future. You will not find a professor becoming a judge at a federal or a high court or a Supreme Court. Although there are provisions of appointing jurists to the Supreme Court, that has never happened. Do you think that that kind of also hinders this movement towards appreciation of research? Again, I am not suggesting here that the Supreme Court is blind to research. The decisions of privacy and nowadays, and all of those routinely quotes from researchers and articles, that is a recent trend of the Supreme Court. But I think there could have been much more. Do you think that the recruitment through which our judges come onto the courts, or our commissioners or our members of the CCI become members, do you think there is a problem there in terms of appreciation of economics? It's an open question. Anybody can pick it up.
If I go first, the basic challenge, if I'm now talking about, I was from the judicial service of the state. I know how difficult it was to really stay on the judicial service, because there was a quota in the High Court. Practicing advocates would be automatically elevated to the bench. So a judicial officer, however he may have started his career at the age of 21, 22, would be languishing during our times. So I had decided to quit. So that is one answer to your question straight away. And I'm not bragging. I was topper in my batch. I was doing very well. During my lifetime in one station, I could get a High Court order confirmed, yet I left. So that is first answer to your question. Second, coming back to the CCI, it's an institutional memory loss. The moment a retired bureaucrat or a person is given the mandate to work on a competition law, he is already around 60, 61. He may not have even known what a competition law is during his entire academic career and bureaucratic career. Even as a professor of law, you know that competition law is still an optional subject or a credit course in prestigious National Law School in India. When I was in CCI, we tried through our advocacy process to impress upon AICTE and UGC to introduce competition law into the law curriculum. Till date, it is an optional subject. Even Bar Council of India put down their hand saying, no, MRTP should continue. So I think I have answered your question. It's an institutional memory loss. It's a problem.
Thank you, Manas. Anybody else who wants to have share their views? I completely agree with, I would want to see people like Professor Bhattacharya of the Delhi School of Economics, or, some of the leading partners of Indian law firms, not only on CCI, on other relevant regulators. I think the bureaucratization of regulatory bodies, I do find has been a challenge, and as we are evolving and as the regulations are touching new areas of law, which is itself in its nascent stage, I completely agree with you, Manas. That
one point, Aviru, I wanted to share with all of the panelists and this audience. Right from the time the Competition Act with only a 64 or 66 sections legislation, it has been amended many a times. Besides, CCI has been coming up with the statutory regulations almost every year. We have always been in the part of the competition law amendment group. And I, for one, being a lawyer, always advocated under Section 35 of the Competition Act to introduce economist who should be appearing before CCI with the Economist report, and it has always been turned down. That is not the case in European Union, neither it is in the US. So if we are mimicking the legislation from the West, why are we not taking economists as part of it? And since economists are not statutory part of the Competition Act, the Economist report invariably forms an annexure to the paper book, and that never gets the light of the day, either with the CCI or with the appellate tribunal, or for that matter, anybody else. This is a very, very sad state of affairs.
So, on a lighter note, I would also like to add that, there is also this lawyerization of, I am sorry that I'm speaking this panel, but this lawyerization of the policy-making process and the regulatory bodies, it's looked at primarily from the lens of law, legal principles, applicability. I think that also needs to change. We need to have more multidisciplinary people, not just economists, but from different walks of life, different experience levels. It needs to be more diverse to have a more comprehensive outlook and framework. Else, if it will become a cycle. If it gets dominated, then it becomes monopoly, and that is what Competition Commission is sort of trying to stop.
So one thing, Rahul, I would just, sorry to interrupt. End of the day, every judicial authority is the final authority wherever you go. It is European Court of Justice in the EU. It is the Federal Supreme Court of the US. It is the Supreme Court of UK. It is the Supreme Court of India. The judges would always believe upon the principles of law. And how do you lead evidence? If you are able to lead evidence on economic principles well, why should a judge disagree? Unfortunately, the part is that the economics are not able to relate the things into a robust evidence. And the judges would not be able to just go on to theories, graphs, charts. They will not be interested in doing that. They would like to understand how the harm has been caused and how is the remedy being suggested by way of an evidence. If that is not there, the judges cannot be asked to be imaginary poets. It's not possible.
Well, from my perspective, I'm all for diversity. In fact, when the second round of the NJSC case was going on, Justice Kurian Joseph, who was then a sitting judge, spoke about this issue, that there is a scope for jurists being appointed as judges, and he questioned why this was not being adopted. You have judges who are moving from lower judiciary to higher judiciary. You have lawyers being moved from the bar to the bench, but why is it that jurists are not being done? This question itself is now nearly 5+ years old, but it's not yet been addressed today. But then when we talk about diversity and the bench, we are also in the midst of a lot of controversies in terms of what are the other aspects in which diversity is not there, including gender. So there is a long way to go when we talk about diversity on the bench and why it's needed, but just to bring another lens to it. Be it policy making, be it judicial decision making. It's not like experts are not involved. To say that they are not involved would be very myopic or would be very simplistic. So we have a process even in judicial decision making, which ensures that you will be involving experts in it. It's unheard of that in the apex court, a non-lawyer will be called upon to represent. In a way, that's what happened in the Aadhaar case. The CEO of UIDAI was allowed to represent before the court because the court wanted to hear experts from other fields also, right? So the apex court has set the pace to show that where necessary, the courts need to involve experts. Amicus curiae is appointed because where in a matter court believes that an expert opinion or an expert intervention is needed, they will be involved. I'm appearing as amicus curiae too in one of the matters before the Supreme Court. So it's not like we do not have a process which involves experts. It's the mode and manner of involvement. In fact, if I were to take a contrary view to what Rahul said, I would say the Information Technology Act suffers because it went more with the technology experts than with the legal, which is why it fell very weak on legal constructs. So therefore we need to balance everything out. And this is where I will link it to Saki's intervention to say that it cannot be looked at with such unidimensional lenses. You'll have to apply a multidimensional lens whenever you're looking at any form of decision making or anything that is going to impact a larger public good aspect. You know, we are today talking about public good and data protection laws. And we are already evaluating how far it's going to impact both in terms of an economical perspective and also the welfare state perspective. So when I spoke about the my generation versus the millennial generation, and by the way, I believe that I'm a millennial too, because I may belong to the 60s. There, I gave away my age, right? I may belong to the 60s generation, but I adapted. I was the first adapter to technology laws when people did not even know the word technology or cyber. So therefore, in that sense, a millennial is not in an age, it's in the mind, you know, and how you think and how you are willing to adapt, willing to evolve, and willing to evaluate and assess the situation as it evolves and not be stuck, you know, in the mud, not be stuck in concrete. Law is also like that. When we talk about dynamism versus certainty, and this is where I truly believe that the legalization of policy making is important. But what we need is actually practitioners coming into policy making, not just looking at it in a very simplistic way because of this delineation which gets lost in policy making, which is that certainty does not mean getting stuck in concrete. Certainty means ensuring elasticity and dynamism in law in such a way that it evolves to embrace technologies, situations, requirements as it is today, but is dynamic enough to adapt to evolving technologies and situations 20, 40, 100 years down the line. If we have laws which have adapted and are still robust, still capable of being applied, considering 100 years of phenomenal and exponential change has happened in our lives and technologies and everything that's happened around us, that is what dynamism is all about. And for this is my takeaway for anybody involved in policy making. Do not make something which is too myopic or too immediate. Dynamism has to go hand in hand with certainty in such a way that you retain first principles. For instance, I'll just explain it in more specifics. You can't have open-ended provisions for criminal laws. That is contrary to criminal jurisprudence. It has to be precise. Whereas you can have purposive interpretation and therefore open-ended provisions for civil, you know, in terms of applicability, but not on liability. So this is where the nuancing happens, and you must be able to apply your mind, keep it open to open out legislative processes to take into account the economic requirement with the welfare state requirement and balance both. But to say that judicial decisions should take into account these things is giving the right of legislative processes to the judiciary, which the judiciary does not have. Judiciary has to work within the parameters of law laid down. And I stand by what I said earlier and do reiterate that I am taking a contrary view from Sakis in that, because it's not just about not being able to do something. It is inappropriate when somebody says judiciary is supposed to take a decision based on economics rather than the law as it has been laid down or legal frameworks. It's inappropriate and it's impermissible. That's the way rule of law works, and we can't go beyond the rule of law here.
Thank you, Ms. Napinai. I don't think anybody else wants to say something. We've reached almost towards the end. I have 5 more minutes left. And I have a few questions which I want to, I'm using my moderator's discretion of not kind of referring to all the questions because there are a couple of them. I think I will read out the question, and anybody who wants to pick it up might want to do that. Recently, a retired Chief Justice of India contended the need for artificial intelligence in justice delivery, whereas on the other hand, the institution is suffering from its own structural and functional problems. Do you think need for artificial intelligence is a kind of ill-placed priority for the institution? Anybody who wants to take this question, do you think artificial intelligence, or for that matter, the way Justice Chandrachud recently presided over a more open and a more delivery of the judicial system, in the times of COVID or even without it, given that amount of deadlock that we have notoriously, do you think artificial intelligence or technology should be welcomed into judicial decision making? Yes, Ms. Napana, you can begin, and anybody else can chip in.
So, one of the earliest times when I had proposed technology in law was in 2004, and at that point of time, it was considered a little ahead of time. So you take not just artificial intelligence, you go beyond just e-courts and virtual hearings, as we have actually survived over the last couple of years, a year and a half now through COVID, to ensure that justice delivery doesn't come completely to a standstill. Adaptation of technology is a sine qua non for judicial justice delivery today. Be it AI, be it blockchain, be it any of the emerging technologies. I personally believe blockchain is one of the most adaptable technologies for ensuring, effective evidence delivery for judicial decision making. On the aspect of use of AI, I just wanted to clarify one thing. We are just catching up, and I'm so glad that the Supreme Court has limited the use of AI to just a supportive tool, not as a supplemental tool. What I'm trying to emphasize is that the US adapted this technology compass to assist it, for instance, in sentencing. Okay, and the ProPublica published a report which showed clear bias in this process of recommendation of sentencing, where it was a clear racial discrimination, etc. So when we are adapting technology, we have to be careful in terms of what is it that we are adapting it for. Today, when you're deciding a liability claim in terms of autonomous vehicles, the underlying issue that every court, be it US, Europe, or wherever it may be, says is humans cannot be replaced by technology. The human behind the wheel still has to take liability. Similarly, when you're adapting technology to judicial decision making, it cannot supplement judicial decision making. It can be a supportive tool, for instance, where here it is supposed to help in terms of research, in terms of, if you were to use blockchain to show accountability, transparency, and immutability in terms of filing to the passing of orders, you can actually root out corruption from judiciary. So there is a way in which technology can be adapted, and it should be adapted. We cannot sequentialize adaptation of technology to say we have much more important problems. We always have much more important problems. Even today, from 80 years back or 70 plus years to make it more precise, to now we still talk roti, kapda, makan. But that doesn't mean we also won't talk about emerging technologies and the relevance of it to public, right? So we need to balance both out. And on the e-court aspect, one of the most amazing things that the Supreme Court took up was the e-court project, which was originally under Justice Madan Lokur and now with Justice Chandrachud. It has been doing a phenomenal job of connecting all the courts, correlating decisions. That also helps in, again, what we've been talking about. I am at least very consistent in my opinions and saying about certainty also. So this kind of e-court project also again helps in terms of certainty, in terms of decision making, irrespective of which court. I mean, this is a utopian mean, which is something which can be possible through adaptation of technology. So I would definitely say we cannot eschew technology. We need it. but we have to be careful in terms of where we adapt it and not allow it to supplement the human element.
Virup, just a brief point here. So I think completely agree that that use of technology has to be embraced, and I wish that we would have hoped that courts would at least live stream all their not non-sensitive cases at least, so that people can view how things are. For people like us, it's completely a black box on how things are unless we have to go to a court. There's an opportunity, we have to use technology, and the ultimate aim, as ma'am initially said, that we have to remove the individuality in terms of decision making, so that we institutionalize this, and with the use of technology happening more and more, I think there will be more and more standards and uniformity across different cases. So that, and also important that we the biases, as ma'am was mentioning, that we should be very careful that our biases are not reinforced through various aspects of the algorithmic decision making or the artificial intelligence, as we say, in the criminal justice system. So because that gets built on over and over, and that becomes like that gives a lot of problems. So yeah, like use of technology for good, I think there is no two ways that this has to happen and must be embraced. Yeah, I'll stop my intervention. Thank you.
I think we've reached the very end of our discussion, and there were interesting questions lined up, but I've been told that the next panel must start in time. Thank you everybody for having such a wonderful and diverse opinion on this panel. We disagreed, we differed, and that's what as lawyers we're supposed to do. I conclude by reminding us, I know Rahul, you're not a lawyer, but the rest of us are, so, and it's a panel on economics. So as Justice Brandeis had said many years ago, that a lawyer who hasn't learned economics is apt to be a public enemy. I think not only there is lawyerization, as you said, but as lawyers, we should also open up to more schools. And as Ms. Napinai was suggesting, continuously learn and apply those learnings to the arguments that we bring either in our research or before courts in terms of advancing the cause of our client or the cause of the work that we do. Thank you everyone for a wonderful panel. I only hope that you and your loved ones remain safe in the situations that we are currently struggling with. Thank you again. Yes, Srijit, I think.
Yeah, thank you panelists. Thank you, moderator, and thanks to everyone connected to us through JGU's YouTube channel. It was an insightful and vibrant session, but we have come to the end of it. Our fourth technical session, an economic analysis of industrial innovation and intellectual property, will commence at 3:55 p.m. Please stay connected or tune in at 3:55 p.m. Thank you, everyone.
All right. A very good afternoon to all of you. My name is Ashish Bhardwaj. I'm the Dean of Jindal School of Banking and Finance at OP Jindal Global University. I welcome you back to this wonderful session. At the outset, let me say that it's, of course, a very difficult and incredibly challenging time for everyone. But our hearts do go out to all those who've not been able to come out of this crisis. And we do hope for a speedy recovery for those who are currently battling the COVID-19 pandemic. Given the current circumstances, we are streaming this conference, this session live on our Facebook page. So if you're still trying to figure out where to watch, where to log in, please look for Jindal Global University's page on YouTube. With that, let me extend a very warm welcome to all the distinguished speakers of this session on the theme, an economic analysis of industrial innovation and intellectual property law. I'm very happy to welcome the moderator of this session, my good friend and colleague, Professor Vishwas Devaya. He's a professor and vice dean of Jindal Global Law School, and he also serves as director of Center for Postgraduate Legal Studies. Vishwas has been a managing director of the Jindal Global Law Review, and he's widely published in areas of patent law, innovation, health law, and biotechnology law. I also welcome all the other speakers who've taken the time out to attend this session and share their views. Mr. Shubhamoy Bhattacharya, consulting editor, the Business Standard and adjunct faculty at Jindal School of Journalism and Communication. Dr. Mohan Diwan, who's principal, RK Diwan and company. Mr. Ujjwal Kumar, policy analyst, Cuts International. We are hosting this conference jointly with Cuts. Professor Yogesh Pai, who's with National Law University, Delhi. Professor V. Ranganathan, former RBI chair professor at IIM Bangalore. And what a delight to host all of you for this session. Vishwas, the stage is yours.
Thank you, Ashish. Thank you for that introduction. And as most of you would know, that the session is largely looking at an economic analysis of industrial innovation and IP laws. It's almost a cliche to say now that IPR was one of the primary engines that drove the industrial revolution in the late 18th century. 18th and 19th century. And IP has since then been one of the prominent areas where governments of various countries, initially in the West, and more so later on in the latter part of the 20th century in a number of developing countries, it has garnered a lot of attention in terms of what can we do to kind of facilitate innovation. And it seemed like for a lot of countries, the recipe was to kind of have a favorable IP regime. But having said that, IP has also kind of produced that kind of tension where there are points of conflict, more specifically with respect to questions of monopoly being exercised by IP holders or right owners, vis-a-vis access, be it in the form of knowledge, be it in the form of medicines. Now everyone can relate to the situation as far as the COVID situation is concerned. So there's an entire debate. I'm not saying that's exactly an IP issue, but there's an entire debate related to IP and access to medicine. So there is a larger, private ownership of innovators vis-a-vis conflict in terms of access to materials that have been created by them. Now, if you're looking at the Indian IP regime itself, to give you a context, India kind of inherited its IP regime largely from the British. Our colonial masters had IP regimes in the form of copyright law, patent law, trademark law, even before we got our independence. When India inherited its patent laws, there was an inherent tension in terms of, it was not more specifically to do with the patent law itself. It's rather the concern in terms of how companies use the patent laws in terms of, we had a thriving pharmaceutical industry, but that pharmaceutical industry was not necessarily run by Indian national companies. They were largely run by foreign companies who were situated abroad. They did have their business in India, but largely kind of chose to manufacture outside of India. And as a result of it, because of non-working of the patents in India, it did raise concern in terms of pricing, import duties, etc. At some point in time, we had a gentleman from United States, a senator, who came to India, who visited India, and kind of actually Senator Kiefer kind of visited India and kind of made the statement that for a developing country, India's pharmaceutical prices were really high, comparatively higher even to a lot of developed Western countries, which pretty much kind of triggered the Iyengar committee kind of coming into play at a later point in time. Iyengar committee, of course, took a fair bit of time to actually come out with a report. And as part of some of the observations made in the Iyengar committee report, the Indian government at that point in time in the 1970 decided to amend the patent law, largely to kind of encourage Indian generic pharmaceutical companies, what you could possibly call as the first phase of Atmanirbhar, right? So in essence, of course, we had our generic pharmaceutical companies, largely kind of innovating as far as processes are concerned, but largely kind of lagging behind when it came to product-related innovation, given the fact that the patent law pretty much kind of discouraged or did not kind of protect product patent regime for pharmaceuticals and chemical fertilizers. Now, the 70s and the 80s kind of threw up a scenario where you had, where the Americans called the Indian generics as the paper tigers. They called it the paper tigers primarily for a good reason, because these were pharmaceutical companies that were largely kind of, reverse engineering product patented stuff in pharmaceuticals, and were able to not only kind of meet the domestic needs in India, but also to kind of, compete with multinational pharmaceutical companies in Asia and other parts of the world as such. And of course, you had, by the late 1980s and early 90s, you had the WTO round of talks, the GATT round of talks happening. And as a result of it, the TRIPS was actually kind of slipped in. TRIPS is nothing but, a set of agreements related to intellectual property rights, which was brought in as an annex to the WTO round of talks. If you didn't kind of want to be part of the if you didn't agree to the TRIPS, you couldn't be part of the WTO regime. And as a result, intellectual property rights as part of the trade regime was largely kind of inserted through the TRIPS regime. And any country which was part of the WTO had to accept it. But of course, India, might come as a surprise to a lot of people abroad, played a much more important role in carving out the flexibilities related to intellectual property rights when the TRIPS regime was actually being negotiated. India flexed its muscle along with a lot of developing countries like Brazil, Argentina, South Africa, to kind of bring in certain flexibilities within the TRIPS norms. And when the WTO regime kind of unfolded and TRIPS had to be kind of implemented, India and a number of other developing countries wanted to exercise a lot of these flexibilities. And it's at that point in time, or at that juncture, more specifically Brazil, where it intended to kind of exercise some of these flexibilities when it came to pharmaceuticals. There was a large scale kind of, bashing of developing countries, which they were even blamed that you're taking the easy way out in terms of actually exercising the compulsory licensing route. And of course, a lot of African countries, a lot of them which were part of the third, the yet to develop kind of economies, were forced into a situation where they had to kind of agree to TRIPS plus norms, right? regardless of all these flexibilities within the TRIPS norms, India as a developing economy has so far exercised its compulsory licensing option only once. We've been very careful in terms, and also wise in terms of where we use those compulsory licensing provisions, right? But it's not enough to kind of say that we've played a stellar role internationally in terms of setting up a TRIPS regime itself, negotiating these flexibilities. But what have we done internally? I mean, like I said, the 1970s brought in the Atmanirbhar regime in the form of our pharmaceuticals becoming self-sufficient, pharmaceutical companies becoming self-sufficient, but we've not invested enough in terms of innovation. And if you look at the figures, our R&D, investments in R&D is pretty low. It's something to the point of 0.7 as far as the 2016 data points out, whereas developed countries like US, Japan, etc., have anywhere between 2.8 to 3.6 as part of their GDP that is being invested in research and development. And that seems to be one of the major problems plaguing the Indian industrial development. There's lack of innovation, there's lack of investment in research and development, and that seems to be one of the primary problems that seems to have actually kind of created major problems for India in terms of having an impetus for its industrial economy to actually grow. Now, apart from this element, India was also kind of challenged because of the entry of number of multinational companies coming into India, bringing their products. There's been a major, raise in the number of IP litigations. There's in the past, I mean, I can stand corrected. Dr. Mohan Diwan is here. He can point to me. I'm compared to the 1980s, the number of IP litigations in today's time is much more, right? We've had a huge increase in the number of IP litigations, and therein comes the legislative framework, the judiciary, the enforcement aspect of IP, and that seems to be an area of concern. Not in terms of whether at all we can actually get a decision from the court, but the problem lies in the fact in terms of how many years does it take for these decisions to come into play. And one area where we ourselves have been invested is in the area of standard essential patents, where we've actually figured that empirically speaking, a lot of SEP related decisions to even get an injunction takes about 4.5 years. An average of 4.5 years, right? So this is an area of concern in terms of we do have the legislative instruments that can protect intellectual property rights. We do have a judiciary that is, especially the higher judiciary is fairly well versed in terms of IP and IP related laws have actually been laid out by the Indian judiciary as such. But there are certain concerns in terms of the duration it takes. The enforcement aspect of it has been a matter of concern. And as a result of it, we've also seen in recent years, especially in 2015, when the Parliament enacted the Commercial Courts Act and recognized intellectual property to be one of those subjects that should be part of the commercial courts, we don't seem to have seen any action on that front. And it's a matter of concern for all of us who talk about intellectual property right and the role of IP, especially in shaping economies as such. So this particular session is going to focus on some of these inherent tensions and concerns related to IP and IP regimes in India. So let me first begin with the first question to all the panelists. And that question is a fairly, it's not something that is, if you're an IP specialist, not something that you haven't heard. It's a question that often crops up. How can we achieve a balance whereby innovation and wider access to such innovation are at the optimal level? Any of the speakers?
I'm Ranganathan. Can I
Please
start?
go ahead, sir. Please go ahead, sir.
First of all, I'd like to see the place of innovation in the context of invention. You see, earlier we had the two words invention and discovery. Discovery is something which is already there, you discover, and invention is something new you have discovered. Now, I would say that innovation is a small subset of invention. Now, innovation comes very, spontaneously, and it occurs to individuals, and also it brings in large benefits, which may not be obvious immediately, but over a period of time it does. Whereas innovations ride on inventions, ride on inventions, and they try to get smaller things, and most importantly, they are processed by corporates, profit-seeking corporates. So, as it were, these corporates are the gatekeepers for this benefit, taking the benefit, and the large benefit that the invention gives is extracted by the innovations. You see, it is as if the innovation is having a large externality and it is being extracted by them. And therefore, there is a question as to how much should the corporates get? What is the proportion of their effort and what's the proportion of their reward? Okay, so I think I would stop at this point.
I'd like to make some comments on this.
Please go ahead, Dr. Diwan.
Because
yeah, please go ahead.
I think innovation is a very misunderstood term. The whole concept is the I's that start. Everything starts with an idea. The first aspect is the idea. When you write down the idea onto a technical idea, if it is a technical idea, when you write it down, then that could possibly become an invention. Now, invention is something that is created generally, what Mr. Ranganathan rightly said, can come into the mind. It is the universal intelligence that sends this idea into the mind of an inventor. Now that inventor he may be a part of a corporate, he may be an academician. In fact, 90% of the inventions that we file are for single individuals, and a lot of innovation is very small term. There is the organization called Honeybee in Ahmedabad that is working on grassroots innovation. Now, innovation is the next level of invention. When an invention is actually worked, there are a lot of inventions that are not worked. Those still remain paper inventions. You may file patents, you may get patents. Even among patents which are filed, those patents it's not every invention that is worked. But an invention that is worked is what we call innovation. That is what in our textbooks or in our technical terms, an invention that is tried, experimented upon. Now there is one missing I between the invention and the innovation. Profit is not a dirty word, sir. Profit is not an abuse. If a corporate makes profit, it is because there is some level of investment. I have been able to merge a lot of academic inventions, a lot of inventions of single individuals with the help of certain investments. We have started incubator centers in various institutions, like for example, in Agarkar Research Institute in Pune. At IIT Gandhinagar, we have worked with inventions and various aspects. What is needed between an invention and an innovation is another I called investment. Mostly many inventors, there are some inventors who are lucky who have the funds, but mostly inventors don't have the wherewithal and the finance to convert an invention into an innovation. And that is where a certain level of, it may not necessarily be corporates. There may be angel funding in most of what we call startups and SMEs. We have funding venture angel funders, venture funders, different types. Some corporate funding, some level of corporate funding. These are the people that come in for converting an invention into an innovation. Of course, you only spoke of an innovation, but then ideas can lead to various other intellectual property, such as copyrights, literary works, musical works. Those are all they're not necessarily technical ideas. Designs, for example, another form of intellectual property. Trademarks is a fourth form of intellectual property. But what is needed is the investment. And when we speak of investment, that is an area. Sometimes we forget that you need that investment to come from somewhere. And at that point of time, there must be some sort of what the word you used, Vishwas, was balance. You use the word balance, and that balance becomes an important part of the whole game of, I would say, invention to innovation story. Of course, there is another thing after that, that is called integration. That is the last I that is involved in that. There must be a market for that innovation. There are some people who innovate. Many academics that come to us innovate for the sake of for academic purposes. But there must be a market, and these are the innovations that are picked up because I must integrate it into my business. The corporate or a funder or the person who starts his own business, there must be a market for that particular innovation. So that is what I wanted to say. If there are any other questions, I'd be glad to answer.
Can I request Mr. Shubhamay to kind of... You're muted. Yeah.
First of all, thanks a lot, Vishwas and Ashish, for having called me here. And I must say that it's much more enjoyable to listen and pick up tips rather than to speak, especially among a nice, good set of people who really know the subject. My point is that, I can understand where IPR issues are now coming in, but in this middle of the pandemic, as Vishwas pointed out. But I would say that there's a bad time to frame the questions. See, because the relaxations that will be needed now on IPR would not heed much on the technical need of it. It'll more be an area issue of a global commons, which will therefore ask for a political solution. So what will happen now in terms of relaxation on IPR, I don't think will be decided by the legality of these issues in terms of the pharma sector. Also, while we are talking about the pharma sector, one of the first things that I would like to say is that the pharma sector has very strongly impressed our thoughts on the IPR sector issues in India. The pharma sector has been a one-off story. There is no other sector, when I've researched it, to find a similar causality on IPR that is affecting it. So to predicate our pharma sector And as I said, the decisions on IPR issues on the pharma sector in the current round will be a political solution, not a legal-based solution. I mean, not because India is presenting a stronger case. India has been presenting a case, but what pharma sector shouldn't be looked at as the prism through which the IPR issues should be evidenced. What I think has been a problem has been that we have left the institution building on IPR away, or rather discarded it in the wrong hypothesis over the decades that we can't afford it. And it is actually something which will hurt, I agree with Mr. Diwan, that will hurt the development. There'll be more profits, somebody will be cornering the profit. As a result, the intellectual ferment or the intellectual understanding of IPR has always been they versus us. And this has been a big challenge for us, for innovators, as Mr. Ranganathan was pointing out, or inventions going on from there, to be able to understand the strength which a robust IPR regime does to innovators. We have not understood how to exactly get around the problem. Let me give an example. The National Research and Development Corporation was set up in 1953 to exactly do this work. The government said, I don't want IPR. I don't want this to get into this meddlesome problem of IPR. I will instead create my own path. And we created this organization. This organization today has a total turnover of just 112 crore. That is it is just written and converted on 60 patents. That's all in the last 1 year. I mean, it is the national organization which was supposed to be shepherding, spearheading their patent regimes in India. Why is it, if we look at its annual report over years, why is it that this organization has failed so blissfully? And the reason for that is that we sort of looked on IPR as an area which we don't want to enter. So the institution building, which could have helped us, has actually not been pursued, and that is what we are now suffering from. That today, most companies which want to look at technology first look abroad, see if there's a possibility of getting it from there at a cheaper cost, and only then, if they can't get it, they try to sort of work out an Indian version of it. The fact that the Serum Institute is producing a huge vaccine is nothing to do with its IPR. It is simply a backbreaking, rigorous, hard job of producing the vaccine. In fact, it's rather Biotech which can actually somewhat claim that it has done some amount of work with the National Institute of Virology. But other than that, what has been the patenting work that has happened even during this pandemic among all the institutions that we have had? It has been, I mean, like we have had embarrassing situations. There are IITs have said, we shall be stitching out PPEs. I mean, come along. Does it take an IIT in technology to be able to create a PPE or face mask? But that is what they brought into the ministries to say that this is what we are creating. This is so ridiculous because it again harks back to the same question that we have not developed the institutional structure, we have let it go. So today, I talk of relaxing it is actually would take us back to the wrong position. Just one point, I think if I look at the startup universe, I'm getting a bit optimistic because the startups in India have been granted not too many patents, about 513 patents in the last 5 years. And in the economic survey of this year shows that startups have filed 1,000 patent applications. So I know that many startups show patent applications to show that, they have got, it eases their funding to show that they've got a patent under the belt. But I think that is where, if our startup universe expands, we shall see a much more happy development and flowering of our IPR network. Over to you, Vishnu.
Ujjwal, you have something to say about it?
Yes, before coming to the original question of yours of balancing, and since the round has gone to clarification on certain terms, I'll also like to share my thought on what is meant by R&D. They'll be taking the same, and you rightly pointed out that the investment in R&D is low in India. When I think about R&D, I think about R and I think about D. And when we discuss, and particularly in policy matters, I think we need to separate it. R has a slightly different dynamics and D has a different dynamics. In R, I see that there are largely two steps involved. First is Eureka, very simple. When you have that idea of Facebook that the answer has said, which can come out any time, and this R phase is largely driven by a scientific pursuit of a person or with a scientific temper, and then an idea comes, then he or she would like to test that idea in a laboratory setup. That is also part of R, the second phase of R. So when in the laboratory setup, the idea seems successful, then the question of patent comes, patent application comes, that should be patented or not patented. And after it is patented, then one is looking for how can this invention be developed or innovation packaged together for public good or for the goods that the products that public can use for industrial production. So the D part, the patent comes after R largely and before D, and the very use of patent here is that D is investment intensive, generally speaking, and so the investor would like to have some sort of exclusivity or some sort of guarantee that he would get it in return. So R is largely a kind of a university setup or the academic setup, and D is largely a private sector setup where investment comes and then patent is used as an instrument for technology transfer, I would say, from R holder to the D partner of it. And in medicine sector, I understand that the more than 70% of invention happens in the university setup, in the public sector setup, not in the private sector setup, public funded. So why India is not having that, I think is not because of patent or patent law, but because we don't have that R ecosystem here. Perhaps we have, in last few years, we have reached to in some sectors at least to that stage or reaching toward that stage. But largely speaking, in universities, the scientific pursuit person, the person with scientific temper, do not really get that kind of laboratories or kind of guidance from the professor or kind of encouragement. And that is why the individuals from India goes to NASA or goes to USA and because there is an ecosystem there. So this is the kind of theoretical aspect that I think upon, and I think that if we are discussing from the policy or the legal perspective, we should separate R and D together because both have different dynamics. And coming to the balance, I think both innovation and access are important, particularly in certain sectors like medicines or agriculture, seeds. And that's why you have more flexibilities in terms of health and agriculture. The balance would lie when we have a clear-cut objective in our patent law or in our PBR law or plant variety protection law. unfortunately, Indian patent law or perhaps many other patent law do not have an object clause. And we believe that we are made to believe that patents are granted to recoup investment. Basically, I understand that originally the raison d'etre was that patents were granted in lieu of you disclosing your invention to the public so that the science prosper and more innovation or more invention happens based on those science. So when in the objective it is inbuilt that you have to have invention and you have to have in certain sector like medicine and agriculture, you have to have access also. And in my opinion, the key lies to balance, and in Buddha's teaching the middle path. Don't have that much strict, I mean, of course, strict patent laws. What is strict is again debatable, but strong patent laws and weak patent laws. So somewhere I think there should be balance of competition and exclusivity, because competition also drives invention. Unless there is a threat of competition in the market, innovation may not happen. Monopoly situation, innovation may not happen. So there should be a balance of exclusivity and competition in the policy thought process, not in the more than legal. It should be the policy thought process and the objective of the law or the application of the law. And here I would like to stop. I think we should have other questions.
Thank you, Ujjwal.
Vishwas, I couldn't hear you.
Yogesh, can we have your opinion on this?
Oh, sure. Thank you. Thank you for inviting me to this exciting panel. Well, the way in which you framed the question, I thought there was some dichotomy between, you thought there is a dichotomy between intellectual property and public interest, and obviously you raised the question from the point of view of access. But let me tell you, I think the way in which we have conceptualized intellectual property as a private interest is itself a very way to understand intellectual property. Yeah. Because without intellectual property as a form of, consider it as a regulatory instrument, forget about all the natural rights and all the other kinds of naturalistic theories about why IP is necessary. Even if you think of IP as a regulatory instrument, that regulation is necessary because firms, when they compete in prices and output, can only reach to a certain extent, wherein after that there is a kind of saturation in the market. And to break that saturation, you need a form of interventionist regulation that are property rights, so that each one is able to differentiate in the market. And then because of product differentiation, etc., you then have another cycle of dynamic innovation. So you have one layer of innovation that is in static prices and what you call outputs, and another layer of what you call competition in innovation and product differentiation. And those cycles of dynamic competition is essentially in public interest, because if you don't have what you call an instrument like intellectual property to enhance that kind of dynamic competition, then you don't have any kind of what you call market as such. So let's take it from the other perspective in terms of access, and let's see. Let me take an example. Most recently, Bharat Biotech's success in terms of getting an indigenous vaccine, and luckily we got all the data right. Hopefully, when it is peer reviewed, the vaccine really proves effective. Because it was released as an emergency authorization. Not that I'm an anti-vaxxer, but having looked into what Bharat Biotech did with NIV, ICMR NIV, NIV provided an early stage support. Bharat Biotech did the D part, as Ujjwal has rightly mentioned. Now, the question today is, who is owning all the IP? Because everybody is now hell-bent upon Bharat Biotech trying to, they are asking Bharat Biotech to declare its IP in public domain. Now, what is the kind of IP that Bharat Biotech actually has? The IP that Bharat Biotech actually has in terms of undisclosed know-how and information in relation to how to actually manufacture the vaccine. Now, Bharat Biotech, for all that it is trying to do, is not able to raise up production capacities. And the government, now Department of Biotechnology, has nudged Bharat Biotech to license it to other players, at least in the form of contract manufacturing. So Panacea Biotech is the only company in India right now to produce it. Hafkind Institute, they asked and they said it will take them 1 year to start production of these Covaxin, made by Bharat Biotech. Now, what is the whole argument then? Oh, you as a state, you as a, an private entity that received early stage lab support from the state, you are supposed to give up on your trade secrets and other kinds of intellectual property that you may have. And I, to my knowledge, Bharat has not filed any kind of patents, otherwise it would have been in the newspapers everywhere. So my understanding is Bharat Biotech only has this kind of clinical data, and the undisclosed information and know-how in relation to how to make the vaccine. Now, what has happened because of this? Because of this, Bharat Biotech has now been under pressure to, sort of reduce prices. That is another level. Now, what I'm thinking of is, what is the public interest here? The public interest could have been actually to allow Bharat Biotech to charge in private sales and for the governments to take upfront purchases at the lowest cost possible, which the government of India is actually perfectly doing by asking Bharat Biotech to give it the vaccine for 150 rupees. Now, if that be the case, then this whole price discrimination model that intellectual property actually effectively allows a player to do in the market is actually helps public interest, because there are different levels of income. And if there are different levels of income who can pay differently, and if there are people who really need vaccines for free, then the government can definitely take it at the lowest cost possible. So I think this kind of cross-subsidization model should perfectly work. And instead of that, we are trying to push Bharat Biotech to open it up. But now the question is, even if it opens up its intellectual property, who is going to produce it? Because there are no BSL-3 compliant producers in India, and in many parts of the world, they are already overstretched. So I think sometimes when you ask these economic questions about intellectual property, they seem to be dichotomous, and I think that's absolutely not necessary in any context if you examine it from a very good economic perspective.
Thanks, Yogesh, for that perspective. So, taking off from that particular first question, one thing that comes to mind is, of course, we always have we had this question about 6 years ago, when the UPA 2 was coming to an end. The bigger criticism was policy paralysis, right? So one major question that we all need to ask is, if the innovation is not happening at the level at which it needs to happen, if R&D is not happening at the level at which we aspire it to, for a country that aspires to be a developed country, challenging major economies like China and United States, we need to kind of ramp up our R&D, we need to kind of increase innovation. So the bigger question is, what in terms of policy, or is there a problem in terms of policy, or is there a regulatory concern that we need to address in order to kind of, enable innovation to happen at a faster rate? So question to all the panelists. Maybe Mr. Ranganathan, Professor Ranganathan would want to kind of take a stab at it first.
Thank you. First of all, as one of the panelists had said, or rather had wondered, how come IITs have come up with face masks and PPEs? I want to endorse his idea that we just don't have a R&D ecology in our academia. In other words, to put it bluntly, we are a bunch of second-raters. That is partly an issue of status of the academicians, as well as the status of the monetary position. That's why if you look at IIT and look at and even IIM, both these institutions, they are known for their students who have a lot of global mobility, and they are not known for their teachers. So here we have to think and ponder this issue. Now, going from the Indian to even global level, even if I look at US, while the number of doctorates, etc., are overrepresented for India and China, but the number of people who get Nobel Prize is far fewer. Now, I can only explain this or hypothesize this by the Maslow's hierarchy of needs, where the Indians are satisfied with the basic needs and social needs. They don't go aspire for the self-actualization needs, which requires, research, concentration on research, etc. So I would say that it requires a lot more thinking of fundamentally changing the level playing field for the academicians. The Atmanirbhar has to come in terms of supporting intellectuals. Right now, ministry does not have a queue of who is good, who is not good. Okay, so doing it through the ministry would be a disaster. We are doing things like, taking one engineering college and converting it into a IIT, changing the name. Somebody, the Nigel Lawson in UK said, but just by putting stripes on a donkey, you don't make it into a zebra. So that's what we are trying to do. So the question which you had raised in terms of how do we encourage R&D is a lot of things have to be done. One more thing, even foreigners are able to exploit the Indians better. Through KPOs, we have knowledge process outsourcing in India. Now, why is it our own IT companies are not able to pick the best? The best of them go to the KPOs of GE and so on. So then, not only give them money, but also the job challenge. Neither of it is available in our Indian corporates. So first of all, they don't spend enough on R&D, as you had brought out in terms of statistics. And that is because they are very happy with the low-hanging fruits that they have. So they don't have incentive to move up the value chain. And that requires not just the craving for money, but for a craving for self-actualization, corporate self-actualization, if you will. That is something which you have to go into the domains of psychology, why Indians are not like that. I'll rest here.
Thank you, Professor Ranganathan. Over to Dr. Mohan Diwan.
Vishwas, I think I'm going to have to take an absolutely diametrically opposite view of what Professor Ranganathan is saying. And I would also retort to Dr. Bhattacharjee. I have the benefit of firsthand because I worked with, I am the attorney for NRDC. So I file patents for NRDC. I also file patents for the Serum Institute because I happen to be in Pune and probably I'm considered as one of the good patent attorneys in Pune. So I work with Serum Institute, I work with the National Institute of Virology, and I work with the with various academics. Sorry, that was just a background, and I did not want to, but I just wanted to say that I've got, I know the kind of research that is being done in academics. There is some seminal work, there is some excellent R&D work that is being done by IITs and the various universities. I believe we have, if these were channelized properly, we can have, I mean, there are just a few figures that I wanted to share. In 1992, the number of patent applications filed in China were 0. They started at 0 level. Today, they are the leaders in the world with 300,000 patent applications, which you are probably aware, Vishwas, that they are the largest number of patent application filers in the world. They reached that stage. We are still around the 50,000. We are talking about IP in patents, whatever, medicinal and pharmaceuticals IP. We are still around the 50, 60,000 mark. Every year it's between 50,000 and 60,000 number of patent applications, where the world is, we are speaking about a huge number of patent applications worldwide. But that does not mean that we do not have R&D. We have an excellent R&D. But the issue is not that what the R&D is, the whole purpose of the R&D that is here. Every person aspires, the R&D people, the technical people aspire that their first haven is that I need to go, I want to do good R&D, I want to do my doctorate, or I want to do my MSc, and I want to go then go to the United States and work. Today, or United States, Europe, wherever, I want to do my post-graduation there, I want to file, join a corporate, I want to do that. For example, we have an organization in Pune, an excellent computer technology, it's called PICT. Pune Institute of Computer Technology. There is 100% every student in PICT every year virtually goes off to the United States. When it comes to patents, we did a statistical survey. There is out of the number of inventors, 1/3 of the inventors on patent applications in the United States is an Indian. There are a large number of, even in pharma, whether it's pharma, biotech, whatever, there are large number of the inventors are Indians. The problem is not because why do we not file patent applications? Because we do not have an inventor and R&D in spite of whatever we train, whatever. I largely work for the domestic companies. I largely work for domestic inventors. And they do not have faith in the patent system in India. Because the fundamental thing is that the Indian patent law says that your patent is not, even after going through the entire rigorous process of patenting, and the section says that your patent is not prima facie valid. Now, why would somebody go through the entire torture of getting a patent granted when at the end of the day that patent is not considered valid? And that is the tragedy. Now, as far as courts are concerned, of course, there is the whole system of courts in India are not patent, excepting, for example, maybe the Delhi High Court and the Mumbai High Court, and to some extent Chennai, and to some extent Calcutta. The courts are not patent friendly. They don't understand. They have not done patents. It is impossible for them. For many laws, even judges, IP, intellectual property, forget patents, but intellectual property is an optional subject. So they haven't gone through the IP regime, so they don't understand patents. So they take it off their board. Even when a patent case comes, they take it off the board. We have 50,000 patents. What are we? I mean, the whole issue is unless there is you believe in a system. Unless you believe in something, unless you have faith in the system, you are not going to It's not a matter of R&D and patents. It's a matter of belief in the IP system itself. We believe in the trademark system. Therefore, we are one of the largest filers of trademarks in the country. We believe in the copyright system. Therefore, there is a very active copyright registrations that happen in the country. But we do not believe in the design system, and we do not believe in the patent system. R&D is extremely strong. I believe every year we are missing out on about 500,000 good patents, good R&Ds. I'm speaking of the good R&Ds having worked with, just because of a faulty educational system that is there. The educational system teaches the scientist to only list his publications. In the US, nobody bothers about how many publications that you have to your credit. They believe in how many patents you have to your credit. In India, it is the Lord Macaulay system that somebody mentioned. We inherited that as part of the thing. But the whole issue was that the emphasis is on publication, and everybody knows. Dr. Mashalkar stated that once you publish, you perish. Once you patent, publish, and prosper. These were the words, and unfortunately, many good patent applications are lost in India. A lot of R&D is not protected, cannot be commercialized, because nobody will want to commercialize an R&D which is not secure, at least for that 20 years. Everybody speaks about monopoly, and when you come to the question of pharma, I will talk about. I'll talk about that particular aspect. There are some excellent pharma, but the patenting is the lifeblood of the pharma industry. Without patents, we would be anywhere in the world. We would be we will still be relying on aspirin. Nobody would have gone beyond aspirin and maybe the first penicillins. Nobody would have filed. Nobody would have developed. There is no incentive to pharma. Unless there is a patent regime, there is a reason for that, which I believe I'd like the others. I'd like to hear some of the others talking. As Dr. Bachchandra said, it is important to hear people. Sir. Go ahead, sir.
Over to Shubhamay. You're muted.
You know, when Dr. Diwan said that he would sort of look at a different perspective, I was wondering, but I'm so happy to see that he's essentially saying what we talked about, Vishwas, and what I think Yogesh also said. It is the patent culture, and that culture, the institutions had been thrown away for decades. This is looking very serious. So let's take something on a light-hearted note. Hindi films or Bengali films that I know of, I think it applies to others. Look at the number of music that had been over the years plagiarized without any compunctions, that does not tell us about a healthy system of respect for copyright, for intellectual property rights. I mean, I fully agree with the trademarks we protect. 5,000 patents that have been filed by the startups. Only about 1,600 have gone on to the next stage, which is the request for applications. You know, that only when that is done, then the patents are excellent. So it just shows that the companies are yet to realize that there is a need to work on their patents. And I think the problem again comes from the fact that institutions like Jindal, will be doing a wonderful job if we say that we support the institutionalization of the system. For something that can happen for a quick, useful today, we are throwing out the baby with the bathwater. Let us encourage the business of taking patents. It is what we need. It is what, I fully agree with all the panelists. I think all the panelists are saying that the people aren't taking out patents, and because it is not rewarded, it is not considered a useful idea. people have to be pushed. And one of that push, the government can't work on patents, but government must have the companies which actually sort of try to work out via media of saying, I can't work or my technology is good, but only if I can get an exception from the can do it. We may have a problem today, tomorrow we'll have a climate crisis. We have a water crisis coming up. There are several other crises. And each time we shall be asking for exceptions to or safeguards. If our people, as Ujjwal was saying, must be demonstrated on the battlefield. If those technologies are really useful, let's put the money on it and let's see, and only then it'll work. Otherwise, we'll come back to this, ab initio first principles. That's my point. Thank you. Over. Vishwas, your mic.
Ujjwal, over to you.
Thank you. I think the original question was the regulatory changes or the things that we want in India so that innovations happen more. I may not be able to pinpoint that, but could give some of the blocks where we can have those changes or retain some of the regulations, I would say also. First, I think we should start with the school. And I agree with Dr. Divan that our system in India is not very experimental as such. The education in India is not very experimental. It's more of a mugging or a ratification of type, and lost many books, but hardly any experiments based education system. So if at all there any regulation is required to change that education system right from schooling, to make the kids more inquisitive, to inculcate more of scientific temper into the kids, I think then tomorrow we have chance of becoming a good innovative country where we have lots of innovations. Then coming to and this whole also applies to the whole R ecosystem I was taking about. We have a good development ecosystem in India. What we lack, I think, is the research phase of ecosystem in India. Secondly, in terms of, say, for example, in patent laws, we have a very strict patent criteria, patentability criteria than many countries, where we don't recognize, we don't give much of a wide patents, so that wide patents are generally restrictive to further research and development in those sections. So I think that should be retained, not only retained, but we should implement that more vigorously. I understand that our provisions like Section 3D may be under pressure when we are having closer relationship with the United States. What we import from United States is the ecosystem, the research ecosystem in India. Without, and we should export the kind of stricter patentability criteria to United States. They need it also. In some sense, they need also, their economy is also very concentrated, and it's very human. And they also need to tighten their notes on the quality of patents. Just the number of patents may not matter much, but the quality of patent also matters. Then we also come to various kind of regulations in form of, say, in medicine, you have drug approval regulation or similar kind of other marketing approval regulations. In biotech or in biologics, I think our regulation or generally the model that has developed, I understand that I'm not a scientist in that, but I feel, I understand that it is perhaps more restrictive than to achieve the objective of safety, efficacy, and of the drugs. I'm saying that because at present I understand that the regulation requires the biosimilar producers to reach out to the innovators or the original drug makers for every vial approval, so that their bioequivalence are to be proved very regularly, not unlike the chemical medicines. So that regulation may be looked into in that sense, so that there is an ecosystem of more D in India, and that more D may translate into more and more into the R part, as when we, so that there is a kind of demand from industry for people from universities or colleges, such kind of people is required, and so some research mind can kind of translate that from G part in India to the slowly and slowly towards the R part. So these are my understanding on this.
Over to Yogesh.
Thanks, Vishwas. So from what I understand from all the discussion, the question was more towards what do we see is lacking in the innovation ecosystem, at least from an economic analysis of law. That seems to have been the thread. So I think there is a serious confusion among various instruments, amongst various pillars of the state, be it the executive, the judiciary, and the parliament, in terms of the normative objectives of the laws, particularly laws that deal with, that have to deal with the economics of IP. The first one being the IP system itself, the patent system itself, for example, patents and trade secrets. And I understand, Vishwas, you have a separate question on what the Supreme Court has done on these aspects. I'll leave it aside. But if the normative goals of the patent system or the trade secret system has to be to protect the patent holders, increasingly you will see, not just in India, but in many other jurisdictions also, that it is becoming more and more of a leaky right, just like copyrights, because you have a system of remedies that could allow you to move from the property rules to the liability rules, where the court is going to intervene and decide the amount of compensation by refusing an injunction. It has not happened so much with respect to certain kinds of patents, but in relation to pharma particularly, you can see that has also happened in India, wherein the courts have directly moved on to deny an injunction and to award damages. So the normative objectives of the patent law are a serious question. The second problem is when you have patents and you want to transact, because the patent allows you the power to also alienate your property through either assignment, particularly licensing, you would see that the normative objectives of contract law in relation to protecting expectation interests arising from the property rights are also not settled. So you will see a string of decisions of the Supreme Court, not in relation to intellectual property, but in relation to contract law, wherein there is serious ambiguity, with reference to what are the normative objectives of contract. Move on to then a situation where, say there is an abuse of intellectual property, then the normative objectives of competition law have to be at least settled for some time. That, competition means not, harm to a single player, but harm to competition as such, industry-wide competition. And competition law should not attack or should not seek competitive outcomes, but must seek competitive process or preservation of the competitive process. Are these goals clear in competition law? That's a very important question. And then fourth, if competition law is not helpful because competition law is ex post, except in case of mergers and acquisitions, you have laws that are designed for market failure or regulatory laws. And it's a situation where the objectives of regulation also with respect to how you would impose outer limits on patent law or trade secret law or copyright law particularly, and we'll come to a Supreme Court case in the next round, then I think there is a complete mess in terms of what the normative objectives of all these laws are. Because all these laws work in tandem with the intellectual property rights system and help in having a kind of innovation and R&D ecosystem. Otherwise, I think it's a simply a kind of ambiguous terrain for anyone who wants to be in the Indian economy and to make any sense of what it in terms of innovation, and it will just remain a market or at best manufacturing.
Thank you, Yogesh, for pointing that out. And one important question that people who work on IP and innovation, especially in the Indian scenario, tend to ask this question often: how efficient are our courts, more specifically in kind of delivering justice, especially when it comes to IP-related matters? And we've had a whole host of problems, and of course, the whole host of reforms that have come into play, wherein probably the powers vested in certain appellate boards have been taken and transferred to the high courts so that they might actually get to step in and decide on IP-related matters. So my question is, what do we really need to do in terms of IP adjudication, more specifically at the higher, at the High Court and the Supreme Court level? And you've always seen that when you read judgments from courts in US and UK, more specifically in UK, in US, that there is a whole range of economic analysis that comes into play when they're analyzing an IP dispute, right? We haven't seen that level of sophistication as yet in our adjudication as such, but it doesn't necessarily mean that our courts are not adept to kind of handle such issues. But what reforms do you suggest or think in terms of how our courts need to kind of handle some of these cases? And how have our courts done in terms of economic analysis of IP cases? Any of the panelists?
Should I start?
Yeah, please go ahead. Please go ahead, Dr. Devan.
Vishwas, I would humbly disagree with you on one front.
Wonderful.
The judgments that have been written, for example, let us say, the IPAB judgments that came out from Manmohan Singh, from Prabha Sridevan, who was one of the earlier chairwoman, I would say. I mean, and Manmohan Singh, both when he was in the Delhi High Court and when he was, the judgments have been I would say, comparable to any good judgment in the United States or for that matter in the UK. Of course, the style was Indian. The style was not the US style, which is very different. The US style tends to be more verbose, the judgment style. But all your economic conditions, the reasons why the judgment was granted, what is the purpose of the patent, why it was granted. And I would, if anybody is interested, I'll share some gems of judgments of Dr. Manmohan Singh when he was in the chairman of the IPAB and of the Delhi High Court. Delhi High Court has been giving some beautiful judgments. The Bombay High Court, some of the judgments of Justice Kantawala, excellent judgments on an excellent analysis as far as these judgments are concerned. I would say that the judgments that have come out from the high courts, particularly the Delhi High Court, which has now become a center par excellence for IP litigation in India, the judgments are second to no other judgments in India. In I would say in the world, if you're comparing to the two US and European judgments. Quality of judgments, quality of language, quality of insights into what the patent stands for. That is one. But now the government, as you know, recently took a very, very retrograde step of abolishing the IPAB. The whole purpose of the IPAB was that because the courts were burdened, because the courts were not specialist courts, because they did not have where evidence was to be documented where it was needed in the IPAB. The IPAB process itself was very litigant friendly. Now we are going to go back to the regime where we are going to have this is going to go into the Commerce Code. Now there are 5,000 now these cases that have been there at the IPAB will have to now go back to some high court. It may go to Bhubaneswar, it may go to Uttarakhand court, it may go to Simla, it may go to Kerala, it may go to I think you are from Karnataka, so it may go to the Karnataka High Court. As far as that is concerned, or it may go to any court depending upon the litigant. Now they are able to document 5 cases. The IPAB registry is able to document 5 cases. There are 5,000 cases that are pending into the IPAB. We are talking about 1,000 days for just transferring of the cases from the IPAB to the courts. That itself is going to be a horrendous task. There is no explanation. The court, they did not consult anybody, either the lawyers or even the IPAB team itself was there, or any jurists, that we are suddenly disbanding these tribunals, the Intellectual Property Appellate Tribunal. We are doing that. Now, having said that, the reform that has to be there is the kind of reforms that are there, for example, in China, that is there in Germany, that's there in Europe. We need to have specialist IP courts. Only then will we have a regime. Only then will we have and specialist trained. I had the privilege and the opportunity to give some lectures to some of the judges at Bhopal. At Bhopal, you have the National Judicial Academy, where I was asked to come and train to give talks to the judges it was very little. Even that was, I was even privileged to be able to give that kind of little insights to the judges that we were able to they could. But there is more needs to be done. We need to have special IP tribunals and IP patent courts which are there, which will take these forward and not burden the normal commercial courts and litigants. Basically, we are not talking about the burden to the courts. Now in the courts, we will have to go in the regular evidence. There will have to be examination, and there will have to be cross-examination, and now that's going to burden the entire IP community, which was the tribunals were doing excellent service. That is my comment, and it is unexplicable what this, and I can only say that there is total lack of understanding of what is needed as far as their requirement to disband this particular tribunal. It was not a matter of finance. It was not a matter of therefore I can only use the word inexplicable. We are all dumbfounded, but that why these tribunals were disbanded.
Okay.
I'd like to hear my friends. Yes, sir.
Thank you, Dr. Diwan. Anyone else? Ujjwal, I know that Yogesh would want to speak. Okay, Professor Ranganathan, please.
Yes, sir.
Sir, you're muted.
Sorry. I want to take this opportunity to raise one of my concerns in the sense how both regulators and judges, they can do very well with a dose of economics, particularly industrial organization. You see, and I'm going to illustrate this through a series of caselets. First was I was an academic activist, as it were. This GMR Energy, which was called Tanir Bavi Power Company. They had a power purchase contract with Karnataka Power Transmission Corporation. And this was, they had inherited a competitively bid project. And so they, in the power purchase agreement, they said the fixed charge will be 4 cents for the time being, but it will, however, be exactly what it is at the time of financial close. That means after the financial close, they will actually get the details. But everything was over and they found the total cost was 2.05. And then still they said 4 cents they want. And it went up to all the, tribunals, etc. So the tribunal, the reconciliating body said, yeah, that's even though it is subject to a ceiling of 4 cents, ceiling was there, but then the arbitration tribunal said this was got by a competitive bid, and in the competitive bid 4 cents was there, and therefore it's okay. They have to give 4 cents. And it came to the regulator again, and this time the regulator took the extraordinary step of convening a second hearing, public hearing. There we went and gave hammer and tongs all the reasons why it should be only 2.02, and 600 crores were involved. So the regulator said that we are not going to make you recover this, because even the government had said pay them, So regulator said, I am not going to authorize you to recover it from consumers. Your duty as a licensee is to the consumer, etc. Now, the thing is here, this was a case when there was we were transitioning from a fixed price, cost-based power purchase agreement to a competitively bid price. So what is the change in market structure and what comes to be a primacy, etc. The judge has to understand it clearly, and the lawyer for the company, Andhya Rujina, argued beautifully. It was a nice argument. If you are buying an apple, would you ask its price, or would you say, what is the cost of producing that apple? So he said that. So when will you ask the price, and when will you ask for the components of cost, and what is written in the power purchase agreement? There has to be some clarity. Now, there was another case where the Central Electricity Regulatory Commission said, okay, higher cost. Tatas and Adanis had incurred higher cost because Indonesia, they had said, whatever be the price of you are charging, international price will apply for tax purposes. So the cost was more. So they said power purchase agreement is non-est. We don't want to do that. You as a regulator fix the price. So the regulator went along, the regulatory tribunal, dispute tribunal went along, but the Supreme Court, at the level of Supreme Court said, contract enforcement, this is what you have agreed for the contract. I like that judgment, but there was a revision petition and they reversed that judgment. So what is the basis of such reversal? Is it based on economics or political power? So on the, on the whole, I can give a number of such instances. One more instance was PNGRB versus the city gas distributor. Now, the PNGRB gave a order, this is your cost, so this shall be your price. The company went into argument saying that you don't have power to fix the price, because in Electricity Act, there is a power explicitly the regulator will fix the price. But here in PNGRB Act, it talks, preamble talks a lot about introducing competition, but doesn't talk about price, because they said you have HPCL, IOC, etc., and the market will play itself and so on. What is okay for petrol is not okay for gas, because gas is a monopoly, and the PNGRB has given. So the lawyer said, where is the, look at the act, this is not there, and therefore the lawyer won. I was in an embarrassing position, because as an academic, my support was with the PNGRB. I was also the director of the board. The board had, the company had won. So I said, this High Court judge must have realized that the Act very clearly says to foster competition. For competition means to fix prices, etc. So that is a point, that with a greater amount of economics, informed decisions may be taken.
Thank you, Professor Ranganathan. Yogesh and Ujjwal, we have about 2 minutes, so kindly wrap up with your response.
So, Ujjwal, you want to go first? Thank you. So, I just wanted to bring one case to the notice, just to show, how the Supreme Court, for example, decides on the question of economics of intellectual property. This is Star India versus DIPP, decided in 2018. And this relates to challenging of certain TRAI regulations that had to deal with the question of pricing by these broadcasting organizations in terms of having a bouquet price vis-a-vis having an individual price. So if you want to buy individual channels, the price would be highly priced, and if you buy a bouquet, the price would be lower. Supreme Court unfortunately did not understand price discrimination. So at the end of the day, what did the Supreme Court say? Supreme Court said, because the contention that was taken by Star was that, look, copyright law provides us the rights to, deal with the content, and TRAI should not deal with the content. And if they were trying to impose restrictions on our ability to price discriminate, because they wanted a kind of flat price for bouquet and also a flat price for individual channel, not moving beyond ₹19, then it doesn't make any economic sense. The Supreme Court said, well, it may not make any economic sense, but the question is, TRAI's law and TRAI's regulations are in public interest and copyright is in private interest. This was the absolute simplistic analysis that the Supreme Court engaged in on the question of whether intellectual property and using copyright, for example, for the question of consumer price discrimination or price differentiation should be, allowed to be thwarted by a regulation through TRAI or not. So does that mean now that in all intellectual property laws, we are going to have a kind of overriding provision saying, this law will prevail over all other laws? Is that the reason why, the Supreme Court is saying that, they don't understand price discrimination? So this is just one example that I wanted to bring out finally towards the end of the session. So I think the problem is also, as Mr. Diwan rightly pointed out, that it seems just inexplicable how Indian government engages with the intellectual property or other laws. Removing suddenly the IPAB without even a discussion paper and a green paper or a white paper, whatever you want to call, I think was a retrograde step. If you wanted to really say that there were certain problems with these tribunals, you should have brought in a paper, had a short discussion and done something about it. I think the way forward may be to increase the strength in the high courts and have specific benches within the commercial courts to deal with IP related cases. I don't see any other way, to kind of deal with routine appeals that will arise from the patent office, to deal with such kinds of issues. Thank you.
Over to Ujjwal.
Let me be brief. I don't have much exposure of court cases and such, but I understand that there are certain issues which are very unique to India. And say, for example, the BT Cotton case. Here you have two IP laws involved in it. And we have a sui generis case, and then you have a patent. So what law would apply to a BT Cotton seed was the crux of the dispute, in fact, and it is still unsettled as such. So we also need to think that, and would that court rely or should rely on more of the amicus curiae or the academic inputs on this, so that their understanding is much better in that sense. Because these are unique. You may not find any precedent anywhere in the world that two IP laws are applied in a case where a court is discussing about. And then second, also, I think more jurisprudence or more clarity is needed on time and again. We have seen that there are case or injunction cases filed against Commission of India about its jurisdiction. While in some of the past cases, Delhi High Court and all have clearly kind of stated what constitutes the jurisdiction of CCI and where patent authority comes in, and particularly in the Ericsson case and all. So I should just stop here. I think the time is up. Thank you.
Thank you, Ujjwal. Thank you all the panelists for your insights and views. It's a fairly complex scenario where we are at right now when it comes to COVID and COVID-related vaccinations. So because of paucity of time, I've had to kind of hold myself back with respect to questions related to questions of compulsory license and access to COVID vaccines, etc. But that raises a whole range of other complex kind of conversations as such. So thank you once again, and it was an enriching discussion on aspects related to R&D, innovation, and of course the role that courts can actually play with respect to IP and IP-related innovation as such. Okay, thanks a lot, and over to my colleague Ashu.
Thank you very much to all of you. I really enjoyed the discussion. Thank you so much. Good evening to all of you. I would like to extend a warm welcome to all of you to this plenary session of the first day of this conference. It has been a fascinating discussion on a rather difficult time when the whole world and of course India itself is battling with the pandemic. The theme of this session is getting policies right for an inclusive growth. We have with us a very distinguished lawyer, a politician, and indeed a public intellectual, Mr. Manish Tiwari. I would like to welcome all of you to this first plenary session of this conference. Now, achieving inclusive growth has been a continuous economic policy challenge for developing countries like India, despite India's economic and social growth for the last 75 years. The COVID-19 pandemic has been one of the most unprecedented crises of our time, a black swan moment, and it has only further exposed the underlying inequalities and vulnerabilities in our own society. The call for an inclusive and resilient economy is thus more important than ever, and it needs to be emphasized at every opportunity available, and this conference was just one more platform for the same. We have a very special guest with us here today, Mr. Manish Tiwari, to deliver a keynote address on getting policies right for an inclusive growth. A very warm welcome to you, Mr. Tiwari. Thank you very much for being here with us in this conference organized by OP Jindal Global University in collaboration with Cuts International. A distinguished lawyer by training and having practiced in the Supreme Court of India, Mr. Tiwari is a lawyer turned politician and was elected as a member of parliament from Ludhiana of Punjab state as member of Indian National Congress in 2009. He started his political career with the National Students' Union of India and later became a member of Congress Party's National Committee. He also served as Union Minister of State Independent Charge, Information and Broadcasting from 2009 to 2014. Mr. Tiwari did also join a US-based think tank as a distinguished fellow in 2017 at the South Asia Center of the Atlantic Council and also served as a spokesperson for Congress. We are deeply grateful that he could join us today to discuss a very important area of policymaking for making our future more inclusive. Therefore, without further ado, I would now call upon Mr. Manish Tiwari for delivering his keynote address. I'm also grateful to my colleague, Professor Dr. Srijit, who will be chairing and moderating this session. Over to you, Mr. Tiwari.
Thank you very much, Professor Rajkumar, Professor Srijit. Ladies and gentlemen, first of all, allow me to thank the Jindal Global University and Cuts International for organizing this very timely conference on the economic dimensions of judicial decisions and inviting me to deliver this keynote on getting policies right for the future. We meet in rather interesting times, if I may say, apocalyptic times. The second wave of the coronavirus has completely overwhelmed us. It's not as if it wasn't expected. All historical, empirical, scientific evidence points towards the fact that the second wave of any pandemic is unfortunately more lethal than the first one. We just took our eyes off the ball. And unfortunately, a lot of helpless, innocent citizens are paying the price for that negligence. And if I may say, criminally culpable negligence. India's caseload on the 27th of April stands at 1.73 crore cases. The good news is that the recovery has also been fairly rapid. 1.43 crore people recovered or have recovered. Unfortunately, 1,95,000 were lost to the pandemic. But what is worrying as of today is that we are on an average, on a weekly average, adding about 321,000 cases daily to the viral caseload, and that unfortunately is completely overwhelming our systems. What do we have in the ground? We have a situation where only about 2.4 crore of our people out of 135 crores have been fully vaccinated. This accounts for just 1.6% of the population of this country. On the other hand, we have, in the past 3 months, exported 6.63 crore doses of vaccines as of today morning. These vaccines, if they would have been domestically used, would have easily fully vaccinated another 3.31 crore people. And that's a lot of people. The reason why I am flagging these numbers at this point in time, because if you were to juxtapose this against the approach adopted by the United States of America and many other European nations, they have decided to prioritize their own citizens first. In fact, the United States of America, the spokesperson for the State Department, went so far as to say that our first obligation is to vaccinate Americans first. And so therefore, this brings us to the fundamental policy question that in times like these, should India have indulged in this vaccine maitri or vaccine diplomacy or whatever else you would like to call it, or we should have prioritized our own citizens first, given that when the rollout of the vaccine started, the first signs of the second wave had already started manifesting themselves. I would like all of you, ladies and gentlemen, to seriously apply yourself to this question, because this is where the story of our misplaced priorities unfortunately starts. And this has been the endemic problem now going back over second decades. Number two, let me just step back 4 decades and take you back to 1976. Why is 1976 important? 1976 is important because that's when the reign of Mao Zedong, the great helmsman, ended in China. It had been a disastrous reign. Undoubtedly, Mao Zedong was responsible for creating the modern Chinese state in 1949. But then the various experiments that he undertook, the Great Leap Forward, the Cultural Revolution, had completely and absolutely devastated China by the time Mao's life finally ebbed away in 1976. In fact, during the last years of his tenure, China was effectively ruled by the Gang of Four, which they eventually had to then face the consequences of that misdirection of Chinese policies. So what was the situation in 1976? China's GDP in 1976 was $149.54 billion. Its per capita GDP was $156 US, and its GDP growth rate was 11.33%. Now, this is a misleading figure, and I would come to it in a moment. And where was India at that point in time? India had a total GDP of 137.30 billion USD. Its per capita GDP was $206 US, more than China, almost 57 US dollars more than China. And its growth of GDP in that particular year was 5.71%. Now, these GDP growth rates are misleading, and I'm sorry, these figures are 1978 and not 1976. But if you were to step back to 1976, both India and China start from a very low base. China was at minus 1.57 in terms of GDP growth, and India was only at 1.66% in terms of GDP growth. Today, 4 decades later, China's GDP is $16 trillion. And India is at $2.83 trillion. So obviously, the Chinese got something right. which we didn't. And what is it that the Chinese got right, and notwithstanding the current antagonism and the border standoff, there are certain takeaways that we as a nation need to internalize, because in terms of size and demographics, there's nothing which really compares with China when you were to try and juxtapose certain examples or take some examples for the Indian growth story. And what China got right was that it stabilized its population. The second thing which China got right was that it was very, very cognizant and conscious of the fact that it needed 30 years of peace on its periphery in order to consolidate, in order to surmount its internal economic and human development challenges. And so therefore, if you were to look at where the population of China was at 93.7 crores in 1976. In 2021, they're at 139.77 crores. India was at 63.76 crores. And in 2021, we are almost catching up with China, and we are at 136.64 crores. Unfortunately, because of the emergency, the population debate completely went off the table. And nobody in the policy space, politicians, academicians, even scientists, were willing to touch this with a barge pole. And unfortunately, a myth was created, the myth of a demographic dividend, that this burgeoning young population is a huge demographic dividend waiting to be harvested. Now, nothing could have been a bigger lie, because what we are currently facing in terms of overwhelmed hospitals, in terms of absence of hospital beds, in terms of absence of ventilators, in terms of absence of basic physical infrastructure for a dignified living, is primarily because our numbers overwhelm our growth story completely. India occupies 2.4% of the world area, and we are a home to 133 crore people. China occupies 2.6%, or 2.5, occupies 6.3% of the world area, almost 2.5 times India's size, and they are at 136 crores, at 139 crores. So therefore, the first and the foremost thing which India needs to do is to bring the population question absolutely center stage. There, we need to shed our inhibitions, that we have to address the population issue. We need to bring our replacement rate down to negative. Otherwise, we really don't have a hope in hell. And we need to surmount this spurious debate of a demographic dividend, which has been a big cover-up for our failure to address this central question. The second thing is that India is not an emerging great power. India is still struggling in order to cope with the fundamentals of economic and human development of our people. And we need to be upfront and straight with our people about it. We need 30 years of peace on our periphery in order to be able to concentrate on our internal challenges. These myths which are propagated by retired foreign office types or people in the strategic establishment, that India's moment in the sun has come. I'm afraid India's moment in the sun will only come when we are able to put all our children into school, when we are able to provide basic health care to our people, when we are able to ensure that the bulk of our populace is insured, when we are able to give proper health care to our people, and not people dying because of lack of oxygen in our hospitals. It's time to get real. Yes, India's moment in the sun will come, but it will come maybe 3 or 4 decades down the road. If we very wisely decide not to hunker down, but to engage with the world in very exceptional terms, being absolutely clear as to what our priorities should be. With regard to India's economy, unfortunately, like China had a great helmsman, we've also had a great helmsman for the last 7 years. And there have been various experiments which have completely and absolutely gone awry. Demonetization was one of those experiments which completely devastated the informal economy of India. An ill-conceived and a hastily rolled out goods and services tax added to those woes. But most importantly, the government was not able to internalize one fundamental reality. And that one fundamental reality is that social disharmony and economic development do not go hand in hand. Money is the biggest coward, and money goes to the safest harbor. And today, because of all the discourse which has been splashed across the international press, love jihad, ghar wapsi, beti bachao, bahu le aao, and every kind of retrogressive, polarizing activity, which unfortunately has been carried out on this government's watch, has sent out a message to investors across the world that India is not a safe harbor. And this is at a point in time when countries are actually looking to diversify from the dependence which they have on China in terms of global supply chains, all leading back to the factory of the world. And the manner in which China weaponized those supply chains over the past 1 year during the pandemic has a lot of people worried. But that the investment which is going out of China is going to Taiwan, it's going to Vietnam, it's going to Bangladesh. It is not coming to India. I mean, if you look at the empirical data that from 2016 onwards, the amount of money which has left China and as to which destinations it has gone to, India has not been one of those destinations. And the reason for that is the discourse about India in the international press, in the Financial Times, in the Washington Post, in the New York Times, in the Le Monde, papers which investors globally read. The entire discourse has been completely negative because of an extremely corrosive social agenda. So therefore, if we want economic development, if we want India to grow at 8%, which is the minimum that we require in order to keep the body and soul of such a huge population together, we have to bring back social peace. And it is not something which is impossible. From 2004 to 14, following the mantra of equity with growth, the then UPA government actually lifted 271 million people, 27 crore out of poverty. Many of them who in the past 7 years have slid back into poverty. So therefore, the way forward for the Indian economy is to get the growth, equity, and social harmony balance absolutely correct, to get that equilibrium in order, and not large-scale privatization of our public assets. And nobody's arguing that they function in the most efficient manner. But that is not going to give us the 8% growth we require. We need to reignite, and we need to let loose the animal spirits of the economy and ensure that this atmosphere of coercion, intimidation, which has been created by the completely arbitrary and brazen use of the instrumentalities of the state, be it Income Tax Enforcement Directorate, the Central Bureau of Investigation, the NIA, this needs to stop, because otherwise money and people who have the ability of entrepreneurship are just going to flee this country in droves, as they have done from 2016 onwards. If I remember correctly, there was data from 2016, which I had seen some years back, that in that 1 year, 100,000 high net worth individuals from India actually became permanent residents in the UAE, most of them in Dubai. So therefore, to conclude, and I would be more than happy to take questions, that we stand on the cusp of the fourth industrial revolution, or in fact, not on the cusp, but maybe in the midst of the fourth industrial revolution, the digital age. And we have the unique ability, given the kind of infrastructure that we have built, to harness this digital age and actually provide and actually create wealth for our people. The question is that, would we be able to catch this bus, or will we miss this bus as we missed the first, second, and the third industrial revolutions? And so therefore, what I'm suggesting is not something which is rocket science. It is not a magic bullet. It has been tried and tested in the past. We just need to go back to that fundamental template, get our growth in order, bring population back center stage, and ensure that we create conditions in our neighborhood that we are able to have 30 years, 3 decades of peace on our periphery in order to concentrate and surmount our internal challenges. Thank you very much again, Professor Rajkumar, Professor Srijit, and to the Jindal Global University, the Cuts International, for having me in your midst. Thank you very much.
Thank you very much, Mr. Tiwari. That was a very enlightening discussion, and I'm very delighted to hear that informative and insightful lecture broadly touching the theme, getting policies right for inclusive future. Before we take the audience questions, I would just like to summarize this. This conference and your talk are quite timely and opportune, that the COVID-19 pandemic has prompted us to adopt a kind of economism at all levels in pursuit of optimal outcomes. The time has demanded us to become effective problem solvers, rational decision makers, and utility pursuers. There is no better guide than policy for those who aim for efficiency in the allocation of resources and optimality of outcomes. Hence, there has never been a time before when policy has the type of relevance as it has assumed it today. Ladies and gentlemen, our distinguished speaker, Mr. Manish Tiwari, has focused on, through contemporary realities, on the role of policy in public space. Before we get into the audience, probably let me become one among them and start the Q&A. Mr. Tiwari, could you enlighten us that probably in the light of the contemporary realities, the role policy can play in mapping scenarios, in estimating impacts, in predicting outcomes, in effectively responding to crisis, in decision-making, and largely in realizing smaller and larger social goals?
And thank you, Professor Srijit. That's a very, very profound question and a very important question at this juncture. You know, if I were to rewind back to 1918, when the First World War was winding down, and the Spanish flu, which of course had nothing to do with Spain, was raging across the world, people at that point in time, policymakers, were bereft of tools in order to either simulate or model or come to certain predictable conclusions on which they could base their responses. We have traveled very far down that road in the past 100 years. Science, technology, innovation, mathematical modeling, artificial intelligence, you name it, now gives us the ability to be able to map scenarios, predict with a reasonable degree of accuracy as to where we are headed, and then accordingly formulate and fashion responses. So under those circumstances, I think mapping, predicting a scenario building, and also figuring out a menu of responses to those scenarios is something which is possible today with a fair degree of accuracy, and which can be applied to a contemporary situation when it manifests itself, or a real life situation when it manifests itself. So under those circumstances, I am quite disappointed. In fact, I'm quite appalled that how could we have missed all the empirical evidence, the weight of history staring at us in our faces over the past 100 years, that a second wave is always more lethal. How could we have actually let our guard down? And I think on this particular question, there needs to be a very rigorous parliamentary scrutiny, perhaps even by a joint parliamentary committee, as to where did we as a system, and here I'm not trying to apportion responsibility or blame, as to how as a system, as a country, be it state governments, be it the central government, how did we completely take our eye off the ball?
We do. Thank you very much for that answer. We have received quite a few questions from the audience. I would request you to take one by one. So the first question is primarily about the role judiciary can play under these circumstances. How can economic policies which help to promote economic growth be better implemented through the judiciary? To what extent can law effectively play a role in enforcing policy decisions?
Well, obviously, the judicial system has an extremely important role, because most policies or their outcomes end up as legal challenges before different courts at different levels. But in my humble estimation, I have found the judiciary completely ill-equipped to be able to handle the complexity of both economic and administrative decision-making. And since the principal responsibility of the judiciary is to arbitrate about the justness or otherwise of government decisions, it is extremely important for judges to actually get a feel of what governance really is in India. And therefore, I am of the view that insofar as the subordinate judiciary is concerned, anybody who gets recruited to the subordinate judiciary must be seconded at least for a year to at the subdivisional level, at the district level, in order to see administration and action, in order to be able to understand their limitations and their excesses, on the ground. And this would really help them in coming to much better conclusions when it comes to deciding the arbitrariness or otherwise of administrative action which is taken. Similarly, with regard to judges who get directly elevated from the bar to the High Court, a similar process needs to be followed. At least for 1 year, they need to be trained at different levels of the bureaucracy at the tehsil level, at the district level, at the state, and at the central government level, at least for 3 months, so that it gives them an overview of how government at different levels functions. Number two, there has to be a certain amount of specialization which needs to be brought in, insofar as economic decision-making is concerned. Now, with great respect to the Supreme Court, the decision which was taken with regard to the cancellation of coal blocks going back all the way to 1992, I'm afraid, it did set the economy of the country back. Yes, if they wanted that coal block should be auctioned, could have been done prospectively if there was a certain amount of arbitrariness or rent seeking in a particular decision. Action should definitely have been taken. Similarly, with regard to spectrum, because eventually when the Spectrum case went before the trial court in order to adjudicate the malfeasance of those who had taken those decisions. Everybody ended up getting acquitted. The case fell flat on its face. But by then, the Supreme Court had already cancelled Spectrum allocation and licenses. And so therefore, under those circumstances, there is a complete dichotomy, or if not dichotomy, a contradiction between decisions which the courts take, and eventually when their consequences in terms of either malfeasance or rent seeking or arbitrariness are tested before a trial court where you lead evidence as opposed to the appellate court, it does not stand on facts. And I think the basic problem there is that our judges, and with great respect to them, do not have an understanding, a ground level understanding of either the administrative or political reality of India.
Thank you. There is another interesting question, again, focusing on the judicial system. So how can adoption of technologies, including disruptive technologies, if at all, would help the judicial system become rational? In other words, can technologies like artificial intelligence help the court to adopt a super economistic approach towards problem solving?
Well, my view of technology, you may call it a little old-fashioned, is that technology is an enabler. Technology is not something which should replace the human being. You know, I know the maximum hiring over the past 2 years in the Silicon Valley has been of pure arts graduates from Brown University and some of the other pure liberal arts universities in the United States of America, primarily because they're trying to put the emotional quotient and the compassion quotient into artificial intelligence. But with great respect, I think the human mind is far better able to fathom the nuances and the complexities which are attendant and intrinsic to any Liz or any judicial proceeding. So I am all for adopting technology which helps speed up things, smoothen things, straighten out the docket, do various other things. But in terms of judicial adjudication, I do not think that artificial intelligence or the robot should really be replacing the judge, howsoever unfortunately compliant the judicial system may have become, at least in certain respects these days.
Wonderful. So in the same vein, the balanced view you have taken towards the technology, we have an interesting question that the use of digital technologies, while leading to several benefits, have also resulted in claims related to exclusion of the desired beneficiaries, surveillance by states, abuse of power by the private sector, so on and so forth. How can the much desired balance be ensured in apparently conflicting economic interests of different stakeholders?
Well, you're absolutely correct. And I think the greatest example is in front of us. The greatest example of the digital divide is right in front of us. And children who come from poor, underprivileged or disempowered homes and who do not have the means of technology at their disposal have unfortunately not been able to access education or education facilities over the past 1 year as compared to their much better off peers. You see, if you go to rural India, and I represent a constituency which has 1,800 villages, which goes across 4 districts of Punjab. And the one thing which I ask the district education officers and other people very regularly at every meeting is, how are the poorer children faring that now that classes are not really happening? And the answer is that, we try and pool resources, etc., but it doesn't work. And so therefore, this is going to be the greatest challenge of the 4th industrial revolution, of the digital age. As technologies are going to replace human beings exceedingly. I mean, if you go by a World Bank estimate of 2018, if I'm correct. They say that automation is going to replace 67% of the workforce in the manufacturing sector, and that's in India. Other places the numbers may be higher. So we have to look for a new economic model as to how do we then take care of all those people, productively utilize their energies, their potential, people who are going to be replaced by automation and digitization from the workforce. And I think enough thought has not been applied to this aspect by governments across the world. Certain progressive political parties in Europe have done some amount of work on this. But on the whole, the human consequences of the digital divide, of the fourth industrial age, is something which has not received the attention. And one day this will just hit us in the face. And so therefore, before the Panipat syndrome, as I call it, reoccurs, at least the Indian state needs to wake up, because given our demographics, we cannot have that disaster staring at us in the face.
Thank you for your observations on that. A slightly unrelated question, but still the question has a focus on the judiciary. So the questioner wants to know what institutional reforms can lead to the reduction of an overburdened judiciary. While the staggering pendency of the cases certainly is alarming for a statistician, the hard fact is that it's also affecting human lives. So how can actually the perspective be turned in a way that the human life comes on the focus when we analyze or when we address the question of the pendency of the cases before the courts?
You ask a very profound question. When I finished class 10th, my maternal grandfather, he was a lawyer and he was a politician. And so he took me to his club for a glass of beer. And he asked me, he says, what is it that you want to become? So I said, I want to become a lawyer. So he says, why do you want to become a lawyer? I said, because I like to argue. And he said something to me, which was very prophetic, and it has stuck with me since then. He says, do always keep in mind that in courts, decisions are handed down, not justice. अदालतों में फैसले होते हैं इंसाफ में. So therefore, the human aspect or the implications or the consequences of judicial decisions, delays on human life is something I think even as an academic discipline has not been looked at some great length. And in a country where you can possibly 2 generations can die before a matter gets decided, litigation is, if I may put it in those words, the luxury of the rich. Civil litigation and criminal litigation, look at the number of under trials who are languishing in our prisons. And so therefore, that is exactly what I was talking about, that we need 30 years in order to set our country straight. And one of the things that is central to setting our country straight is setting our judicial system in order. Spending enough money in order to augment both the physical and the intellectual resource of our judicial system. If you go down to some of the tehsil courts, the infrastructure is absolutely abysmal. That's not the way a judicial system should be functioning. And therefore, on education, on health, on our judicial system, we require a far greater outlay in terms of our GDP than what we are possibly able to prescribe. And even and the most scandalous part of it is that we are not even able to fill up the vacancies which exist. Our high courts are functioning at half the strength. Collegium decisions are not actioned. Collegiums are not able to arrive at a consensus with regard to decision making. So therefore, in fact, I am of the view that the NJAC paradigm needs to be relooked at, and the NJAC in some form needs to be reinstated. The collegium system, unfortunately, with great respect to the judiciary, has not been able to deliver. And so therefore, if in a country you have to actually pass a judicial order that you can rehire retired judges in order to deal with pendency, while you have 50% vacancies, I mean, what kind of a system are we really talking about? So there has to be a fundamental overhaul, and this whole business of judges judging themselves, this goes against the very essence of the doctrine of separation of powers. And so therefore, some kind of a check and balance needs to be put into place. Judicial confirmations, like in the US, through a Senate committee, maybe give it to a Rajya Sabha select committee in order to do the vetting, and for the Rajya Sabha then to confirm the appointment of judges. So therefore, there is a lot of reform which unfortunately needs to take place, because you see, it's very interesting. I'm sorry if I'm being a little long-winded, but when India went into the coalition phase from 1991 onwards, and the center seemed to weaken, the judiciary stepped into that vacuum. And unfortunately, in 2014, when you had a majority government at the center, the commentary on the independence of the judiciary in the past 7 years is all there before us. You just have to read the newspapers on a daily basis. It actually makes you extremely shameful to even contemplate as to where we have reached. So India's judicial system requires a surgery, and it requires a drastic surgery to be able to deliver on the fundamental tenet for which it has been created, that is, giving quick and speedy justice to the people.
Thank you very much. Perhaps, we are coming towards the end of the session, but I'll pose one question relevant to the theme of today's conversation. Probably this could be the last question. If you compare law and policy, one is normative standards which show the right ways of living, and the other a guidance to move forward, a motivation to move forward, a commitment, a guarantee to the people. Which one gives hope for the people of India, especially under the present circumstances in which we live?
Well, I think there has to be a balance. You see, there has to be enlightened policy making, and there has to be robust judicial oversight. You see, it's really the balance of the two which brings out the best for the people. So when you have enlightened policy making, which takes the concerns of 135 crore people who live in India on board, and then you have a humane, compassionate judiciary, which then arbitrates in a just manner and gets its priorities right. I mean, unfortunately, some of the cases in the docket during the last 1 year in the Supreme Court, when a pandemic was raging and there were large number of constitutional matters pending, could really have waited. So I think it's the balance between an enlightened government which makes correct policy, and a fiercely independent judiciary which has compassion at the core of its philosophy of jurisprudence. That is the not the best. That's the only way forward for this country, or any country for that matter.
Thank you, Mr. Tiwari, for your elegant musings. I must say that this was a very enlightening session. You touched the contemporary realities using a theoretical framework. So on behalf of the Jindal Global Law School, on behalf of OP Jindal Global University, and on behalf of Cuts, I extend my heartfelt thanks to you. Over to Professor Rajkumar.
Well, thank you very much for that really comprehensive tour de force on the historical evolution of the idea of inclusive growth and what kind of a society that we need to build. I was very particularly intrigued to hear your China narrative, because I had the privilege to work in Hong Kong for many years, and I've traveled across China. And one of the less talked about aspects of Chinese context is the significant investment in education and health in the early part of that evolution. And at that time, those investments were made, and clearly China began to benefit from that investment at least a few decades later. Even Professor Amartya Sen in his book Development as Freedom, also in other narratives, this has been emphasized. So I think I was particularly inspired by the fact that you touched on that, and then of course to bringing it into current realities of how we ought to govern ourselves, and instead of we need to recognize the priorities that are needed when it comes to policy implementation, and education and health ought to become the two critical areas in which a lot of our attention, including policy and governance attention, need to be made. So once again, thank you very much, Mr. Manish Tiwari, for your fascinating keynote address. I deeply appreciate the fact that you took time out on a very busy day and indeed very difficult times. And I appreciate your participation in this conference. Thank you.
Thank you, Professor. Thank you, Professor Rajkumar, for having me. Thank you very much. And thank you. And everybody who's watching this, please stay safe. Please stay careful.
All right. For all of you, we'll be joining shortly with Dr. Abhishek Manu Singhvi, who will be delivering another plenary address shortly. I will meet very soon. Thank you.
Thank you.
Good evening to all of you. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. I would like to extend a warm welcome to all of you to the first day of the National Virtual Conference on Economic Dimensions in Judicial Decisions, organized by OP Jindal Global University in collaboration with Cuts International. We are about to begin the second plenary session of this conference to be addressed by Dr. Abhishek Manu Singh. Before I formally introduce him and also talk about the session, I would like to say that since morning, we've had a fascinating discussion. We began with the inaugural session on the theme, the economics in judicial decisions or judicialization of the economy, followed by the first thematic session, which focused on economic analysis of public infrastructure, trade, and constitutional law. We then had the second thematic session focusing on law and economics, approach to corporate laws and corporate debt restructure in India. And then we had the third thematic session on law and economics approach to competition policy, digital economy, and new technologies. This was followed by the fourth thematic session, which had a very specific focus on an economic analysis of industrial innovation and intellectual property law. After these four thematic sessions, we had the first plenary session on the theme, Getting Policies Right for an Inclusive Future. And now we are entering into the second plenary session on the theme, Institutionalization of Reforms in Courts in India. As we know, the Indian judiciary has demonstrated intellect and creativity in a number of landmark cases over the years. However, even today, we see the judicial system of India overburdened with pending cases. Currently, India has almost 40 million pending cases that traverse across the district courts, the high courts, and indeed the Supreme Court. The ongoing pandemic has only further introduced new dimensions in aspects of justice, which will need courts to demonstrate adaptability and innovation on a continuous basis. It is evident that the Indian judiciary, even with all its strengths, is in crying need of reforms, not just as a function of the case overload or other parameters, but also due to the changing and dynamic landscape of the challenges posed by issues relating to access to justice, more strongly reflected during these difficult times. These reforms will vary from increase in the capacity of the judiciary to technology-driven record management to improvement in the functioning of the district courts and many others. Therefore, it is important that while we discuss some specific reforms across the 2 days with respect to the economic dimensions in judicial decisions, we must also reflect on the larger vision of institutionalizing reforms in Indian courtrooms. Hence, I am very grateful to have our next esteemed and distinguished speaker here today with us to deliver a keynote address on this very important topic, institutionalization of reforms in courts in India. Thank you very much, Dr. Singhvi, for taking time out to be with us. And I want to say that Dr. Abhishek Singhvi has been a very dear friend of OP Jindal Global University and Jindal Global Law School. And besides his many other accolades, I want to say that he has been a distinguished adjunct professor at Jindal Global Law School and also teaching full-fledged courses for our students. Dr. Abhishek Manu Singhvi is a senior 3-term sitting member of parliament. He's a former chairman of the Parliamentary Standing Committee on Law and Justice. He was India's youngest designated senior advocate at 34 and also India's youngest appointed additional Solicitor General of India at the age of 37. He's a well-known author and columnist and a very visible media personality. He's also the senior most serving national spokesperson of the Congress Party. His columns have appeared in India's 2 top English dailies and have been published as 2 books titled Candid Corner and Straight Talk, both with forewords written by Dr. Manmohan Singh, former Prime Minister of India. He's also an occasional columnist in major Hindi dailies, including Dainik Bhaskar and Rajasthan Patrika. Awarded the Global Leader for Tomorrow Award by the World Economic Forum at Davos in 1999, Dr. Singhvi has been the opening lead speaker for the Treasury Congress benches in Parliament for almost every major debate from 2006 to 2013. He has been the common factor in almost all landmark Supreme Court cases spanning constitutional law, corporate law, arbitration, and several other subjects. He supports many charities, including the Prayas Center for Destitute Children and the Singhvi Scholarship at Trinity College, University of Cambridge. This is apart from the sterling work done by him over a decade in Rajasthan from his MP-led funds, supporting over 400 projects in the fields of health and education. A book on his nearly 400 plus MP-led projects in Rajasthan was recently released by the Honorable Vice President of India, Dr. Mr. Naidu. His definitive legal analysis of the law of emergency powers in comparative perspectives was also released recently by the Honorable Chief Justice of India now, then the Chief Justice designate, and 3 other distinguished judges of the Supreme Court of India. Dr. Singhvi topped India at the school leaving Indian school certificate and did BA Economics Honours at St. Stephen's College, MA and PhD from Trinity College, Cambridge. He also taught briefly at St. John's College, Cambridge, and did a brief summer program called PIL from Harvard, United States. We couldn't have had a better individual to deliver this keynote address. With those words, I now call upon Dr. Abhishek Manu Singhvi to deliver his keynote address.
Well, thank you again so much, Raj, for an extremely generous introduction. Certainly not deserved in such glowing terms, but it's very kind of you. And I somehow feel that there are so many missed vocations which you could have had, not only being a remarkably successful founder, vice chancellor of this university, which has grown out of suddenly nowhere in the shortest possible time I can imagine. But, your events are so comprehensively organized and such large that you have a lot of advice to be given to those sectors also who organize such events. Let me just pick on the first sentence you said, that the Indian judiciary has been very creative. That is why the theme of your topic today makes you somewhat uncomfortable and almost hang your head in shame, because I don't think that a more dynamic, a more pulsating, a more talented judicial system, and when I judicial system, I include judges, lawyers, law persons, academics, all the law family in that loose sense. I don't think you can have a more dynamic and a talented system than the one you have in India. I don't think the kind of legal doctrines we have invented, which are the pride of India and the envy of the world, could have been imagined elsewhere. Imagine basic structure, that even a constitutional amendment is unconstitutional. This is an Indian invention. PIL, for that matter, good, bad, or indifferent, a remarkable vehicle. The power of judicial review, which Indian courts, from High Court to Superior Court, Supreme Court, exercise, would make Marbury Madison blush 100 times over in the US Supreme Court. There is nothing which is away from or immune from the judicial review powers which our courts have. Which is why, amidst all this, this elephant in the room makes us hang our head in shame, which is this mammoth backlog, arrears, pendency, clogging, call it what you will. And therefore, when you look at this topic, I always feel this irony frequently, and remember Benjamin Franklin's phrase as to how, for want of just a horseshoe nail, a battle could not be fought and a kingdom was lost. The problems which seem so awesome and so humongous are sometimes susceptible to such simple solutions that you feel angry, sad, that those simple solutions are not adopted and ceaselessly and continuously and consistently implemented. Of course, as far as your theme today is concerned, in many ways, business is the real sufferer. For business also, this is the elephant in the room. Business is the real sufferer because enforcement of contracts, recovery of debts, punishment of crime or offenders, stability, certainty, efficacy. These are no-brainer adjectives for a good, efficient legal system. And these are sine qua nons for a prosperous, for a pulsating business environment, which only a good legal system could give. Of course, I realize that part of our problem is the democracy tax. We willingly pay the democracy price, but that should not mean inefficiency, laggardness, a chalta hai attitude, a business as usual attitude, leading to this strange, tragic figure of arrears, as if it is something we are to live with, as if it is a given, and as if we can do nothing about it. As I said, I continue to be awestruck by the enormous inefficiencies and tardiness of the Indian legal system, which ironically is matched only by the remarkable simplicity of the solutions available to eliminate it. But before I turn to the problem, the nature, the size of the problem, and some of these solutions, I want to make a few more general points on administration of justice and reforms therein, because that's the largest subject we have today. Reforms in the administration of justice. The first thing which struck me when I started speaking on this more than 20, 25 years ago is the fact that till recently an overwhelming proportion of our law schools did not treat administration or reforms in administration of justice as a taught subject at all, neither in the 3-year nor in the 5-year. So you would learn all these nice, delicious, hardcore legal theories like basic structure, but what makes them work in what ambience, in what system, or rather does not allow them to work, is not quite taught to young minds. I know that is being changed gradually, but even now, large swathes of legal education territory do not deal with it. Second, the scourge of this backlog, according to me, can be met only by less talk and more action, by fewer lectures, including lectures like this, and more implementation, by less legislation and more ground achievement, because I believe that we know all the solutions or most of the solutions. It's a question of implement, implement, and implement. Thirdly, the mammoth number of barriers thrown at us, according to me, and I will try to demonstrate that, should neither be looked upon as a deterrent because the figures are large, nor a depressant. According to me, they are really, if attacked at the core consistently, they are nothing more like but a pack of cards, which if properly dealt with will collapse. Fourthly, and here Thomas Hardy is always reminded to me, if you take care of the small things, the big things will take care of themselves. A lot of nitty-gritty small things which we don't take care of. Fifthly, the approach has to be holistic, not piecemeal. It has to be multi-pronged, not partial. It has to be both curative and preventive. It has to be surgical, bold, unconventional, I would say even shocking occasionally, because it needs to shock people out of their somnolence. It needs to make the system lose its inertia. And therefore, it is time to be blunt and not diplomatic. As Palkiwala said, words have to be an assault on the senses if reform is to occur. And in all of this, on the general points, perhaps the most important is, in all of this, you should and can never underestimate the importance of attitudinal change. Something least quantifiable, least specific, but possibly the most important. The best proof of this I find when I was a much younger lawyer in the 90s, and Chief Justice Ahmadi, who had this passion for reform or administration of justice, but the court limited it only to the Supreme Court at that time where he was, made a combined team of Indian and American lawyers, a very small, tight-knit group, about 3 or 4 from India, headed by a then Supreme Court Judge Justice Saikia, and 3 or 4 US Court of Appeal judges just below the Supreme Court of US, and a few lawyers. And we studied the Californian system of ADR, where ADR was virtually invented. And we then made a module for the Supreme Court. Ultimately, of course, we are proud that our report, which I had the privilege of largely authoring, led to the amendment and the institutionalization of Section 89 in the CPC, which came much later on the basis of our report, providing a menu of ADR options. But the point, that is a different issue. ADR is not the subject today. The point I'm making is that that exercise between roughly 93 and 97 or 92 and 96 led to a change, attitudinal change in the Supreme Court. And all stakeholders, registry, litigants, etc., started looking at delays and case management issues. And we had at that time the lowest ever, between 30 to 50,000 arrears, 30 to 40,000 actually for a long time. So both attitudinal and my last point, the importance of teamwork cannot be overemphasized. And of course, in all this, the apex court has to always be a multi-role model. An umpire, a participant, a facilitator, an organizer, a catalyst, an observer, a role model, a mentor, call it what you will. It needs to be all of that. Well, Friends, the problem is so simple as to be laughable. You can't have these fantastic hospitals, buildings, equipment, medical equipment, and yet no doctors. How will you treat COVID patients? Take all the best oxygen cylinders you have and all the best things, you won't be able to treat any patient beside COVID patients. Well, that's part of the problem, even if it sounds like an oversimplification. And I'm giving you September 2019 figures, but you have latest a judgment by Justice Kaul, who has got interested in the subject, and I has been kind enough to mention my article in that judgment 2 weeks ago. So there are the latest figures there, and these figures don't matter because they can be updated. But the September 19 figures is that all the high courts put together, about 400 vacancies, all the posts put together. Imagine in a country of our size, we have under 1,100 judges. And if 400 are vacant, and the interesting statistic is that from no time since independence have more than 66% odd been filled. There's always been 33% vacancy. Now you can have all kind of horror stories. You know, you have in Allahabad some 60 posts vacant out of 160. You have in most big high courts like Mumbai, Delhi, and Madras, 1/3, 33% vacant. The joke used to be that in the older days, the original sanction strength was, let us say, X. They increased the X to Y. And they find now that far from reaching little below Y, they are way below the original X. So this is the reality of appointments. So you can't expect these big figures of pendency to even come down if you don't have judges. You have a similar, though not as acute a problem, but the load is greater there. So in that sense, you can sympathize more with the lower courts. Here it has been 33% in the high court level, I just told you. But in the lower courts, at least 25% of our 22 odd thousand, entire India has 22,000 odd lower judiciary. I'm giving you just rough figures. And at least 25%, 1/4 has always been vacant. How on earth can you decide to solve this problem unless you attend to something so simple as appointing judges, appointing sufficient judges, appointing them in time, and making sure that, of course, you appoint decent judges. Well, all of this which I've said has got considerably exacerbated in COVID times. Recent articles in newspapers suggest that this humongous, this absolutely dreadful and scary figure of 3.5 odd crores, it is something like 3.3, 3.2, 3.4, that range, has become 4.4 as of COVID-2. Now, as we speak, I'm talking of last week. Can you imagine on a 3.3 figure, we've added a crore, 1.1 crore. This includes the entire figure. Obviously, the bulk of this is in the 19,000, 20,000 odd district courts. Then there is the High Court in the middle, and then there's the Supreme Court. In this last 1 year alone, to arrears, not to filings, we have added about 75 odd lakh cases. This is the COVID period, so to say. And of course, you have further horror stories. None of these are my figures. This is something so obvious. Niti Aayog did this horror story without knowing that they were doing a horror story in 2018, where they came across a figure that at that time, that is the pre-COVID 3.3 crore figure disposal rate, it would take 324 years to clear the backlog. 3 to 4 years. Now, of course, you have 1 crore clear more cases added. You can add the number of years. I don't know the maths, but it is so dreadfully frightening that, it is not even worth discussing. Well, friends, it is to a large extent because of the fact that we know that we have to appoint judges in time. We know that judges are retiring on their birthday. We know the date. On the date of my appointment, I know the date of my retirement. We know the procedure is to appoint, or rather start the process of appointment 6 months before they retire. And yet, and we know that we have started a search exercise in all the high courts. And we also know the 5 best people in each high court. I've always joked that if you were to put a blindfold on strangers to law and let them loose in each of our high courts, say 3 good people, they'll be able to find within a month the 5 best chaps eligible for appointment to the high court. The problem with our system is that after locating these 5 chaps per high court, of those to appoint, we start looking for reasons to disappoint. Why I should not appoint rather than why I should appoint. And you then add ennui, dejection, frustration, anger, till many of the self-respecting ones withdraw. In all this, the politics of the judiciary would make the politics of public life blush. When J.G. Griffiths, an academic in 1965 or 4, wrote a book in the London School of Economics, a small penguin book, which he titled The Politics of the Judiciary, there was a huge uproar. People said, how the hell could you title something like that? Now, it seems that this kind of politics, of whatever you call it, the collegium or the judges, is something we just have to eschew. And I'll be dealing with this in a minute, because the Lok Prahari judgment, some of it on my suggestion, does deal with it and actually acknowledges it. But in all your business environments, in all your World Bank studies, and recent reports have quoted a well-known World Bank study in 1998, they have pointed out that this most deleterious influence of this is the business environment. It is not merely more judges or merely more laws which will solve this. It is an overhaul of the system. It is, for example, a system of assessing judicial promotions and performance. I'm giving only one example. For example, creating a weighted average index formula, which is a complex but a comprehensive formula of days of time taken to decide cases, adjournments granted, quality of judgments, number of adjournments, and blah, blah. We just haven't made, we do it for bureaucracy, we do it for civil services. We haven't done it for our judiciary. Take artificial intelligence, for example. I think it's overstated because we are not even at the basic stage. But certainly for aggregation, for massification, for finding out how your brethren are deciding the same point, we are highly underutilizing this. For example, endless appeals on the same point of law. People do not know, by the lack of use of artificial intelligence, why there need not be endless appeals on that point. But we seem to go along merrily, oblivious to how much the world has changed and oblivious to the tragic circumstances of the Aam Aadmi in this dilatory process. I was the opening lead speaker in the NJAC in Parliament. In these fractious times when we have no consensus even for walking 3 steps, the NJAC in both houses was voted by all 750 odd MPs minus 1 or 2. So the percentage of negative vote is 0.00 something. In today's times, you can't imagine that can happen in Parliament because everybody's fighting everything. Now, I was actually a very strong votary of the collegium. But the way the collegium has functioned over the last 30 years, I believe, it's as simple as saying that we originally tried central government primacy for 50 years of our independence. 40 years. We then tried collegium for another roughly, let's say, 35 to 40 years. So the time would have come perhaps to try out, not that it would have succeeded on, the NJAC, which is nothing but an expanded collegium with a larger base. Well, once even innocent lions have tasted blood, they become man-eaters. So once the judicial system tasted blood in the early 90s with its collegium judgments and arrogated to itself the right to appoint judges, I did not think that the NJAC would pass through comfortably. And as predicted, it was held unconstitutional. No problem, that's a legal process. But 2 strange things. One, right through the 18 months when the NJAC debate went on in Parliament, law was passed and then challenged in the Supreme Court. To give an example of how little we pay attention to administration of justice. While the court was hearing this matter for 18 months, they took the strange, self-imposed, self-destructive decision to virtually freeze appointments. There is absolutely no logic because there was no stay. The original non-NJAC system, that is the collegium system, could and ought to have continued. But on some exaggerated notion of fairness and decency, they stopped it. So by the time the judgment came of the collegium, on the collegium rather, there was some mammoth arrears which was unimaginable. It took them another 8 months or 9 months to just clear the arrears of the arrears. And these silly and strange things are happening in our system. The second oddity, of course, is that on the one hand, I arrogate all the power to appoint judges. And then I expect myself to be blameless when you have 400 odd judges always vacant in all the high courts put together. You can't have it both ways. You cannot have the sole and exclusive, or at least the final power, and yet escape responsibility and accountability. I do not blame the executive less. And something I've been writing about, as I said, for over 20 years, and now it is being noticed by the Supreme Court. A flowchart plan is now being put into place. Because take another small thing, how things were held up. And of course, it will change now, hopefully, because of this low priority judgment. The collegium, with all its deficiencies, would, let us say, recommend 33% of the vacancies or 50% of the vacancies. They would travel the tortuous path from the High Court through the Supreme Court up to the central government. The central government had a power to return, let us say, one name. Singhvi's name is returned. That name, if it is reiterated by the collegium, 2 judgments of 9 judges and several other judgments say that thereafter, if the collegium recommends Singhvi again, the central government has no power, zilch. But yet, do you know that all the delays at the level of the central government happen because they've adopted a very simple device. They say we don't say no to Singhvi the second time. We don't say yes to Singhvi the second time. We just keep his name pending. Now, as you know, there is just because there is no specific power written down that, look, if you don't respond, therefore it can't be endless. I have written long ago that a single notice more than 10 years ago, even to a law secretary of contempt, would have solved this problem. But judges have been unwilling to act. So one chunk of the areas on the executive side is that if I don't like X, Y, Z, I simply first reject him, and then on a second recommendation, simply do nothing about it. And you've had periods of pendency of such names, in some rare cases up to 18 months, certainly above 1 year, and many above 6 months. But equally, as I said, the judiciary cannot escape responsibility. Some of these uncomfortable home truths on the judicial side were brought home recently in the very recent hearing of the low plenary judgment, when the Attorney General, because both are complicit according to me, the central government and the judiciary. So when faced into a corner with the accusations by the collegium, the central government retorted by saying that, look at these figures. Of the 196 names for which recommendation was sent by the High Court collegiums, 94 were pending with the SC collegium. So this is the flip side. The central government causes delay, but look what happened. Your own family sent 96 names, 94 are still pending. This is for a certain period, of course. And there are many high courts. So this is at the Supreme Court level. Now they gave another figure. There are many high courts for which no recommendations for posts have been made by the High Court collegium at all. For example, of the 220 High Court judge posts, imagine out of 1100 total in India, roughly 400, just under 400 are vacant, of which for 220, no recommendations had at all been made. And the affidavit gave the breakup. No recommendations at all for 28 in so-and-so High Court, 23 in Delhi, 21 in Gujarat, and so on. Now, they also added that many High Courts have not recommended names for 5 years against 5-year-old vacancies. The point is, I can keep on repeating and expanding these horror stories. But the point of all is, why is this not done? You give lectures, you give seminars, you give all this, you give sermons, but a very simple thing can take care of all this. Your flow chart with an absolute management person monitoring every stage of the delay and ensuring that each side a whip is cracked to make things move. I think in this context, the low priority judgment is very important. Imagine after me alone writing for about 20 years on this, and everybody knowing this problem, that nothing of this which I've said till now is rocket science. It took so long because, and that too because one judge, Justice Sanjay Kaul, is a well-known reformist in this field, and he picked this up and he constantly flogged this horse. So we have now several useful things. One, of course, is it is known as the ad hoc judges case, but it is much more. The ad hoc appointment power, as you know, I wrote about it, was there originally in our constitution. For an inexplicable reason for which we have no time to go into now, it was deleted. It was brought in hardly within 2 or 3 years as 224A. It's a vast power because it allows, forget the Supreme Court, it allows even High Court Chief Justices to get people retired or recently left, not only from their own High Court, but from other High Courts as ad hoc judges. The advantage of this is that these are tried, tested people. You don't have to go and search for unknowns. And they can be put, whether it is X, Y, or Z number, they can be put for old 15-year appeals, 10-year appeals, criminal appeals, get rid of all this backlog. Not once except 3 times in our 75-year history has this power been excised by the High Court. Can you imagine? People don't know of 224A. And not more than 5 to 7 times in the Supreme Court. Now, the Lok Prahari judgment, as I said, does several interesting things. It, first of all, activates, pushes, promotes, in fact, gives a huge laudatory push to this power, exhorting that they should be used. But it equally wanted to be very aware, perhaps it was over-aware and over-conscious, and therefore a little defensive, of the accusations which might follow that you are just being incestuous in helping retired judges, giving sinecures. So it gives a lot of useful safeguards there, some of which I'll mention. It also quotes a huge amount of interesting data on pendency. It explodes a myth, for example, that those high courts which have the maximum vacancies are the ones with the highest arrears. Sometimes it's the opposite. 5 high courts in India are responsible for 54% of the total 60 lakh arrears across the country. Of those 5 high courts, those are UP, it is Allahabad, Punjab and Haryana, Madras, Bombay, and Rajasthan. The highest vacancies, the highest arrears are in Madras, strangely, which has the lowest vacancies. And conversely, Calcutta, which has the highest vacancies, has lower arrears. So, these analyses are important. And there is also in this judgment a useful analysis by period of pendency, 0 to 1 years, 1 to 5, 5 to 10, 15 to 20, like that. This data and this helps a lot in solving problems. Now, the safeguards given in Lok Prahari are important. They have made it clear that we don't want it to be a SOP and a sinecure for retired people. So if I am friendly with you, Professor Raj, I appoint you an ad hoc judge immediately after retirement. You are friendly with somebody else and you appoint. That's not the object. They say that the first safeguard is that the vacancies should be more than 20% of the sanctioned strength before you can use the power of ad hoc appointments. We're talking about the high courts. Of course, Supreme Court has a similar power where they don't need to do all this because it's a smaller number. So it's not that, you have just 5 vacancies, start appointing ad hoc judges. You need to fill it for the regular vacancies. Then it should be normally used for cases pending over 5 years. The idea is not that, the current work is being done by the regular judges. Third is that more than 10% of the backlog of the High Court which exercise this power should be more than 5 years. So it's really ideal for old cases. And then many other safeguards are given. But the point is, this is something very useful. The second set of important recommendations of Lok Prahari, and I would applaud, not because they have noted my article and acknowledged it, not at all because of that, we are very happy that the subject is being looked into. They have also said that you must have this flowchart thing. So 6 months before. So if Professor Rajkumar is retiring 6 months later, everybody knows his retirement from the date of his appointment, because judges, as you know, retire on their birthdays, unlike civil servants. Well, 6 months before that, that High Court with 10 vacancies, the process must start. So 6 months minus 1 month will be taken in making recommendation to the collegium. I'm just giving examples. Then another 3 weeks will be taken collegium to Supreme Court. Another 3 weeks from there to central government. Then another 4 weeks for back and forth. So you must have the name actually 1 month before the man retires. In fact, I had jokingly suggested that it has never been followed in the observance. It has always been followed in the breach. The post after retirement of Singhvi lies vacant for 6 months, 1 year. The post after retirement of Rajkumar lies vacant for years. So I had joked one day, I said the only way to force the pace on this is to make a rule, of course, entirely in jest, that in case a successor is not appointed immediately, the incumbent shall be deemed to continue beyond the retirement age. So there's no vacancy. Of course, that is a grave misuse and not possible. But this is the level of this whole problem. Well, friends, I have more or less come to the end because I would love to have question answers with you. Let me just say 2 more things that I've done. Before I end with that famous felicitous quote of Palkiwala, which I have quoted many times in these seminars, but it brings you in his inevitable style the problem. I remind you that we are now talking of the ABCD of judicial reform. This theme, this plenary, this topic, this elephant in the room is the ABCD, which is A for access, B for backlog, C for cost, and D for delay. This is the bane of our legal system, not the great fancy doctrines which you are taught in the classrooms, which are actually avant-garde as far as India is concerned. We have the best and the brightest lawyers and judges and law teachers and law students, but they don't work because the ABCD doesn't work. The second thing before I come to Palkiwala's famous quote is that in the end, this compromises and hits economic business environment, which I believe is the larger theme of your conference, not the narrower one of the plenary, but the larger theme of the conference. And in this, I want to make 4 or 5 quick suggestions, which I have noticed over the years. Number one, as a practitioner over the last several decades, and of course, many of these avant-garde doctrines have happened more in the last 3 decades than before. PIL, for example. No inbuilt institutionalized post-judgment audit exists in our system. Mark my words, inbuilt, institutionalized, post-judgment audit. So today, an environmentally conscious judge directs garbage cleaning of Delhi. Tomorrow, somebody directs sealing of illegal premises. Blah, blah, blah. Those examples can be multiplied. Has anybody gone back and after 3 years published a study that 3 years of stick wielding and carrot wielding by Justice Rajkumar, what was the actual ground result after 3 years on a statistical analysis? Forget the court doing it. There's hardly any institution, and I would exhort excellence institutions like yours to start doing these audits, kind of have an audit section. Number two, this audit, when rarely done, much later, by the time it has become irrelevant, should be contemporaneous and should be not only quantitative, but quantitative and qualitative. Number three, there should be a system of referring it back as inputs to the court. There are various means, I don't have time to get into it, but at least within 3 to 6 months after the continuing mandamus exercise is over. And although there will be resistance, as there is resistance to all reforms, and judges are very resistant creatures, mind you, but you will find that slowly they will start welcoming and indeed inviting such inputs. Because otherwise it becomes ivory towerish. It cannot be understood in the context in which the orders are being passed for grassroots direct benefit at the grassroots level. Number four, no studies even divorce the court proceedings. Leave aside during, I would ideally like some kind of an inbuilt court mechanism. Number five, the unifocal approach which you have discussed in earlier sessions, I'm sure. Study one is of the benefit done in the PIL. The second kind of study, of course, has to be how a unifocal focus may have actually benefited that unifocal focus point. I'm not saying it does. Frequently, it doesn't even benefit that unifocal point. But equally, the burden of that has more than outstripped the benefit to any other sector. The burden of harming other sectors, the economy as a whole. That again is a statistical and a quantitative and a qualitative analysis. We just don't have institutional mechanisms, courses, semesters, or more than that. I mean, you have, highly specialized institutes. I don't know why we don't have a judicial audit institute. And lastly, perhaps some of these, when the jurisprudence of these aggregates, and this will happen only over a few years, suppose you have 20 such studies, then perhaps those judges appointed after that date or likely to be appointed should go through some of these studies at their entry point in places like Bhopal Academy. Because it's just in many cases, it changes your horizons about the quantitative and qualitative consequences or the lack of consequences or indeed the deleterious consequences of your exertions. And this is howsoever bona fide your exertions may be. Because as they say, the path to hell could be paved with good intentions. And so friends, I end by reminding you of what Palkiwala said. He's turned many, many decades ago, and it's very harsh words, but it is our own person, most eminent person using it for our own country. May I turn to the situation in India, which has the second largest number of lawyers in the world. While it is true that justice should be blind in our country, it is also lame. It barely manages to hobble along. The law may or may not be an ass, but in India it is a snail. It moves at a pace which would be regarded unduly slow in a community of snails. A lawsuit once started in India is the nearest thing to eternal life ever seen on this earth. Some have said that litigation in India is a form of fairly harmless entertainment. But if so, it is a highly expensive way of keeping the citizenry amused. If litigation were to be included in the next Olympics, India would be quite certain of winning at least a gold medal. Well, friends, at the end of it is Gandhiji's common man. Not the business, not the institute, not the university, not the professor, nor the lawyer, nor the judge. It's the common man who asks these questions. And I end with that common man question, which is, दोपहर तक बिक गया बाजार का हर एक झूठ, दोपहर तक बिक गया बाजार का हर एक झूठ, और मैं एक सच को लेकर शाम तक बैठा रहा. It is this शाम तक बैठा रहा which you have to address, without which all the other things cannot work. Thank you very much.
Well, thank you very much, Dr. Singhvi, for an absolutely fantastic tour de force on the entire evolution of the various approaches, initiatives, and challenges associated with the institutionalization of reforms and courts in India. You have actually raised many more questions, but also provided very useful reform initiatives that can address this problem. And I know that there are many questions that have already come. And so we have, say, 15 to 20 minutes, and I'll take up those questions as it comes. Let me begin by referring you to a very pioneering work by none other than Professor Mark Galanter. As you know, Professor Galanter has done significant work on law in India, but also Indian legal profession. Way back in 1968, and this is literally over 50 years ago, Mark Galanter noted that Indian lawyers, and I quote, are quite unable to visualize any basic change in either the legal system or the organization of professional services, unquote. And he, of course, talks a lot about the state of the legal profession. My question to you is that, to what extent this challenge that we are confronting today with regard to the court, reforms in the courts, is both, particularly the lawyers, to what extent they are A, culpable, and B, they can play a substantive role in initiating those reforms and actually working towards implementing it. You need to unmute yourself.
I don't think anybody can honestly say that Mark Galanter was wrong, not only when he said it, but for, unfortunately, almost 25 to 30 years longer than when he said it. The good thing is that the comprehensiveness of what he said has changed for the better since the new millennium. But the change is too slow. The pace and direction is too slow. Resistance comes a lot from the legal fraternity, there's no doubt about it. And we'd be failing in our candor and our honesty if we continued that incestuous peer cloak of not being candid about it. But ultimately, it's a question that the whole system works together, judges and lawyers as a whole together. And once some harsh decisions are taken in the dialectics of the profession and the judiciary, you will find very quickly that the system adapts also. I know that when we did Section 89, don't forget Section 89 is a revolution in the mindset of Indian lawyers. It was our report, which I personally wrote large sections of it in the late 90s. It became law in 2000, early 2000s. Now, 89 was considered by large sections of our associations to be a kick on your legal stomach, to take away work from you. Today, the proliferation of mediation and conciliation, chambers doing it, lawyers doing it, personnel doing it, is very exhilarating. So the point of it is that you need to press on and follow that 5 R's of Gandhiji, that, first reform leads to ridicule, and then it leads to rejection, and then finally it leads to respect. So you need to persist, and ultimately, I think the rate of change of acceptance is much faster now. The openness, because of technology, because of, if you don't have it, your children have it, and if the children don't have it, your grandchildren have it, and they all teach you, and they all change you. So I think that is a good thing. But yes, you must remember the basic germ of the spirit of what Mark Galante said, and always beware of it.
All right. Thank you, Abhishek, for that. Listen, some of the reform initiatives that you have proposed, and as you rightly said, has been in discussions by successive law commission reports, many other policy initiatives, including promoted by former judges of the Supreme Court of India. There are occasions when even the Chief Justice of the Supreme Court at times, including in the Judges Conference, and also law minister initiated law ministry initiated conferences have brought together reports that have identified pretty much these policy areas for judicial reforms. Now, my question to you, and I want to refer to an academic work undertaken by Bob Hudson, David Hunter, and Stephen Peckham, who have identified 4 contributors to policy failure. And they have said, and I quote, overtly optimistic expectations. That's the first. Second, implementation and disbursed governance. Third, inadequate collaborative policymaking. And fourth, vagaries of the political cycle. And they have said this could be the story of most policy failures. And the authors have suggested that there's a need to develop a robust policy support program if we want to be serious about implementing any policy. And they've also said that threats to successful policy implementation are so widespread that simply hoping that normal procedures and channels will be sufficient to resolve them is no longer realistic. At a minimum, a better understanding is needed of the processes through which policy moves and at how at each point of these times policy can best be supported. And they've noted 4 consequential points can be identified, which includes preparation, tracking, support, and review. Now, I want to bring this discussion to you because, we have been discussing this issue for a very long time. And my question to you is that despite amazing minds that have occupied both the bar and the bench, why do you think that we have simply not been able to address this issue despite the fact that so much of attention has been given to it in terms of the discourse itself?
Now you know the reason why I started with general points in the beginning. And the second of my general points was talk less, do more, implement, implement, implement. The argumentative Indian is not just a academic Amartya Sen phenomenon. Almost everything which I've talked about has been written or known for years and decades. Why does it happen? Well, the first reason is that India is over-legislated, over-written, over-commissioned, over-seminared, but least implemented. We have never focused with the requisite degree of implementation. All the 4 very academically and diplomatically worded points of your authors in that last work can be summarized in one I for implementation. We don't do it from the point of view of implementation, and after the idea, we don't actually implement it. Number 1. Number 2, some supposedly cussed or things or villains can actually turn out to be very useful. Today, the villain is the collegium system. But the collegium system has got one great advantage. Today, because it's the collegium system, if you have judges, just the first 5 in each collegium, not only the Supreme Court, following this plan of implementation, let's say the 10 things I talked about today, or the 5 things which Lok Prahari talks about, you don't need anything. You don't need seminars, you don't need legislation, you don't need policy initiatives also, unless you call what they are doing policy initiative. You simply need officers at every level who are cracking the whip that, look, 6 months is coming, Professor Raj is retiring, where is his replacement search? You see the sea change. Of course, you should have 5 such programs, including, doing away with just tracking, for example, having 2 tracks, if not 3 in each high court. One taking care of current filings, one taking care of old criminal cases, one taking care of old civil cases. So now these are such commonsensical things. We need to only push up tighten our belts and work on this. And the rest will follow. The third thing, which all these 3 authors would not write about because they were writing academically. I'm talking of the practical operational reality. The third is that we have too much of individualism, too much of mid-course correction. So when I succeed you as the Chief Justice, merely because I want to leave some stamp, I will just make some changes. Now you may be good, bad or indifferent, but I've not allowed your policy to work even halfway through. It doesn't start showing effects before I tweak it. Take those fast track courts. Remember the fast track courts?
Yeah.
They did some great work. In some states, they did not do so work. Ultimately, they were largely scrapped, or rather not scrapped, but they said the funding of that is reduced. We don't have fundings. Take the Gram Nyayalaya. The big 2009, I remember the big debate, and it was to some extent useful at the very petty, small, lower level. Those cases are massive in numbers, and it would have taken care of them. But again, people lost interest because the successor wanted a change and a new stamp. So we need to, once we decide, you can take 3 months to decide. Once you decide, the decision should have the last clause, this shall not be changed for a minimum of 5 years of consistent implementation. You will see the results. I can challenge you, Raj, in the 3rd year onwards. But many of these policies are fallen by the wayside. I could recite so many. I've given only 2 examples. So these are the things which we need to look at. It's so simple. I would say it's commonsensical and it's very nitty-gritty, which is why I both gave those 5 principles, including Thomas Hardy in the beginning.
Yeah, yes. Well, thank you so much, Dr. Singhvi. There are several questions coming, but we have only 7-8 minutes. I want to shift gears and move into something that you talked about, which is as a part of the institutional reform, the elephant in the room, the judicial appointments. Now, I was somebody who, even before the judgment came, I wrote extensively, but also in an article in the Economic and Political Weekly, I said that judgment, that law will be declared unconstitutional by the Supreme Court, and it so happened. And but in another article, I mentioned one of the things I talked about in the future of collegium, and I want to give that idea, and is that what is needed, I believe, is an office of judicial appointments, which will have its own staff headed by a director and other staff members whose main responsibility is to process all applications for the review of members of the collegium. The processing of applications is not a routine mechanism, but rather a comprehensive and rigorous mechanism that will involve an entire administrative system to ensure that all information is duly collected and collated for the examination of the members of the collegium. Now, one of the major challenges, as we know in the collegium system, is the lack of time and attention given by the judges to the appointment process, along with their primary duties and responsibilities of hearing cases, adjudicating matters, and of course, writing judgments. So the question is there a possibility of creating such an independent body that will manage the appointment process of judges?
You must see the real problem, the real issue here, and you'll get the answer immediately. This again underlines that phrase, if we take care of the small things, the big things will take care of themselves. But it's not a small thing, it's the big thing itself, which seemingly is the small thing. Now, do you know that this is something which has to be done? But let me link it with another point. When you evaluate judges in the collegium, After all, you are doing about 1100 odd High Court judges and 35 odd Supreme Court judges. Now, different collegiums to have broad uniformity and also to have intergenerational equality. Would you not want to broadly mark them on similar parameters? So the collegium of 5, how do I know how Judge Raj is marking me versus Judge X versus Judge Y? Now, the first point is nobody is saying you disclose your marking. Nobody is saying it should be subject to RTI. Nobody is saying that it should be even available. But even within yourselves, there are no consistent 5 columns. For example, column 1, quality of judgments written. Column 2, integrity. Column 3, years of, rather, success as a lawyer. Column 4, I don't care. I'm not saying the other columns. I think it can be any such 5 columns. And the weightage can be anything you decide. But the point is, and though it will not be disclosed, it will be secret, it will be your decision. Even that is not done today. Why not? Because there is no scientific approach to this problem. The same reason is why your Office of Judicial Appointments failed. It actually happened. It actually happened in real life. An apprehension was expressed that if you make such an office, it will be subject to RTI. And RTI will have to disclose all these papers. It could easily have been obviated. It need not be. Because I am one of those who believes that when you do sensitive things like judicial appointments, splashing and sensationalism should not be the object. But at least within yourselves, it would be efficient, is the point you are making. Within yourself, it will be consistent. Within yourself, it will be uniform. Within yourself, it will have an intergenerational consistency. So that this generation of collegium, it appoints, the next generation appoints broadly on similar criteria. Now, these things are just not looked at. They're not thought of. They're not adverted to. And I see no reason. And I think there are some excellent Chief Justices coming up down the line in the next decade and 2 decades.
Well, thank you very much.
Open to ideas. Why should they not take up these ideas? I don't understand. There's no reason.
Absolutely. Absolutely. Thank you, Dr. Singhvi, for that. Let me move into something that has been talked about. You yourself have done work on this. Now, it is not that we have not identified new ways to address this problem. For example, there was a point of time, at least a decade ago or more, different forms of alternative dispute resolution, including arbitration, mediation, conciliation, have all been identified to address some aspects of the choking that is happening in the legal system in relation to matters ending up in the court. In fact, the same Mark Galanter famously observed that it's not that Indians are more litigious because one would think that because so many cases are pending in the court, somehow Indian society is more litigious. He actually said it isn't, and empirically he proved that it is not so much. There are more. It's that there are not many more cases coming into the system, but once these cases come in, they just don't get out or take longer time to actually get out. So the question is, why do you think that largely arbitration and ADR as a phenomenon, both in relation to mediation and conciliation, in my view at least, has been a phenomenal failure when it comes to promoting reforms in the court system in India?
I think this may require a more nuanced answer, Raj, but of course this could be a seminar topic itself, so I have to be very quick and brief, but it will take 2-3 minutes. I think the answer is a little more nuanced. I agree with large parts of your formulation, but I disagree with some because of the nuance. One, it's very clear that arbitration has been a phenomenal failure, but not necessarily ADR. It's also, number 2, very clear that ADR has been a late starter, but has actually caught on like wildfire in the last decade. Number 3, judges are now relying more on ADR than on arbitration. Number 4, arbitration has been treated as pre-litigation litigation in India. And it has all the ABCD ills: access, backlog, cost and delay, with which the legal system is afflicted. You remember, arbitration was the original bypass to litigation. Now, why did we start considering ADR? Why did we write the report of 1997, which became Section 89? Because we had to perforce consider alternative bypasses to arbitration itself, which is why ADR was born virtually. Now, when we did this study in California, we found that 5 out of 100 cases go to trial. This is, I'm talking of when I wrote the report in the late 90s. 5 out of 100 cases filed in California, 5 go to trial. 95 are settled outside. There is some such similar ridiculous figure when you go in appeal. Out of 100, not more than 90. In fact, you have a pre-appellate conciliation or mediation system. Now we have a menu. Remember, of course, one thing. When we studied it, we found curiously that there were 6 alternatives in US. And we could not adopt one because the 6th one there was judicial settlement. That is mediation and conciliation by a sitting judge who would not be the trial judge. Now, since you have a paucity of 40% vacancy here, we could not very well suggest that judges who can't do their own rosters will start doing mediation also as sitting judges. Right. So that statistically in California was found to have the highest success rate. We don't have it here because somehow judges inspire more confidence if they are sitting, but we don't have it here. But nevertheless, today you have had an increasing culture, Samadhan and the other one, I forget the name, Delhi High Court, and each of the affiliated centers in each High Court, and now with the district courts, are getting a lot of referrals. The difference is that they are mostly smaller cases and restricted to only, let us say, 10 subjects or 5 subjects, matrimonial, land acquisition, motor vehicle. We need to expand that. And we need to start having specialized lawyer chambers, which today I should call myself a mediation chamber. Why should I call myself a IPR chamber only? Why should I call myself a sports entertainment law chamber? You can also have chambers which are mediation and this was there in JAMS, Judicial Arbitration Mediation Services in California, when I studied this system in 1993-94. A chamber of lawyers exclusively devoted to these services is growing in India now, mind you. I know many people are doing well in that, but I'm saying that this needs to be pushed. I think the judges are the best people to push it. The more they say that we give more confidence to setting it out for 2 months to this chamber, let them do it, the better. And lastly, they have to be considered as reasonably paying services. Today, the problem with the High Court affiliated centers is that a large chunk of the work there is unpaid. And somehow the value of something increases unless it is unpaid, unless it is paid.
Well, listen, we could keep going on with this. What an extraordinary exposition of, compelling perspectives. I really want to take this moment to thank you and appreciate you for being part of this conference and delivering an inspiring keynote address. I have many more questions that are waiting, and I don't think I'll be able to take it. I just want to say that thank you very much for being here. For all those viewers, the entire session is out there in YouTube, and I hope that many of you who have missed can watch, but I know many of you have watched this live. We will be back tomorrow when we start tomorrow's proceedings at 9:15 a.m. on Judges Colloquium on the theme, the role of economic analysis of law in India. We will have Honorable Mr. Justice Swatandra Kumar, former Judge Supreme Court of India, Honorable Mr. Justice B.N. Sri Krishna, former Judge Supreme Court of India, Honorable Mr. Justice Madan Lokur, former Judge Supreme Court of India, joining me in this colloquium. Thank you very much once again, and thank you, Dr. Singh.
Thank you so much. Thank you.